Hey, what's up, guys? Welcome. Welcome to Trial Splaining the Interwebs. I'm your host, Nick Recato of Recato Law. Sorry, I can get started right now. For whatever reason, man, when I come back to my computer, not used to the mic being that way. When I come back to my computer to start up the show, my camera is laggy and jittery as hell. And so I rebooted it. Rebooted it. I rebooted it, though my computer, because it's probably some sort of memory issue that has to do with the browser. I don't know. But I rebooted my computer right before stream, and it was still jittery and choppy. So sorry about that. We'll get this dang old trial running right quick. I'm pulling it up right now. I hope y'all had a nice weekend. Let's see. Okay, I do have the courtroom here. I don't want this. I mean, I guess I can make it full screen. This window. Let's see, just getting things set up. You know how it goes. Share that. All right. We got nothing happening here. Let's see. Here's this. Can I move me around? I'm using Rumble Studio right now for this, which I have not been using because we were co-streaming, Bronca and I. But we've got that ready to go. As soon as anything happens on it, I will you'll know as soon as I do. Go away from that. But yeah, so I had a nice weekend. Lady Raggets and I, as we do every year, went to the Make-A-Wish Minnesota annual Wish Ball, which is where they have people come and it's a fundraiser to raise money to make wishes happen. One of the better organizations that exists out there, in my opinion, is Make-A-Wish. If you have not familiarize yourself with Make-A-Wish as a charitable organization, they really are cool. People think that it's like just doing something silly for kids who are dying, but actually the overwhelming majority of Make-A-Wish kids live. And it's about alleviating pressure and stress from the lives of these families that really go through quite a bit of hell fighting these illnesses. Even when you win, it's constant and it's devastating and it's tiring and exhausting and expensive. And so when Make-A-Wish is able to step in and make something happen for the kids, it's their whole family gets a moment to take a breather, go, okay, we got this, and then move into some life for a little bit. And as they typically do, the event raised over $1 million. It's about $10,000 per wish. They make that $10,000 go a lot farther than you or I could. Because, they can send a whole family to Disney on $10,000 with backstage tours and stuff like that. It's like, wait a minute. Where's this discount? How many diseases do I need to get this? But yeah, it's a great organization. It's a great event that we go to every year. So we got to do that, get to dress up. And it was nice. It was nice. Blue Varo says something good to listen to while I drive to Hibbing and Grand Rapids. Hey, thank you. Yes, again, once the trial starts up, we'll get it pulled up. It's just a fan right now. Chris Olin gifted 5 memberships, and so did Blue Varo. Thank you guys for doing that. I do have some ideas on how to incorporate more of the memberships on YouTube and on Rumble into some content that goes along with locals, trying to even things out over those three, over those three platforms to make sure that anybody can join anywhere and get access to roughly the same stuff. Unfortunately, like if you're a member on YouTube, I cannot get you automatically into locals or anything like that. So there will be some, what's it? Splitting, segregation. Sorry, I'm eating an omelet as well. Omelette du fromage. I'll try not to be too disgusting. I posted the wrong link on locals. Did I? So the PO scam continues. Yes, whatever that means. Oh my God. So what did you guys do this weekend? How many of you sat around and watched stuff about Karen Reed? Slagless says Yellow Flash's book is flopping hard. Turns out backstabbing the audience that built you cost a few million in sales. It's too bad. M. Leggy says retarded and homosexual. Well, yes, very much so. Okay, I need to get. What we got? I got to get all my chat windows up. Let's see. Spent most of the weekend trying to make your wife's book cover, which I finally finished. Well, very cool. Oh, here's something. Yeah. Hello, this guy. There's no hair in Massachusetts. They ran out of it a while ago.
Hear ye. All persons have any business before the Honorable Beverly Cannody, Justice of the Norfolk Superior Court, before the County of Norfolk. Draw near, give your attendance, and shall be heard. By the Commonwealth of Massachusetts, this court is now open. You may be seated.
I didn't realize this was being broadcast in different language.
All right. Good morning, counsel. Good morning, Ms. Reed. Good morning, jurors.
Good morning.
I do have to ask you those same three questions. Were you all, four actually, I guess. Were you all able to follow the instructions and refrain from discussing this case with anyone since we were last here on Friday?
Yes.
Everyone
No,
said
Your
yes,
Honor.
noted affirmatively. Were you also able to follow the instructions and refrain from doing any independent research or investigation into this case?
No, Your
Everyone said
Honor.
yes or nodded affirmatively. Did anyone happen to see, hear, or read anything about this case since we left on Friday? No. And were you all careful? Everyone said no or shook their heads. Were you all careful with your social media this weekend?
Yes. Very careful,
Thank you
Your
very
Honor.
much. All right, Mr. Brennan.
Good morning, Your Honor.
Good morning.
Unlawful call, Ian Whiffen.
Okay. All right, just come on up.
All right, we got an approach straight up the gate. They have a matter they like to address. There's a lot of sidebarring going on at this in this trial. Whoa, that guy got some sun. Look at how red my man is, bro. Put some sunscreen on. What? He's got the goggle outlines. Guy looks like he just sat in front of a nuke test. Got, flash burned. Whew. I thought all the lobster was up in Maine. I am still getting my damn stream setup going here? You can watch this, of course, on YouTube and Rumble, wherever you would like to. It is available. Where all good content is sold. Oh, I don't want to hear me. Better stop that right away. Okay. I just wanted the chat window. Come on, computer. This is a lovely view of the audience. They all paid a good price for this show. You know, they're not used to going, where is that guy's chin? Okay. No, he was just hiding it. All right, he still has one. Well, look at that bailiff. He's big. Oh, wait, no, they tricked us. Sorry, I'm not so easily fooled, chat. I thought that man was a giant, a towering giant. Then I realized the other two bailiffs were just women. So he's probably like 5'10", but he looks like he's 7.5 feet tall. Whoo! Oh my goodness. I was about to get excited with how large that guy was. Weird that Bronca slept through the opening. Bronca did not sleep through anything. Just to be clear, Andrew Bronca is moving to another trial. It is the Christopher Schur trial, I believe. A while back, he's a police officer who shot a suspect in the back of the head while he was down on the ground. Now he's on trial for murder. I believe Bronca thinks it's a good shoot in his expert analysis. When I looked at it, it didn't look like that to me, but
stop quick and raise your right hand.
that's more in his purview.
The evidence you give to the court, the jury, in the case down here, should be the truth, the whole truth, and nothing but
Use of force. So that being said, he's welcome back at any time. For now, we're
May I, Your Honor?
Yes, please.
Good morning, sir.
Good morning.
Would you kindly introduce yourself to the jury?
Yes, my name is Ian Whiffin. I'm a digital forensics examiner and decoding product manager for Cellbrite.
All right.
You just mentioned Cellbrite. Is that where you work?
It is, yes.
And you're a forensic examiner.
I am.
Can you tell us a little bit about Cellbrite?
Not what
where
I
you work?
expected.
Yes, Cellbrite provides digital forensic solutions to customers globally for access and decoding of digital artifacts from devices.
Is this a real
Where would
Irish?
you find a digital system? Is that resigned to a phone or is it all systems?
Typically, Cellbrite focuses on phones or iPads, but we do have some additional devices that we can also interrogate, computers, vehicles, things like that.
So simply, what is Cellbrite?
Sounds Irish.
Cellbrite is a digital intelligence company.
Do they use a certain type of software? Do they brand a certain type of software?
Yeah, we create our own software to access devices and to decode the data that we pull from devices.
So essentially, does that software help you look into the data on the phone and analyze it?
It does, yes.
I figure if you
What is
move
the role of a digital forensic analyst?
away from England,
Typically, the analyst would take the data that's been extracted from a device such as a cell phone, process that in software such as a physical analyzer that Cellbrite create, and use that information to filter, to search, and to create a report for the investigator that would allow them to see what happened on the device at the time being investigated.
How long have you been involved in analyzing data, sir?
I started my career in digital forensics in 2013.
Can you take us back to the beginning of your career and tell us a little bit about how you became involved in learning about analyzing data?
Certainly. I spent 5 years as a frontline police officer in the UK during the 2000s. In 2009, emigrated to Canada and continued policing frontline officer in Calgary before joining the digital forensics team in 2013. Pursued several qualifications related to digital forensics and just continued in that role until 2019 2020, when I left the police agency and began working for Cellbrite.
While you were working at the police agency and began your career analyzing data, were there special classes that you took?
There were. In order to be a forensics examiner in Canada, you have to take a 3-week foundational course in Ottawa, basically covering the basics of digital forensics. And then from there, other courses are available that would focus on things like cell phones, would focus on how to get data from different types of devices. And then there's industry qualifications that can be sought as well, where you can focus on particular types of device or particular types of data.
Does software in this field continually change?
It does. Every time an update is released to an application or to an operating system, there's the opportunity for the foundation of that software to change. And from a forensics point of view, you have to re-understand what has changed, make sure you understand what is now happening on that device, and provide that information to the users.
As you've progressed through the field, do you continue to take classes?
I've not taken a class now since I actually joined Cellbrite and did the basic foundational courses that Cellbrite offer. But prior to that, I was doing courses across the industry.
Do you teach courses?
I do teach webinars. I don't teach any actual courses, although some of my research and some of my tools are taught to examiners in many of the industry standard qualifications which users seek.
Do you ever write papers about the subject that are published?
I do. So I have a blog where I publish my research. Sometimes some of those become papers which get peer reviewed and distributed in more academic channels. So
when one of your papers is peer reviewed, can you tell us what that means?
Yeah, essentially, other forensics examiners would read over the paper that I've written, do their own testing, compare their testing and research to what I've conducted, and make sure that what I've said is consistent with their findings. And presuming that what they find is the same as what I found, then they would agree that it's a valid document and it gets shared.
Take us now to Cellbrite. When you began working at Cellbrite, what did you do?
When I started there, I was considered the senior digital intelligence analyst.
When you started
my role
there?
was to help the developers of the software understand the role of a digital forensics examiner, what an examiner needs from the tool, what an examiner wants to do with the tool, and how they want to use it. And then since then, I've progressed to the decoding product manager, where I can manage the backlog of software applications that we support, decide how we should support those applications, and how that information should look to the users.
Do you do research?
I do still do research, yes. It's not my primary function within Cellbrite, but it's something that I've continued to do throughout my career.
Have you ever done any programming?
Yes, again, I'm not an official programmer with Cellbrite, but I do program as well. And I have several tools which I've written myself for the last few years, since around 2015. Tools that I wrote to do the things that the vendor tools didn't do, and to offer examiners things that the vendor tools didn't offer. And I continue to maintain those tools as a learning opportunity for myself, and also because other examiners can make use of these same features.
Mr. Whiffen, have you ever testified in courts regarding forensic examination of data?
I have, yes.
And can you share a little bit about that?
I've been qualified as an expert in Canada, Australia, the UK, in total around 20 times.
I want you to take us now to the Cellbrite software.
Why didn't you just get it right
we
the
talked
first
a little
time,
bit
you
about
weirdo?
it. I don't want to go into too much detail, but can you help us explain how software works like Cellbrite software?
Yes, so fundamentally, when we've got data from a device, it's a series of files, a series of databases, property lists, or all manner of different structured data. The software that we create knows where these files exist, knows how to read these files and what the data inside them means, and provides a clear view for the user to view that data. As an example, if you were to look at the SMS database on a device, all you would see is a long list of messages that don't really have an easy way to interpret or to read them. Our software takes that information, converts it into a conversational view so that as a user, you can read the data, you can see who sent what message, what time it was sent. We can do decoding and decryption of various different types of security to give the user as much information as possible.
Is there other software available in addition to Celebrite?
There's multiple vendor-supplied tools and multiple tools available that are maintained by users in the community, like myself.
Lots of tools in that community.
Examiner, should they rely simply on the software program, or is there more to do other than the program itself?
The software program is great at finding the data and displaying the data, but I always maintain it's the role of the examiner to actually understand what that data means and provide context and validation for what that data means, making sure that the end user of the report, whether that's the investigator, a judge, or a jury, can understand what that data actually means rather than just taking it at face value from the software.
Does the software create a report that you can look at that manages or arranges some of the data that you can see?
It does. It just creates a list of all of the results that the examiner wants to include in the report.
So the software can produce a report, but the examiner goes beyond the report and looks into the data itself?
The examiner can and should go beyond what the program provides.
Let's turn now to your involvement in this case. Can you share with us when you first became aware of the data in this case and how that came about?
Yes, it was actually one of the public relations managers at Cellbrite who reached out to me or to my team because he'd heard about this case and about the confusion regarding a timestamp and requested if we could look into it and find out what the confusion was and how we could respond to it. At that point, I contacted the investigators to get more details.
Did you learn that a consumer had called about a question relative to a report produced by the software?
Yes, there was both the troopers who had requested information about this particular artifact and also a private forensics examiner, Richard Green.
And when Richard Green reached out to your company, what specifically was the question or issue?
He reached out to the tech support team, asking basically, there's a timestamp that doesn't make sense. I need to understand what this timestamp means.
What is a timestamp?
What timestamp?
Essentially, it is the time which is attributed to an artifact. So it should intentionally be when something happened on that device, we would show a timestamp associated to it.
Can you tell us what an artifact is?
An artifact would be any piece of data that we pull from that device. So it could be a text message, it could be a location point, it could be a photograph.
So if I had photographs on my phone, would each photograph be considered an artifact?
It would, yes.
Would the date and time I took the photograph be considered an artifact?
I'd consider that a property of the artifact.
And if I had a phone call or a text message,
they should go beyond the reports.
Yes.
When I look at my phone and I
justify
see a call
changing
or
a
a name, does that
changing
tell
a
me all
time?
the information about that call?
When you look on the phone itself?
Yeah.
No, there's usually a lot more information in the background of the phone that's available to the forensics examiner, which the user wouldn't necessarily see on the device.
And so when you're looking at an artifact, a phone call, a text message, whatever it may be, and you see it on a report, if you want to know more detail, where it came from, when it was developed, when it started, is that what a forensic examiner would do, to look into the data to try to identify that other information?
Yes, you can see what other information is available. You can see if there's any information that's been deleted that can be recovered. And you can validate the information that's there and make sure that the timestamps are being interpreted correctly and that they mean what you think they mean.
You told us you got a call from a consumer or a forensic examiner, Richard Green, about a timestamp. What type of timestamp? For what type of artifact was this timestamp?
That's when you get the time you lost your virginity tattooed on your lower back.
And so there was an internet query on a phone that had a timestamp, and this gentleman, Mr. Green, had a question about it.
He did. He wanted to know how accurate the timestamp was in relation to when the internet query was made.
Did you look into the question, the query that was made?
In response to Richard Green at that time, I didn't. I wasn't aware that Richard Green had made this request until several months later. But it was an almost identical question that had been asked by the troopers here. And that's the question that I was able to look into and to answer.
And can you share with us what was the issue? What was the question that you were actually looking into?
The question was related to a timestamp of 2:27:40 a.m.
227
and an internet query that appeared to have occurred at that time. There was no other information on the device that suggested that that internet query had occurred at that time. So we wanted to know how relevant is that timestamp to when the query happened. So I was able to take test devices.
The Brits really
recreate
can
test
say
data
query well,
to find
can't
out
they?
exactly what this timestamp meant, and discovered that it was actually the timestamp that the tab within the browser was brought into focus and had no relevance to when the actual web query had been made.
So after you looked into the issue and came to a determination or opinion, did you reach back out to Mr. Green?
Eventually, yes, I did. After I provided information to the troopers, I wrote a blog that covered this information
a blog?
because there was another examiner in Europe who had a very similar question, and I realized that this is a relatively common point of confusion. And then eventually I reached out to Richard Green, offering to speak to him about this issue and clear up any confusion, but never received a response.
So to summarize, there was an inquiry about a phone that made a Google or a internet search, and the question is, what time was that search made?
Correct.
And relative to that inquiry, there was a timestamp on some of the data that said 2:27 a.m.
Correct.
Sustained.
So at some point, did you have an opportunity to forensically examine a telephone that was attributed to a person by the name of Jennifer McCabe?
I did have the opportunity to look at the data that was extracted from that device. I never saw the device itself.
Putting that aside for a second, secondly, were you asked to look at any other phone to examine data in this case, aside from the phone attributed to Jennifer McCabe?
Yes, I was also sent the extraction of data from John O'Keefe's phone.
Did you look through the data and analyze some of the data in John O'Keefe's phone?
I did, yes.
Did you make fun of his internet history?
So I want to walk through both your analysis of Jennifer McCabe's phone, but also of John O'Keefe's phone. So if we can first start with Ms. McCabe's phone.
Yes.
Did you actually receive her phone?
I didn't know. It was just a download of the extraction.
So how does that work?
The examiners here had done the extraction of the device, resulted in a large zip file, which is a container containing all of the files extracted from the phone. They uploaded it to Cellbright's secure portal, where I was able to download it and verify what the data was in the extraction.
When you received the download of the extraction for Jennifer McCabe's phone, was it similar process for John O'Keefe's phone?
With John O'Keefe's phone, I actually received the data on a USB thumb drive through the mail.
And before we begin, can you summarize briefly the issue, what you were looking for, and what the scope was as far as Jennifer McCabe's phone?
For Jennifer McCabe's phone, it was related to the internet search that occurred, or that allegedly occurred at 2:27:40.
Okay. And as part of your effort and analysis, did you put together a PowerPoint that would help educate us on how a timestamp works and what happened in this case regarding a search?
I did, yes.
And have you
Kind of
seen
leading.
that PowerPoint recently?
I did, yes.
May I approach, Your Honor?
Yes.
In the locals chat, Still Life says
Getting you a
1.63
binder
gigabytes of
that you
Shrek
look at,
memes.
know or you recognize within that binder.
Yes, this is the PowerPoint presentation I created related to Jen's phone.
Could you imagine what you find on
With that
people's phones?
presentation,
Like, what a
you have it
disaster.
downloaded on your computer.
I do, yes.
I'd like to introduce this as the next exhibit, please.
No objection, Your Honor.
All right, thank you.
Like, you know, there's a dude's
If the
phone out
court's
there with just
permission, I'd ask Mr. Whiffen
cat
to be able
ass
to use
pictures
his
on it.
computer to walk us through the PowerPoint and explain it to the jury.
No objection, Your Honor.
Yes, thank you, Mr. Whiffen.
incidentally, that person's most likely to have their phone searched.
Okay.
May we begin, Your Honor?
Yes.
Mr. Whiffen, if you would walk us through and explain the PowerPoint and explain this issue to the jury, what the question was and how you resolved it.
Of course. Okay. The query revolved around a database called browserstate.db. Browserstate stores information about Safari internet browser and about the tabs that the user has either had open or has open. Fundamentally, in this presentation, I wanted to include information from iOS 14 and earlier. iOS 14 is not the version of iOS that was on Jen McCabe's phone, but iOS 14 has an easier way to understand how this database works. And then I can move on to iOS 15, which was the device or was the version installed on Jen McCabe's phone.
that the state is here.
And hopefully by that point, it will be
prove
clearer
that
how this
all of the
information is being
text message
populated
times
on the device.
We're just
Could you
fine.
tell us what
except
iOS
this one.
means?
This one's wrong.
iOS is Apple's proprietary operating system available on iPhones.
Thank you.
Fundamentally, the browserstate.db tabs table is shown, hopefully I can show this on here, in the top here. The real database has many more fields, but these are the fields which are important for the demonstration to just see the row ID, the timestamp that's recorded, the URL or the web address, and the title of the page. And the example at the side there, you can see there's the browser is open, but there is no tab actually in focus at this time.
Can I take us just a little bit back so we can put this in context?
Yes.
When you are doing internet searches on your phone and you
How
hit
often is it for
Safari or
children?
Google or whatever search engine you're going to use, does it create a tab?
Because that's what I
It
do.
doesn't create a tab just by opening the application, but there may be tabs already open in the background when you start the application, and then you can tell it to create further tabs.
So if I have a phone, can I have a number of different tabs on my phone at the
It's
same
like
time?
talking to your
if I
grandpa
search for
about owning a
different things
phone.
throughout the
You
day?
can have multiple
Correct. You can have
tabs.
hundreds of tabs open.
Hundreds
Do
of
tabs
tabs.
stay open forever, or can you close them?
They stay open until you close them.
So if you look at your phone and you have a number of different tabs, and say, for example, I start with one tab, I'm looking for the local football score. Can I reuse that same tab for some other search, or do I have to use a new tab to start a new search?
You could use that tab for as long as you wanted, or create a new tab to do additional searches while maintaining the original tab in its current state.
And so what you're trying to demonstrate to the jury is identifying a time on one of these tabs where a particular search was made.
Objection, Your Honor.
Sustained is to full.
Could you explain this demonstration as it relates to tabs on these internet searches? What are we actually trying to learn?
So as I showed, there's a field in this table called timestamp. It's actually called last viewed timestamp.
Ooh.
I wanted to prove or to demonstrate what that timestamp means, how that timestamp gets populated,
Wanted to prove
and
it.
how it's relevant or irrelevant to a case.
So if I have one of many tabs open on my phone, each tab will have its own timestamp?
Correct.
And the URL, that's whatever I look up, what I search on the search engine?
Objection, Your Honor.
I'll allow that.
This attorney has at least 70 eBay
That's
tabs
great.
open
The
at any
URL
given
is
moment.
the address of the page that's being viewed.
So if I have a tab open and I use it continuously, 3, 4, 5, 10 times, will the timestamp change?
No, it will not.
And is that what you're explaining to us
Oh
now?
my
Correct.
God.
That's part of the demonstration and presentation.
I'm sorry to interrupt.
So in this instance, at 10 a.m., which is shown in the top of the device there, we can see I visit firstpage.com as an
Wait, Varying,
example website.
It's hard to
At
explain
that
all
time, a row is
some of the
created in the
individual
database
objections,
that
but they
shows row
don't,
ID 1 with the timestamp 10 a.m. when the page was opened.
Sorry.
The URL and the title are relevant to the page that was
They're not-
visited. So
waiting for
firstpage.com.
They're not required to provide grounds for their objection.
A minute
Actually,
later,
they're
excuse me,
told not to.
I now use the same tab to visit
That one
secondpage.com.
was
What
sustained
actually
as
happens in the
form.
database at this point in time
Form of the question was bad.
is the first record is updated with new information. So we continue to see row ID 1. We continue to see the timestamp that the tab was opened at 10 a.m. And we now see the URL and the title that are related to the secondpage.com website. So I've shown it here. The first one is red to show that's no longer a live record. It's been replaced by the new record that's underneath it in black. A minute later again, I can visit thirdpage.com. And at that point, the record's updated a further time. So we still see that it's row ID 1, because no new rows are being created. We're just simply updating the existing rows. So we still have row ID 1. We still have 10 a.m. as the timestamp, and we have the URL and the title that show thirdpage.com instead.
Mr. Whiffen, so in the URL column,
So how is this going to tell me that she didn't search how long for a body
there's
to
three
die in the
different pages
cold?
that have been visited
At
within
the time
same
it
tab.
says, like,
in the
you
data,
have to sell
it
me on
has
this still.
3 timestamps, but they're all the same.
Correct.
Okay, thank you.
This database is not monitoring web navigation events. It's purely monitoring the tab events. So when the tab's brought into focus or when the tab's created is the only timestamp that's relevant here.
Thank you.
From a non-forensic point of view, if I was looking at this database in a regular database viewing tool, all I would see is the black record at the bottom. I wouldn't see the other 2 records because they've been essentially overwritten by the third record.
Because of DEI.
If I was to use a forensic tool, though, then I would see all of these records because the forensic tool is designed to find the older versions of these records that have been replaced. So again, from a forensic point of view, I would see all of these records, I would see all the different URLs, and I would see the same timestamp and the same row ID for all of them. This fundamentally changed in iOS 15, and I've tested this on multiple versions of iOS 15, 16, 17, and 18, including iOS 15.2.1, which is the same version of iOS installed on Jen McCabe's phone. In this case, the data is not written to the database immediately. So I've tried to show here that we have some in-memory variables, so essentially a short-term memory that the device knows exist, but aren't written to the database yet, so they're not written long-term. So in this case, if at 10 a.m. I go to firstpage.com, we see that the in-memory variable for timestamp URL and title are updated to show a 10 a.m. timestamp and the firstpage.com information. But you can see at the bottom, I still have the browser state tabs table, and nothing has been written to that database at this time.
So can I ask you a question about this browser state DB? What does that mean? What does that tell us?
The browser state.db is just the name of the database that Apple are using to monitor the tab activity on the device.
Will a cell phone have a number of different databases it will send information to, or is it all one database?
There are hundreds or thousands of databases, depending on what applications are installed on the device. Each database typically targets a different application or a different feature.
Can information from a URL or a Google search or a Safari search, can it leave data on different databases, or does it always go to one database?
It can leave on different databases, for sure.
Thank you.
So again, to continue this example, if I now go to secondpage.com a minute later, we can see that now the in-memory variable is updated. So the timestamp still remains 10 a.m., the same as it did previously on iOS 14, but the URL and the title are updated to reflect the current web page that's being viewed. Again, nothing has been written to the browser state database. I can go to thirdpage.com.
This is bullshit.
Again, we see the
Like, it's
in-memory
just bullshit.
variables for the URL and the title are updated, but the timestamp still remains the time that this tab was brought into focus or created, not the time that the navigational event occurred. Still, nothing's been
These
written to the
companies
browser state
know
database.
how to log
it's not
the
until you
moment
actually
that you
close the
search
tab
for something.
That the
They
information
do it.
gets removed from the
All of them.
in-memory variables
It's
and written
valuable
into the
business data
database.
for them.
And at that
don't get it
point, the
wrong.
information written to the database is whatever was in the in-memory variable. So right now, all we have is a single record in the database that shows the 10 a.m. timestamp. That's when the tab was opened. and we have the thirdpage.com URL and title information, which is the most recent web page visited in that tab. It wouldn't matter whether I was looking at this data using a regular database tool or a forensic database tool.
Incredibly valuable.
The only record that I would see is this particular record. There may be multiple versions of this record, but still would only show me this timestamp and this URL information, because this is the only information that was ever committed to the database. Okay. Moving on from that, there was multiple databases or multiple data sources on Jen McCabe's phone that could be used to see what actually happened on the device at this time of day that was of interest. So the analysis I did looked at the browser state database that we've just described, the history database, which is what is tracking the navigational events. So every time you visit a website and the website fully loads, it gets written to the history database to say this URL was visited at this time. And that's the information that as a user you can see. When you look at the internet history in your device, it will list all of the web pages that have been visited. com.applemobilesafari.plist is a property list file, so essentially a list of values and information, keys and values that would describe various settings on the device typically, but it also stores information such as the last searches that were conducted using the Safari search feature. And then finally here we've got knowledgec.db, which is a massive database at the heart of iOS that stores lots of types of information. It can tell you what web page was actually on the screen at any given time. It can tell you when the backlight came on, when the backlight went off, when the device was locked or unlocked, the battery level, lots of different types of information, but useful here for the web pages that were being viewed. So using the combination of all those sources, I could see that at 2:27:29 a.m., Safari was opened from the application library on the device.
Library.
At 2:27:29 a.m., when Safari opened, there was already numerous tabs open in the background.
She had tabs open. I mean,
the browser would show,
who knows what her search was,
in the foreground, whatever browser tab was opened when Safari was previously minimized. In this case, we can see, looking at knowledgec.db, that the web page that was being viewed was related to Hockomock Sports, Friday's schedule scoreboard. At around 2:27:30, that tab would have been closed. Now, we don't actually have a time that the tab was closed, but based on other activity, this timestamp can be inferred. But essentially, when this tab was closed, a record is created in the browser state database that shows the timestamp 1:59:44 a.m. That would have been the tab at the time that the tab took focus.
27
and then
minutes
Hockomock Sports
earlier.
Friday schedule scoreboard URL. At 2:27:31, there was a browser switch occurred, and the last visited timestamp that's held in memory would have taken the time that this occurred, so 2:27:31. This URL was PayPal. There was no navigational event listed in history, so this wasn't a page that was visited from a bookmark or from typing in a URL. It was whatever was currently shown in that tab when the tab was brought into focus. And we know that this exact URL was last visited at 7:40 a.m. on the 28th of January. This is evidenced in browser state and in knowledgec. Around a second later, that tab gets closed, and that record gets written to the database with a time of 2:27:31, because that's the time the tab was brought back into focus.
Hocus
It
pocus,
gets written with the URL and the
focus.
title information related to PayPal. At 2:27:33, another tab is brought into focus from the background. This one related to Eastern Bank. Again, the last visited timestamp would be updated because this tab has now been brought into focus, causing the timestamp to change. We know that this particular website was visited at 8:02 on the 27th of January, and there's no new navigational events at this time. So we know it's just brought into focus and visible on screen according to Knowledge C and browser state databases. That tab gets closed and it gets written to the database. This, again, is going to show, and I've just noticed there's a typo on here and the timestamp at the top is shown incorrectly. But essentially, it's closed around this time, and the Eastern Bank URL is written to the browser state database with the 227.33 timestamp.
Oh, guys, we have a Ronnie O'Neill voice now.
227.35, we see that there's a YouTube video shown on screen related to It's Raining Men. This shows in Knowledge C. There's no new navigational event for it, but there's also no timestamp in the browser state database at this point.
It is Raining
This is
Men,
because
isn't
this
it?
page is actually, or this tab is brought back into
Fucking
focus
man.
a second time. And when it gets brought into focus the second time, the timestamp that's attributed to it overwrites the timestamp that would have been written at this point. Sounds convoluted, but essentially, if you imagine that the in-memory timestamp here would have said 227.35, but then there's another tab that's brought into focus related to Hockomock Sports at 227.36.
Mr. Whiffen, can I ask you a couple questions?
Yes.
Can I ask you a
This
couple?
timestamp,
He's literally on the.
227.36. Does that indicate the time when this tab was actually opened?
Yes.
Of course you
the,
can.
The time that the tab was
He's
brought
on
into
fucking
focus
witness stand.
or opened.
What does it mean brought into focus?
If you imagine you could have 5 or 6 or however many tabs in the background, you select one of those tabs to view, it makes it full screen, that would be considered in focus, and that would cause the timestamp to be updated.
So if someone had an open tab that had a timestamp, and then they put it in the background to look at a different tab, but then went back to an earlier tab and opened it, would it create a new timestamp?
It would update the timestamp.
If somebody had an open tab and they didn't put it in the background, but they used other functions or shut off the phone, and when they came back, that tab was still open, would that create a new timestamp?
As long as Safari doesn't close, then the timestamp will remain the same. So if I just minimize Safari, put it into the background and start to do other things on my phone, the timestamp won't get updated. If I completely close Safari or turn the phone off, when Safari reloads, then that tab does get a new timestamp when it opens up again.
Thank you.
Okay. So at 227.36, we've got Hockomock Sports, Gallery Shoots, Canton Girls, basketball to important win at Mansfield is the page that is visible on screen. Again, we know that there's no navigational event at this time, so the page is not being loaded as a result of a bookmark or typing the URL in. It's just showing what was on screen previously, and we know that this page was previously viewed at 22:55 on the 27th of January. This tab gets closed and gets written to the database as well, and we see it's written with the timestamp 227.36 when the tab was brought into focus. And then we go back to the YouTube video tab. So at this point, the timestamp that had been written there gets overwritten again with 227.38, and it shows the YouTube video is the active page that's on the screen. At around 227.39, that tab gets closed and the record is written to the database showing a timestamp of 227.38 when the tab took focus, and the YouTube video URL.
I'm just glad that he used examples
Then
from
we
his
move
own
to
phone.
227.40,
It's Raining
which
Men
was the
video.
time of interest. And we see that a browser switch occurs, causing the last visited timestamp to take on the time of 227.40. This is the tab that was ultimately used to search.
Whoa. That's not me. There we go.
At this point in time, there is no navigational events recorded anywhere. All we see is that the web page that was brought into view is ozonebasketball.com/teams. This web page was last visited at 14 minutes after midnight on the 26th of January. We know that this is on
Hose
screen
long
because
to
it tells
die
us
in
that in
cold.
Knowledge C, and we know that the time
Funnier when you
is
think of it that way.
227.40 based on Knowledge C timestamps
They're pining
and
for a
based on the
frigid
browser
death.
state database timestamp. At 227.42, there is a web navigation event. Whether this is loaded from a bookmark or whether it's typed in, I can't say. But a web navigation event occurs using the same tab that's just been loaded. And now the user is loading the web page hockomocksports.com/standings. This is logged in the history database that shows what web page is visited when. And it also shows in the Knowledge C database to show what web page is on screen at this time.
Mr. Whiffen, in the slide before 227.40, you mentioned that was the tab in question.
Yes.
Do the following pages that you show us in the PowerPoint follow that one specific
This is
tab?
insane. Trying to
Yes.
show there's a
Thank you.
browser tab that's just open.
So at 227.47,
that
there's
happens
another
at this time.
web
because you
navigation
brought it
event
up from the
as
past.
the web
like,
page hockomocksports.com/schedules is loaded. Again, this is evidenced
Doesn't
in the
follow
history
a basic
database to show that a
logical
navigation event occurred and
chain of
completed,
events.
and in Knowledge C to show that this is the web page that was viewable on screen. At 227.53, there's a further web navigation event where when now loading the page hockomocksports.com/schedules/girls hockey. Again, this is evidenced in the history database and the Knowledge C database to show what page loaded and what page was visible on screen. At 227.58, there's a further navigation event for girls hockey Franklin 21-22. Again, this is logged as a navigational event in the history database and shown on screen according to the Knowledge C database.
So I understand these are all subsequent searches on the same open tab.
Correct.
Are these
Sustained as to form.
all subsequent searches on the same single open tab?
There is no tab switch event listed. We see the tab switch event occur at 227.40, and then we see lots of navigational events occur.
Thank you.
At 228.06, Safari is minimized, so it's removed from focus so that something else could be viewed, or the phone is locked.
Is remove from focus different than closing?
Correct. If you remove it from focus, it's essentially going into the background, but it's still open. It's in its current state, just in the background, versus if you close it completely and have to reload it later on. So in this particular state, the timestamp doesn't get changed. The timestamp remains 227.40 as it was earlier. Safari is then not used again until 6:23:37, when it's opened from the background using the icon in the app library. At this point, when it loads up, the same page that was open when Safari was minimized is shown. So we still see hockomocksports.com/schedules/girls hockey/Franklin/2021-2022. There's no navigational event at this point, so we know that it wasn't completely reloaded. It's just showing what was on screen previously, and it's evidenced in the Knowledge C database. At 6:23:49, there's a cache file created. The cache file is related to how long to digest food.
Cache money files.
Now, these particular cache files show up as suggestions in Safari. So as you're typing in a query or a word or a URL, for example, Safari tries to take that information and make suggestions based on what it thinks you might be searching for. So if, for example, you were to type in how long to die with the word spelled just DI, Safari can mistake that for how long to digest food, and it could present this information. And up until about 12 months ago, this is the information that was provided by Safari. If you were to do this search, if you were to type in how long to DI, you would get the result that's shown at the top of the screen with an image of somebody eating a plate of food. And this is the image that was cached onto Jen McCabe's phone at 6:23:49.
What does cache mean?
Essentially,
But that's not when
downloaded
she's
now for
alleged
use
to have
later.
searched for it.
It will download it, it will save it in case it's required again. If it is, it doesn't need to download it, it's already there. If it's not required again, eventually it will be deleted.
So is it stored information from prior events that's available in case the device thinks you're looking for it?
Yes. So at this point in time, at 6:23:49, when it downloaded it, that's the first time that it's downloaded this image, and it stores it. If an hour later, for example, I did the same search a second time, it wouldn't need to re-download the image because it's already got it in cache. So this, the creation time of this image shows that this is the first time that this cache file was downloaded. A few seconds later, at 6:23:51, the blue button at the bottom of the keyboard is used to submit a search for the term "How long tid I in Kikdi?" CIKD. This creates a specific URL in Safari, which is shown on screen here. So google.com/search "How long tid I in Kikdi?" IE UTF-8, OE UTF-8. Client Safari is the important part of this string that tells us that it's a query that's made using Safari. This is different to if I visited Google, for example, and just typed in the search text box in Google. It wouldn't necessarily have this same structure of the URL. So we know that this is the query created by submitting a search using the search bar here and pressing the blue button at the bottom. We know that that search was conducted at 6:23:51 according to the information in mobile Safari.plist. And Knowledge C also shows that this page was visible. Importantly, there is no history record made that shows that a navigation actually occurred to this website. Several reasons why that might happen. One could be if the device was in private browsing mode. However, it can't have been in private browsing mode because if it was, we wouldn't have the search recorded in the mobile Safari plist either. So we know it wasn't in private browsing. It could have been deleted at some point after the fact. That would leave a gap in the numbering. Every time a record is written, it would be consistent numbers 1, 2, 3, 4, 5, 6. And to delete a number would leave a gap there, so you would see 1, 2, 4, 5, and that number will pretty much never be reused. So if you don't see a gap, then you can be confident that nothing was deleted, and there are no gaps.
If you don't see
device.
a gap, you're looking at the wrong
The
thighs.
third reason, and the one that I believe is the reason why it wasn't recorded in the database, is that the page never completely loaded. If I go to a web page and cancel the navigation prior to it completing the load, it will never get written to the history database. At 6:24:18, there's a second search submitted using the same method, so still using the Safari search bar, this time searching for host long to die in cold. This is evidenced in the mobile Safari.plist. Again, there is no record made in the history database that to me suggests that the page never successfully loaded. At 6:24:24, Safari is minimized again. It gets
There's no
reopened
data
at
to suggest the page
10:33
didn't
a.m.
load. That was a double negative.
Again, loaded from the app library and brought into focus. And at that point, the previous page is shown to the user. That previous page is related to the search host long to die in cold. This is evidence in Knowledge C to show that this is the page that's visible on screen, but there is still no history event that shows that the page completely loaded. And at around that time, so around 10:33:34, that tab would have been closed, resulting in the record being written to the browser state database with the timestamp 2:27:40, when that tab was originally brought into focus several hours earlier, but it shows the most recent URL information, which is the Google search for host long to die in the cold. It doesn't have any of the other URL information that was visited during that time period. It doesn't have the previous Google search for how long to die in the Kikdi, because all it records is the most recent URL that's visited alongside the original time that the tab took focus.
You can get these answers on Google without ever opening a page.
Information. The title information is included within the page itself. So if you do a Google search, the title of the page that showed up would show Google search, and then it would show the query that you typed in to search for. The fact that this doesn't have a title also suggests that the page never loaded. So again, it kind of ties back to the fact that it's not written in the history database. We have no title. It's both indicative that the page never successfully loaded.
The page not successfully
Whiffen,
loaded
when
doesn't
a
mean
tab
the
is
search
ultimately
wasn't
closed,
successfully or wasn't attempted.
does the URL always
It doesn't
have
matter if she gets
the
the
last
answer
search,
to the
or
fucking
could it show an
question.
earlier search?
It will always be whatever URL is visible in the tab at the time.
Why is that URL visible in the tab?
Thank you.
Why? Why? Tell me why.
To overview again the data sources used here, com.applemobilesafari.plist is known to be a reliable location to get search timestamps from. We know that it's good to show the time that a search was conducted and what search was conducted. It doesn't record if the device is in private browsing mode. The only time it shows how long to die in the Kikdi is at 6:23:51.
In the Kiki.
And the only time it shows how long to die in the cold is at 6:24:18. There's no other mentions of either of these searches anywhere else in this file.
There's only one thing
The
that
history database, again, is known to be a
Wears
good
bandana all the
source
time.
of data for visited web pages and timestamps for the pages that completely loaded. Again, in this case, neither of these
No record of
searches
their
or neither of
searches.
these URLs was in the history database, but there are no missing records, which indicates that nothing was deleted. And again, the only reason that I can come up with for why that is the case is that the page didn't load.
What about private browsing mode?
There
You have
must
it right
be an
there.
entry within this database to allow the user to delete it.
Why-
Obviously, if the page doesn't load,
Why does it say
it doesn't
private
get written to
browsing
the
mode? I'm
history.
looking at
As a
it.
user, you can't see that item in your internet history list, so you can't delete it. And then knowledge C, which shows the page that's on the screen when the browser is in use. Again, we know that this
We're
is
just going to
a
skip
good
over that
timestamp.
private browsing thing.
And we see the only times that web pages related to these web searches were open is at 6:23 and at 10:33. There were multiple deleted records in the browser state database. It wasn't just the record for Hostile to Die in the Cold.
Wasn't just the
When you say
inconvenient
there's
one.
multiple deleted records, can you go into a database and see what URL searches have been deleted from the actual item?
Yeah, so from a forensic examiner point of view and using forensic software, I can look at the database and see the records that have been deleted and recovered. There does become a time when you're unable to recover any more records and they're now just purely deleted and unable to get back. But at this point, I was able to recover a good number of records. And these were the 5 that I thought it was important to focus on for here. You can see that 3 of them occur at 2:27. So at 2:27:36, 2:27:38, 2:27:40. And these are the web pages that we've just seen in the presentation. So Hockomock Sports, the YouTube video, Hostelong to Die in the Cold. And then 2 additional pages for cantonma.org and Ozone Basketball. The way that we're able to recover these records forensically is because of how databases work. What I've tried to display here is that when you first create a record, in this case, creating record 4025, a new page is created in the database. A page is simply a block of binary data that's organized in a way that can be understood by the database as a page of data, much like it would be a ledger with a list of records. So it creates frame 181 with page 2752 and the record 4025. What is a little bit different from if you were doing this manually is when you want to add a new record, or when you want to delete a record, or when you want to update a record, it has to create an entirely new page or an entirely new version of that page. So in this case, we see that frame 194 is also page 2752. It duplicates the record 4025 and adds the record 4026. From the database's point of view at this time, frame 181 is now dead. Like, it won't be used for anything. And a regular database tool would only refer to the most recent version of that page, so frame 194. Forensically, I can look back at all of these different versions of the page and I can start to see differences. Not so important in this case when all that's happening is that you're adding information, but when you start to delete or edit records, being able to go backwards and see these previous pages, you can see the records that have been changed or deleted. So
Maybe you just said it wasn't important in this case, but you're talking about an entry that was deleted.
Each of these refer to a time when a new record was added. Every time a new record is added, a new frame is created, it duplicates the page from before, and it adds the new record. I've highlighted record 4028 in green across these 3 frames because this is the Host Long to Die in Cold record that is of interest. Moving forward again, we continue to see records being added, but particularly here at frame 430, record 4029 is deleted. 4029, if I go back a few slides, we can see 4029 is the cantonma.org Families Index webpage. As far as I know, no relevance to anything related to this case. It just so happens this is the first record deleted from the browser state database. We don't have information that tells us at what time the record's deleted, but we're able to infer what time that record was deleted based on other records in this frame. So, for example, we know that at the time that record 4029 was deleted, record 4031 already existed. Record 4031 has a timestamp of 6:29 on the 31st of January. Therefore, we can summarize that record 4029 had to be deleted at some point after 6:29 on the 31st of January.
Oh, okay.
We see again record 4030 is deleted on frame 468. Again, we can look at what record was the most recently created on that frame at the point that that record was deleted. And that gives us information that suggests record 4030 had to have been deleted at some point after 8:35 on the 31st of January. We can continue to go along and continue to see that records being added, edited, and deleted, but the record of interest, 4028, still exists even on frame 650. And in fact, it doesn't get deleted until frame 732. By the time the record related to Host Long in the Cold is deleted,
I'm looking forward to Alessi's
record
cross-examination.
4037 already exists. Record 4037 was created after 2207 on the 31st of January. Therefore, we know that the Host Long to Die in the Cold record was deleted at some point after 10 p.m. on the 31st of January. Taking all of those deleted records, those 5 deleted records, and the earliest time that they could have possibly been deleted, we see a spread throughout the 31st of January.
I'll show you a spread.
A few quite early on at 6:29 and 8:35, a couple at 9:20, 9:40, and then finally the one that we're interested in at 22:07. For the user to cause these to be deleted, if you wanted to do it selectively and delete one at a time, the record has to be available in the history database. As I said earlier, it wasn't ever in the history database because there'd be a gap. So this record could not have been deleted by the user selectively. That leaves options of deleting everything from the history, but if everything was deleted, we would have none of this information, and we do. And it also leaves the option of deleting everything from what's considered today and everything that's considered today and yesterday. And again, if either of those options were the case, we'd have much less information than what we have, and we wouldn't see this staggering of timestamps that we see here where the information was deleted. Ultimately, I wasn't able to say what caused these deletions at these particular times, but I'm confident that it wasn't as the result of user interaction. That's something that was brought on purpose.
Mr. Wethen, I have a couple questions about your analysis and your opinions.
Yes.
You showed us a tab that was opened at 2:27:40, and it had something to do with Hawkmock Sports.
Yes.
In your opinion, to a reasonable degree of scientific certainty, was that the same tab, that 2:27:40 tab open for Hawkmock Sports, was that the same tab that later was used for searches or attempted searches at 6:23:51 and at 6:24 relative to how long or how's long to die in cold?
I believe
Are
it was,
you
yes.
fucking kidding me?
Does your opinion, is it based on your analysis of reports generated by software like Celebrite?
This is insane.
Sustained as to form.
She didn't search it at 2:27 when it shows up
Was
on the
your
phone. She
opinion
actually searched
limited
it at
To
6:50
analysis
a.m.
of reports generated by companies like Celebrite or Axiom?
It wasn't, no. I went into the data, looked at the various different databases, different files that were in use, tested it across many different devices to make sure that my understanding and analysis of it was correct.
In addition to your opinion that the two searches at 6:23 and 6:24 occurred at that time as opposed to 2:27:40, did you also, when analyzing the data, come to an opinion whether or not either of those searches actually connected and produced results?
If either of those searches had connected, the information would have been written into the history database. The fact that it wasn't in the history database strongly suggests it never completely loaded. And the fact that there is no title information on the browser state tab as well also suggests it never loaded.
And finally, those
Again-
attempted searches at 6:23, 6:24, you mentioned that information at some point was deleted from the phone.
The only records that were deleted were the browser state database records. Yeah, they were deleted from the device.
Do you have an opinion to a reasonable degree of scientific certainty whether or not that information was removed as a natural application of the phone, or was it because somebody took the phone and actually deleted it by hand?
This is unreal.
So again, I don't believe it's possible, given the situation and the information that's available, that it would have been possible for the user to delete it. I believe it was more than likely a system event that caused that, but I've not been able to replicate that system event.
I want to take you back to your first opinion, where you opine that the
So no, not to a
how
reasonable
long to
degree of
die in the
scientific
search
certainty. You
occurred
can't
at
identify what it
6:23 and
was.
6:24, not at 2:27:40.
Yes.
And so, in looking at the data, coming to that opinion, what caused the confusion with the software where it could be misunderstood the time those searches were actually made?
Objection, Your Honor.
I'm going to allow it.
The way that forensic software typically works, certainly the way that Physical Analyzer works, is we design models for the data. So we know that an SMS application, for example, will always have a message body. It will always have a sender, a receiver, a time, that kind of thing. We always know that a web visit will have a URL, a title, and a visited timestamp. In this particular case, in the database, the timestamp is called last visited timestamp, which is indicative, you would think, of the time that the web page was visited.
You would think.
So when that information was being modeled within the software, the timestamp that was within the database was used, and it was called last visited timestamp. Since the investigation that I did into this case, I requested that the forensic research team at Cellbrite revisit this data and confirm if there's confusion around it. Were my findings correct ultimately? There are times that that information can be correct. If, for example, you create a brand new tab, visit a website, and then close the tab immediately, then that timestamp would be indicative of the time that the URL was visited. But if you were to create a tab, use it for 3 hours, and then close it, the timestamp would not be indicative. Also, if you were to bring an old tab into
you
Focus
said-
that you'd used several days earlier and then close
there was no
that tab,
result, which
again,
it
you're
just
going to
matters
get
when she
bad
typed it,
timestamp information.
which would have been when it was
So
created at
ultimately, from
2:27 a.m.
Cellbrite's
There's
point of
no
view,
other
we
explanation.
removed the timestamp from that data, to avoid confusion in the future.
You shared with us that the URL for the 623 and 624 attempted searches ultimately was removed from the device.
Yes.
Would it be fair or accurate to say there were over 4,000 deleted files from the phone, or there was 4,000 deletions from the phone?
There were many.
Sustained.
Okay.
As to form.
Would it be accurate to say that the only deletion from that phone was that 623, 624 search?
No, there were thousands of records deleted ultimately for various reasons that I can follow.
That would be an inaccurate assertion?
To say that that's the only record that was deleted is inaccurate, yes.
Yeah, but you said that you could
Okay.
identify the
Thank you. I'm now
cause
going
of
to turn
the other
to a
ones,
second
just
phone that
not
you
this
looked at.
one.
Okay.
But again, it doesn't matter. The record exists. How long to die in the cold happens at
You told us that
2:27
you
a.m.
looked at two phones. The second
There are
one was
no
a
results.
phone that
Who fucking
was
cares?
or is attributed to John O'Keefe.
Correct.
When you looked at the phone for John O'Keefe, were you looking at things different than we looked at on the phone attributed to Jen McCabe?
I wasn't as interested in internet data. I was more interested in location and health and anything else that could be useful.
Before we show any presentation,
Could
I
be
want to
Googled
get
how
a
to
little
stop myself
understanding
from getting murdered
of
by
what
my
you
friends.
looked for and what you found.
That'd be important.
Were you looking for what's called location data?
I was, yes.
Was there a period of time that was important that you were looking for relative to location data?
God, I'm hungry.
Typically after midnight and before 6 a.m.
Is that
hate
on
eating
January
breakfast. It makes
29,
me hungry for more
2022?
It is, yes, sorry.
How does a phone, like an iPhone, store location data?
In your
multiple
mom.
ways that it can be stored. Primarily, there's a database called cache.sqlite. And every time an application requests location data from the device, a feature called Location Services on iOS tries to calculate the device's location using a combination of technologies, GPS, Wi-Fi, cell tower, and Bluetooth. Calculates the device's location and stores that into the database as a latitude, longitude, altitude, timestamp, accuracy radius.
How often does
information
your
like
phone show you in the
Are there
women's
different
bathroom at a
types of
Wendy's?
location data that are captured and stored
A
on a
Wendy's,
device like an
I should call
iPhone?
it.
Can you define different types, please?
I'm sorry?
If you could define what you mean by different types.
The different sources of data that are generated that then captured on an iPhone.
Yes, so the application can specify how accurate it wants the data to be. So, for example, if you're using a navigational application, you'd want high accuracy data. So the application would request high accuracy data from location services. Location services would then try to use GPS primarily to get location information. Versus if you were using a weather app, for example, where you don't really need to know precise information, you just need to know the approximate town maybe that the user's at. So a weather application would ask for low accuracy information, and the device may be
You're
able
good at low
to
accuracy
calculate the
information.
location based on cell tower information, for example. Both can be stored in the database with the accuracy information that's available.
Would a application that is devoted to navigation in your programming experience typically have stronger data, location data information than a more general application like a weather app?
Yes, for sure. And Apple actually specify in their documentation, when they specify the various different accuracy levels, they have one for navigational purposes for map applications.
How do you define accuracy level from the different data that's being stored in the phone?
How do you mean? Sorry.
Is there high level, middle, low?
Yes, the information is typically provided with a range of meters. So you'll have a latitude, longitude coordinate and a number of meters that you have to draw around that locational point. And the device is somewhere within that circle. It could be as accurate as 2 or 5 meters. it could be as inaccurate as several miles, depending on the technology that was used to get the data.
Are you familiar with an application
Still just ignoring
called
that
Waze?
private
I am, yes.
browsing.
Tell us what Waze is.
Waze is a navigational tool, so you can plot a route and it will try to direct you the best way, avoiding toll roads, avoiding accidents, that kind of thing.
What is the level of accuracy in location information that is generated by using Waze?
That would be the highest level of accuracy. So it would aim to get GPS quality information of around 5 meter accurate.
So why doesn't a programmer in every application just use the highest level location data for every application?
Getting GPS data is not always possible. If you're in a building, in a basement, for example, you may not get that. But also, it can be expensive to the device in terms of processing power, in terms of battery requirements. So if it can find location information cheaper by using the Wi-Fi networks, for example, then it would prefer to do that. So just a lot less resource intensive than using GPS all the time.
In order to capture the highest level of location data, the
Hawkins,
most accurate
I
in
know
an application
because it
such
says
as Waze.
private doesn't mean it is.
If
It
somebody's
was
using
on
Waze
his
and then
PowerPoint
turns
as
it
an
off,
explanation
does it
for
still
how
continue
the
to capture
search
that
wouldn't
highest
have
level
results.
of accuracy?
We just
Typically not. It may
glazed
do
right
for a
over
short
that.
time, as it's still kind of working through a backlog. But fundamentally, if there's no application open that's trying to use location
Yeah, these
services,
dorks are trying to say
then
Waze is the most
location
accurate
information that's being requested and
navigation
recorded
software that
is
exists.
far more sporadic. It's typically background applications that may be requiring location data.
When you analyze John O'Keefe's phone, in addition to the location data, did you also look into data known as health
I
care
did,
data?
yes.
And could you tell the jury how that works?
Yeah, so
My phone is Googling how to
pretty much all
remove its
iPhones
own
for the
battery
last
as it listens
10
to
years
this
or
guy.
so have Apple Health included. It monitors activity on the device, such as steps taken using various sensors inside the device, looking for motion which appears to be walking. It monitors altitude, so it knows whether you've gone up a flight of stairs, for example. It uses that information in concert with the steps taken, so it knows the difference between going in an elevator versus walking a flight of stairs. And all that kind of information is available to you as a user to essentially see how far you walked each day and to monitor your own health.
Thanks.
When you look at healthcare data, you said it interprets it in different terms. One you used was steps. If I have an iPhone and I'm walking and it registers steps, can it tell what direction I went in?
No, it's purely just looking for motion of the gyroscopes, which appears to match the pattern that it expects of somebody who's walking. It doesn't know whether you're in a straight line, walking in zigzag circles, just number of steps.
What if I had my iPhone and I was moving the iPhone, but my feet weren't moving? Would it register?
It could register some, but typically it's relatively good at picking the difference between actually walking or throwing the phone around or shaking it.
The healthcare data, does it store with date and time?
So there's two locations that health data is stored. Primarily a database called HealthDB_secure. And that aggregates the information into periods of time. So you may have a 10-minute period where it
Usually
says
it's 5
100
days
steps
or
were
so.
taken. It could be that the 100 steps were taken in the first
pretty
2
quick for
minutes,
this guy.
and then virtually nothing was done for 8 minutes there. But there's another database called Cache Encrypted C, which is more granular. It's where the information
Granular?
is written originally prior to it being aggregated and moved into the bigger health database.
You also mentioned that the healthcare data has a term known as steps.
Yeah.
If the movement registers as steps, would that necessarily mean that a person was walking up or down steps?
Sorry, are we talking about steps taken or flights climbed?
I'm sorry, flights climbed.
A flight climbed, according to Apple, is essentially an incline of 3 meters over 16 steps taken. So it wouldn't really matter whether it was walking up a flight of stairs, walking up a steep inclined hill, on an escalator, something like that. If there is movement that appears to be walking and an incline of 3 meters, then that would be considered a flight climb event.
Is there any other ways that the phone could register flights climbed, but the person's not actually walking up or down stairs?
You launched them out of a catapult.
So I did test this a few months ago, driving in my vehicle.
Hoist them up
I
with
was
a
able
rope.
to, if I just put a phone on my dock as I'm driving around, nothing was
Whoa.
recorded.
Put it on
But I
vibrate
found that
too.
if I was actually holding the phone while driving at the same time,
Hold the
then
phone.
the natural suspension of the vehicle plus the movement of my arm would be considered enough to be steps. And if that motion happened while
Why
I
was
was
this
driving
motion
up a hill, it would also result in a flight
Not
climb
while
event.
driving, brother.
And the testing that I did consistently resulted in, I think it was 9 flights of stairs climbed while I was driving up
That's
the
a
same
lot of
hill,
this, man. That's 9
multiple
flights
times.
of stairs. Whew.
In your studies, what elevation change would have to be present if you were in a car with a phone and it would register healthcare data as steps? Is there a certain level of elevation that would trigger that?
Again, it's just a 3 meter incline is required.
Did you say 3 meter?
3 meter.
That's a lot of incline.
The healthcare data, in addition to being able to give a range of time of movement and defining generally terms, whether it's steps or stairs, is there any other information about healthcare data that is important in your analysis of this case?
Sorry, can you just repeat that, please? I'm just
Sure.
trying to think.
The healthcare data you shared tells us there's movement,
Yes.
and it may come in the term steps.
Does not
You
register
also
drive.
shared that the healthcare data can show elevation. That can come in the term flights.
Yes.
Is there any other information about the healthcare data you looked at? Did you look at it across a wide range in this case?
No, it was just the steps and the flight climb that I was interested in.
What is the time period you looked at the healthcare data for in this case?
Between midnight and 6 a.m.
No,
or
girl
6:30
Friday,
a.m.
when I
At
drive to the
midnight on
grocery store, I get
January
38,000
2022
steps.
till about 6 a.m.
Yes.
And before we get to any presentations, did you see movement on that phone relative to healthcare data at different points through the night?
I did. Yes.
Did you identify those different times in your report?
I did.
You created a PowerPoint for Mr. O'Keefe's phone. Are those time points and movements, are they indicated in the PowerPoint as well?
They are. Yes.
So you had, with Mr. O'Keefe's phone, you looked at location data, you looked at healthcare data. Is there any other data you found important in your analysis to try to track the movements or non-movements of the phone of John O'Keefe on January 29, 2022?
Yes. I've also looked at battery temperature information and at a feature called Doppler, which is monitoring for Face ID.
Tell us a little bit about the battery temperature. Is it the battery temperature of the phone or part of the phone?
There's a battery
you
temperature sensor
Break open
built
the casing
inside
on
the
your
phone,
bath
within the
battery. You
battery.
can warm up your
And
bathtub
it's
with it.
Essentially,
Try it out.
always checking for battery overheats or battery
Lithium bath
cooldowns to the
bombs.
point where performance will be affected and the device needs to power off to save itself being damaged. So that temperature information isn't recording ambient temperature. It's not interested in the temperature in the room, for example. It's purely interested in the battery temperature. But it is affected by ambient temperature. And I, again, did lots of testing by putting the phone into controlled temperature environments, so inside a freezer for a set amount of time,
Inside my pants.
to
but
monitor
it's-
how the battery temperature would decrease over time, given the environment it was in. Bringing it back into a warm environment and testing how long it takes to increase. Putting the device outside. I live in Calgary, where it's pretty cold in winter. So putting it outside, it was like 40 Fahrenheit, I think it calculates to. And the temperature of the environment had a big impact on the battery temperature that was recorded by the device.
Were you able to track the changes in battery temperature for Mr. O'Keefe's cell phone over the course of the evening from after 12 on January 29, 2022 through after 7, 8 in the morning?
Yes, there wasn't a massive number of records, but there were records that I've included in my report.
In addition to those three areas, when a person uses an iPhone and presses the buttons, or they hold it and they try to open it by recognizing their face, what is that process called?
The Face ID would be the process for the unlocking, and then the locking, pressing the button on the side would lock the device.
When an iPhone is being used, does it
trying to lie.
act
What do
or
they call
operate
it,
differently
Pastor?
when it's out in the open, or if it's in your pocket or
Your
under
pocket.
something?
Yes,
Like
so this
the
is the
judge.
Doppler function that I found within a feature called Unified Logs. Essentially, whenever the device receives a phone call, or when you pick up the device, an iPhone X or above is trying to find a face to use to unlock the device. If the camera is blocked, a record is made to say that it's within a pocket state. So if my phone's in my
about to
pocket
go
when
get a
somebody
bowl of
calls
cereal.
me, it tries to look for a face, it immediately recognizes that the camera's blocked, and it records pocket state. As soon as I take the phone out of my pocket or unblock the camera, it records a pocket state cleared event. So we know when the camera was covered up versus when it was uncovered, if at the time it was receiving a phone call or was being picked up.
Does an iPhone always record whether or not the camera was blocked or hidden or covered at the time a call comes in?
No. For example, if the device is already unlocked, then it won't make a recording to say that it was within a pocket state or a pocket state cleared. And if the device isn't blocked at all, so if I have the device on a desk in front of me, for example, and a call comes in, there'll be no record that says that it's in a pocket state or a pocket state cleared. It will only record a pocket state event if the camera's blocked, and it will only record a pocket state cleared event if the camera was blocked and now isn't.
So if I have my iPhone and I put it inside my jacket in the darkness and I get 30 calls, would all of those calls result in a reading of pocket state?
They'd all result in multiple readings of pocket state. The pocket state check is conducted more than once a second. I can't remember the exact number, but it's very frequent. And an average phone call from the start of the ring to when the device essentially hangs up, somewhere in the region of 500 checks. So if you had 10 phone calls, then you'll have 5,000 checks made that would all report pocket state.
Did you analyze John O'Keefe's phone on the evening, early morning hours through the next morning on January 29, 2022, in an attempt to identify where he was, what he was doing, and whether his phone was inside or outside?
That was my goal, yes.
And did you engage in that analysis, sir?
I did.
And in your efforts, did you write a report?
I did.
Did you write multiple reports on these separate issues?
I did.
And those reports are provided to everybody?
Yes.
In addition to the reports that you generated from your study, did you present or did you prepare a PowerPoint?
I did.
Does the
This guy
PowerPoint
loves
outline
PowerPoints.
some of those points?
It does.
You know you're a
At the
government
end of the
expert when you're
PowerPoint,
still
you
using
go through a
PowerPoint.
timeline accumulating many of these pieces of evidence together that show them in a chronological sequence.
I do.
And does that help capture the movement or non-movement of John O'Keefe's phone through that night?
I believe it does.
Or may I approach?
Yes.
I'm showing you a binder, sir. Could you look at it? Let me know if you recognize it.
Yes, this is the presentation that I created regarding John's phone.
And does it include some of the subject areas we just spoke about?
It does.
I'd move to introduce this as an exhibit, please.
No objection, Your Honor.
Thank you.
John Campbell, did you write multiple reports? Isn't it leading? No, because his answer could be no. I prepared one report, and the
Thank you.
asking of the question doesn't infer the answer they're looking for. You wrote multiple reports, didn't you? Would be leading.
With the court's
Did
permission,
you write
Mr.
multiple
Whiffen,
reports? Is just yes or no.
referring to Exhibit 39, I'd like you to walk us through John O'Keefe's phone on the evening of January 29th
Okay,
2022.
Yes.
thank you.
By the way, guys, when the
So I
there's a
start
break
the
in testimony,
presentation
we'll
with
get
location
super
data.
chats and super tips.
As I mentioned earlier, this comes from the cache.sqlite database, which is considered the most reliable location or the most reliable file for location data on an iOS device. Stores information whenever location information is requested. That could be through user interaction with the device using something like Waze. It could be background activity, just depending on what applications the user has open, what settings the user has chosen. It's constantly trying to find its location and recording it in this database, partly for the purposes of identifying frequent locations. At 12 minutes and 5 seconds after midnight, the device shows multiple location points at Washington Street around Forge Pond. What I've tried to show here, there's a kind of a gold dot in the middle, which would show the actual latitude, longitude information. And then the circle around it is what's considered the accuracy radius. The smaller the accuracy radius, obviously the more accurate the information is believed to be according to the device. But ultimately, if the device is anywhere within that circle, then iOS would consider it correct. It considers it an accurate record.
Mr. Whiffen, why are there multiple circles of location data for one point
Didn't you see
where Mr. O'Keefe's cell phone was?
So this wasn't a single point in time. This was multiple records at around 12 minutes and 5 seconds. No application was actually in use at this time requesting location information, but the device, for whatever reason, recorded multiple records with various degrees of accuracy. Typically, you would see accuracy start quite low and get better over time, which you may have seen on your own device when you open up the map application, and it may show your device close to where you are, but not perfectly where you are, and then wait a few seconds, and that information gets refined. Essentially, this is the same thing.
So low accuracy would be a wider circle and higher accuracy would be a smaller circle?
Correct.
At this point, Mr. O'Keefe is not utilizing Waze on his phone,
Correct.
but location data is still being stored randomly on the phone from multiple different sources?
It is, yeah. Depends on the device itself.
In the top left-hand corner, it says 12:05. That's the time that this snapshot?
Yes.
Okay. And
in
then
this
below
case, approximate.
and below it's obviously the date.
Yes.
Okay, could you take us ahead, please?
Okay. There were multiple records between that last time and what's shown on screen now at 19 minutes and 33 seconds. But all of the records were sporadic and low accuracy with values of 1,000 meters or more. But around this time, around 19 minutes and 33 seconds after midnight, is when Waze was actually brought on screen. Waze starts to ask for high accuracy data, so we see the accuracy immediately start to improve. So again, we see relatively low accuracy data to begin, and then over the next few seconds, it begins to refine itself until it gets down to a 5-meter accuracy records as the device continues up here. We'll highlight that there's a cluster of records here as the device came to either a slow or a stop. Momentarily, multiple records were created, and then the device continued driving up Denham Street.
Mr. Whiffen, below the time, 12/19/33, in the date, talks about the average accuracy,
Yes,
and that's in meters?
that's in meters. So again, the records that are shown at the bottom here are around 55 meters. The records shown at the top are around 5 meters.
Is it typical in Waze that once it locks in, the range is around 5 meters?
Typically, yes. That would be the goal.
You also mentioned the average speed. Where do you learn the speed from? Where does that come from?
Where do you learn
The
that?
database, the Cache SQLite database also calculates the average speed between two data points, and also the
Not difficult.
the bearing or the direction of travel between those 2 points. So the average speed that's shown here on the left is approximately the average of all of the records that are shown on this map at the time. And each of these map points has a directional arrow that points in the direction that the database recorded the device was traveling in.
It's called
When
a
you
vector.
look at this information generated because of the usage of Waze, and you can see both the accuracy and the speed, with the Waze information at its most accurate, can you actually tell whether the vehicle is moving or whether it stops?
Yeah, based on the speed and the location and the timestamps, you can determine whether the device is moving or stopped.
Thank you.
Also important to, I think, point out here, in
Wait,
terms
what?
of knowing how
Here's the
reliable this location information is, I typically look at something along the lines
Objection.
of...
No question
does
was asked.
the location think it's accurate, in this case 5 meters, so yes. Does it make sense? Like, it's on the road, it's on the correct side of the road, so again, it kind of makes sense. It fits the pattern of the road. The cadence and the speed are, what you would expect for this road. Like, traveling at 20 to 30 miles an hour up here seems quite reasonable. So all of these factors taken together increase my confidence that this would be reliable location data. Moving to the next slide, between 20 minutes and 19 seconds and 21 minutes and 58 seconds after midnight, the device starts on the on the right side at Dedham Street, drives up and turns left onto Maplecroft Road. Again, we see that all of these location points match the pattern of the road layout. They all have a consistent cadence, a consistent speed, traveling at between 10 and 20 miles an hour. And we see a cluster of records here, which is around a stop sign. So again, it indicates how reliable the data is, because the location, or the location data that's recorded recognize the vehicle slow, come to a stop, and then continue after the stop sign.
Is Maplecroft Road in Canton?
Yes. At the end of Maplecroft Road, the device turned left onto Oakdale Road and continued heading down there. Between the hours of 21 minutes and 59 seconds and 22 minutes and 53 seconds, the device continues down Oakdale Road. Again, all of these location points show with 5 meter accuracy. They show a consistent cadence, consistent pattern to the road. And again, we see a cluster where we see the device come to a slow or a stop for a stop sign. The device ultimately turns right onto Cedar Crest Avenue, I believe, and continue down there between 22 minutes and 54 seconds and 23 minutes and 57 seconds. Again, as I've said before, all of these points, 5 meter accurate, they all conform to the road. The cadence is good. And again, we see a cluster on approach to a stop sign. The device shows that it overshot Fairview Road and continued turning up Cedar Crest, but came to a stop somewhere between 50 and 51. And at 23 minutes and 58 seconds, the device appears to have turned around, so potentially a 3-point turn, in order to head back down Cedar Crest Road and turn right onto Fairview Road. Again, accuracy 5 meters.
I'm going to accurately go grab a bowl of
conformity to the
cereal
road.
and hit the
All
bathroom. I'll be
appears
right
to
back,
be,
guys.
Reliable and makes sense, traveling at an average of 20 miles an hour.
And that road coming down at the bottom of the screen where John O'Keefe's phone travels, that's Fairview Road?
This is Fairview Road here, yes. The next few slides replay that same data, but instead of showing multiple points on one graph or on one map, it's going to show one location point per slide. So at 24 minutes and 20 seconds, we see the device is already on Fairview Road. Accuracy of 5 meters, traveling at 14.8 meters and heading south. 24 minutes and 21 seconds is now at 16.2 meters, but it's still highly accurate information. 24 minutes and 22 seconds, traveling at 18.3 miles an hour. 24 minutes and 23 seconds, traveling at 16.9. 24 minutes and 24 seconds after midnight, traveling at 16.9. 24 minutes and 25 seconds, traveling at 16.6. 24 minutes and 26 seconds, traveling at 17. 24 minutes, 27 seconds, traveling at 15.9 miles an hour. And at 24 minutes, 28 seconds, traveling at 14.5 miles an hour, at which point it's approximately outside number 34, around the driveway area. 24 minutes and 29 seconds, traveling at 12.1 miles an hour. 24 minutes and 30 seconds, traveling at 11.5. 24 minutes and 31 seconds, traveling at 10.4. 24 minutes and 32 seconds, traveling at 8.9. 24 minutes and 33 seconds, traveling at 7. 24 minutes, 34 seconds, traveling at 5.2. 24 minutes and 35 seconds, traveling at 3.5. 24 minutes and 36 seconds, traveling at 3.2 miles an hour. And at 24 minutes and 37 seconds, traveling at 1.4 miles an hour. Finally, the device comes to a complete stop at 24 minutes and 38 seconds. I'll say from the testing that I've done related to the speed, it may not be 100% accurate, but it's a very good indicator of the speed in general. So if it says it was traveling at 10 miles an hour, it would have been traveling at somewhere between 9.5 and 10.5 on average.
Mr. Whiffen, you just showed us the travel of Mr. O'Keefe's cell phone around 12:24 to 12:24:38 on January 29, 2022, and you said at 12:24:38 it came to a complete stop.
Yes.
Before that complete stop, was the car continuously moving at some speed?
Yes, this is the first record that shows 0 miles per hour or 0 meters per second. Prior to this, there was always a record that showed some level of speed.
If you look at number 34 on that chalk, if you can highlight it, please. Okay. If the driveway were at the right side, the top side of the house,
Yes.
does your studies indicate that the vehicle, or at least the phone, traveled past the driveway before it stopped?
Objection, Your Honor.
Ask it non-leading, please.
Did this car, or the phone that was in the car, ever stop at the driveway of that address?
No, according to the location and the speed data from the device, by the time it was approximately the driveway, the phone reports it was still traveling at around 15.9 miles an hour.
Have you ever seen a photograph of that address?
I have.
You have or have not?
I have.
You have. And in that address, do you see on the far left corner of that address, the yard, there's a flagpole?
Yes.
Where this car stops, or this phone stops at 12:24:33, how close is the phone to that flagpole?
I believe very close.
And do you ever see the car or the phone stop anywhere near that driveway?
No.
Please continue.
Between 24 minutes and 39 seconds and 25 minutes and 8 seconds, there were a cluster of more records, all showing 5-meter accuracy, but no movement. Although the center point does move around a little bit, you could interpret this as movement, but because all of the radiuses or radii overlap, there's also a good chance that there's no movement that actually occurred here. This is just the device as it's trying to refine its location. At 25 minutes and 30 seconds, we see a relatively significant change where the accuracy drops to 34 meters. We do see a course or a bearing that shows that the device reported it was heading west. But again, this accuracy radius includes the previous locations anyway. So it's difficult to differentiate between actual movement based on this location data or just on the fact that the accuracy reduced. The center point shifted because of that accuracy change, and therefore a bearing was attributed to it when it shouldn't have been.
If I could ask you some questions about the chalk on that indicates 25 minutes, 30 seconds, so 12, 25, 30. The circles become larger.
Correct.
Is Waze still being used, or has Waze been stopped?
No, Waze has been closed at this point for about 40 or 50 seconds.
For how long, sir?
About 40 or 50 seconds.
This location data, or this circle, the perimeter, that's not coming from the Waze application anymore?
No, the location data never came from the Waze application. Waze was requesting location data. iOS is responding to that request, and as part of that response would write the information to its database. Waze itself records very little location data.
So when you look at that circle based on location data alone, could the phone be anywhere within that circle?
Correct.
There is a bullet pinpoint center of that circle.
Yes.
That center of the circle doesn't necessarily mean that the phone is at that exact location, does it?
It doesn't know. The center point is purely an indication of where you need to draw the center in order to draw the radius. If we didn't have a center point, how would you know where to draw this circle?
And so the phone could be anywhere in that circle, close to 34, inside 34, 32.
Objection, Your Honor.
Ask it non-leading, please.
Could the phone be anywhere in that circle?
It could.
Could it be at the center point?
It could.
Could it be still in the car?
It could.
Continue, please.
Between 25 minutes and 31 seconds and 25 minutes and 36 seconds, there's an additional cluster of location data ranging between 61 meter accuracy and 17 meter accuracy. All of them roughly centered on the same point, approximately, and all of the the accuracy radius covers the same area. Like, there's so much overlap in these records that the device is essentially anywhere within the smaller circle. Between 27 minutes and 35 seconds and 38 minutes and 15 seconds, there was approximately 50 low accuracy records. Again, the device wasn't being used to ask for location data. This is completely passive and resulting in some pretty poor location data. I've highlighted with the red arrow where the 34 Fairview Road is. And we can see, although a lot of these location data do overlap with that point, there are location information here that doesn't. At 38 minutes and 16 seconds, the accuracy improves again. Is now 18 meters accurate, but continues to show approximately the same location that we saw 10 or 15 minutes earlier, around the flagpole area. 38 minutes and 17 seconds, same general area, slightly higher accuracy information down to 14 meters. 38 minutes and 18
Riveting
seconds.
testimony.
Accuracy increased to 12 meters, shifted slightly. Now the flagpole area is essentially at the lower side of this circle. Obviously, the top side of the circle now includes a part of 34 Fairview.
If the location information is indicated by the circle and the
Took
circle
me a little long
has
because the
shifted,
kids
does that
finished all the
mean
sugar.
Necessarily, the phone has moved.
Not necessarily. Typically, you could assume it has, but when we're already talking about accuracies of
Always have to double check the powdered
12,
substances.
13, 14 meters, it starts to become a little bit harder to determine how accurate this data is. So at this point in time, it could be anywhere within this circle, and the movement of the center point could just be the result of refinement of the device or environmental conditions that suddenly change. If the weather changes, it could cause the device to slightly miscalculate or to calculate differently.
Would a snowstorm or a blizzard potentially impact the precision of location information that's not precise like Waze?
It definitely has the potential to, yes.
How about a phone being covered? could that affect it?
That could also affect it, yes.
If somebody was lying on a phone, could that affect it?
That could affect it.
Could being in a building affect it?
It could.
Thank you.
Done that one at 38 minutes and 20 seconds. Again, refining information more. We've got an 8-meter accurate radius, still focusing primarily on the front yard towards the left side. And then accuracy of 7 meters at 38 minutes and 21 seconds, again showing that same general area. Between 40 minutes and 22 seconds and 59 minutes and 29 seconds, accuracy fairly drops off again, and we see some fairly wild records that don't cover the area at all. But we also see some more accurate records showing, again, where the red arrow points at Fairview Road. Those records are highlighted here, just between 40 minutes and 22 seconds and 59 minutes 29 seconds, only showing records of 25-meter accuracy or better. And again, it's kind of focusing on that flagpole area. Between 1 a.m. and 2 a.m., only looking at location information, which is 25 meters accurate or better. Again, it kind of focuses around the front yard area, although some of these accuracies are still rather large and could put the device inside 34 on the opposite side of the street, towards 32. Between 2 a.m. and 3 a.m., fairly similar story. Again, most of these points are centered around that same location at the front yard.
So who's ready
Similarly,
for Whitmed?
between 3 and 4 a.m., between 4 and 5, between 5 and 6. And in fact, if I take all of the location data between 25 minutes after midnight until 6 a.m., only looking at the records that report 10-meter accuracy or better,
Adderall.
then typically they all focus around that same location at the front of the yard, nearish to where the flagpole can be found.
I'd like to ask you some questions about this photograph.
Look at
There's a
this
red circle with a bunch of
photograph.
red dots in the middle.
Yes.
Would those red dots indicate
Like to
the
congratulate
center of some location?
Tons
that
of
was
law and
captured
having
at a particular point
350
over that night?
viewers.
Yes. So
Really good to see
each
him
of
growing
those
into
center
his,
dots
into his
is
own.
the center
Very
of
proud of
a
him.
10-meter
watching your
accurate or better location record. I chose to
Son go
not
off
show
to college,
the
but it's community
accuracy
college.
radius circle on this image, just purely because it makes it hard to see when you've got all these intersecting lines. But ultimately, if you were to draw a 10-meter radius around all of these points, they would all fall within the large red circle that's shown.
So this photograph was meant to take readings from the most accurate of the data throughout the night?
Correct.
Sustained. Ask it again differently, please.
Was this circle, did it include low frequency data?
No, this circle only includes 10-meter accuracy or better.
The fact that the center dots are in different spots, is that inconsistent with a phone being in the same place?
I can
not
say that
moving
joke because I
entire
went to
night?
community college first.
It could indicate movement. It could indicate refinement.
Is it impossible to tell?
It's impossible to tell at this level of detail
I
anyway.
earned
Are
that.
all of these dots, given the range, 10 meters or under, are all these dots and all these readings of the high frequency data that you compiled for that night, are they all consistent with Mr. O'Keefe's phone being near the flagpole and not moving that night?
Objection, Your Honor.
I'm going on.
I think that's a reasonable assumption.
All right, this might be a good spot. Are you ready to move on to the next area, or you have any more questions about
Now
this?
would be a fine time, Your Honor.
All right. Folks, why don't we take our morning break, 15, 20 minutes?
Thanks, Judge.
Judge, please leave your notebooks for all to see.
Thanks, Judge. Looks like a hangover.
Please rise for the jury.
I always rise for the jury. Oh my goodness. Dalton Barrett, what? Do you not like what other people in the chat are saying? It's a vicious cycle, man. It's a vicious cycle. Speaking of vicious cycles, if you guys are interested, check out supertip.gg/RL. We added 7 new voices. We've got 2 from this trial. We also happen to have Kurt, I believe. We have Nate. And we have Ronnie O'Neill. So all of those are available for your viewing and playing pleasure. The evidence will show. Ronnie O'Neill, my favorite axe murdering superhero. Here we go. These are super tips. Here's what they look like. Here's how we do. Get off my screen. Oh my God. Where's this? Can I press the button? No.
Your Honor, there's this saying, late and gay. I say this because Nicky Rackets is so late that he's a flaming homosexual.
That's true. That's actually a fact. Let's see. Here we go.
Did you hear about the crazy allegations against the Buffalo School District, including lawyers ignore subpoenas?
It's weird that a school district would ignore a subpoena. No, I have not heard the crazy allegations regarding the Buffalo School District, but maybe send me a link to it or a story on Twitter or something so I can follow up and see what you're looking for.
Objection, Your Honor. He said he's an expert in Australia. We all know that, in fact, doesn't exist.
Correct. Australia is not real. Can't be. Too funny. Also upside down and backwards. Oh, God.
I think this guy lost the jury quicker than Coach Toe ate your SEED off of April's tits.
Haha, yeah. Okay, yeah, faster than that's right.
He was crying, holding April's hand, saying, I ate it, I ate it, I ate it.
Come on. No. Stop.
So glad to have you back, Nick. Been with you from almost the beginning. Donga Saga. Watched the last Karen Red trial with Emily. Now the Reed trial with you. Let's go.
Let's go. Let's go. Let's go. It's not that kind of party, Mark. Get out of here.
Thoughts on if this limey is undermining convictions using Celebrity?
Well, look, what you have is an industry standard in Celebrite, and the industry being putting people in prison. You're not going to get it unseated and your conviction overturned so simply. First, they would have to show that this is actual evidence of unreliability of Celebrite's either software or forensic analysis. Second, that particular inaccuracy would need to be demonstrated to be sufficiently similar to your instance, your case, to overturn the conviction. Now, does it mean if they... You would need to rely on a finding, though. A finding that Celebrite is not reliable to really get anything out of it. Because right now what you're going to get is a jury's opinion on the reliability of Celebrite and their forensic analysis and their forensic analyst. I mean, the jury's going to form that opinion. There's not going to be an order about it or a ruling or whatever. If there was some, if there was some sort of motion hearing that resulted in a judicial finding that their results were inaccurate, that would be something that could be relied on by people on appeal. Right now, you're just going to have people who, go, yeah, they screwed me over too. But what do we got this here?
As long before Whiff Whiff gets a kick in the kitty on Crisscross Nicholas.
Pretty soon, I would imagine. The prosecution's going to drag us through this. And they've got their evidence in now to just say that the data shows that this other chick didn't search for the hose long because our expert said so. It's like, which is an insane proposition, but that's what they put before the jury. The question is, will the jury remember and believe it by the time we get to closing arguments? I should have taken a bite right before clicking play on one of the sound clips. That would have been the smart move. What is the... Let me see. Papa Slapnuts says, what is this British guy doing in my Boston courtroom? I don't know, man. I can tell you what he's not doing is providing an accurate representation of how reliable the browser search data is. Again, search data, aside from, I mean, it's even being factored into large language models, but aside from like just general communication, which is valuable to AI because it builds off of the aggregated communication of the entire world to try and make more effective AI. Well, simulated AI. It's a large language model. It's just aggregating data very fast and repeating it in a way that people write, and it gets more refined with more data that's put into it. So that's valuable for large language models. But I mean, Google search data, for example, it is what built what is, if it's not the largest company in the world, it's pretty damn close. And it's the search data that built all of it. What are people looking for? I mean, how valuable is that to everybody? Anyone who wants to start a business of any kind wants to know what people are looking for, and especially if they're looking for them and their product and what time and where these people are and who they are. What are their demographics? What else do they look for? Where should I sell ads? You know, what kind of places are these people going to? What are they buying? What are they selling? All of this is relevant. It's the most valuable data that exists for commercial purposes, for government purposes as well. It's not like commercial industries are the only ones who value this data. Government obviously does. And you and I do. Like, we care what other people search for. We want to know a little bit. There's value to everybody, whether you're paying for it or not. And we recognize that value in different ways. Sometimes we don't recognize that we're engaged in that value. But when you type in and there's a good prediction on what you're looking for, when you start typing your search and cuts down and saves you some time or gives you a better result, like that is hugely valuable to you. What is the one thing you cannot buy is more time. So cutting down the amount of time it takes you to find what you're looking for is valuable to everybody. So to suggest that these companies like just somehow got it wrong that you typed in this search, and he's like, well, I mean, no page resulted from it, blah, blah, blah. So we know that it was typed into the phone. You're just trying to somehow suggest that the record that was created at 2:27 a.m. didn't actually occur until 6 a.m., which doesn't make sense at all. But that's what he's trying to convince us has happened. And it's very, very strange to try and convince someone. It's like, well, actually, no, it was 4 hours later. Like, how did the software figure out she was, like, I know their predictive results are good, but that's a little much, right? But that's how it comes across, and he's sitting there trying to do it. But it's like, they're not going to get this data wrong. It's the most important thing for them. It's what they're looking for. It's why their search engines exist. It's like, we want to know what people are looking for because that data is worth more than the ads we sell on their search results. Sabina D says you can literally go to the history tab /activity on your browser and everything you will have the correct timestamp. This open tab time is BS. I agree 100%. Harvard Yard, welcome to lawyer status. Thank you for joining the channel. Elena Stansby says probably more about children than you would hope, Nick. He was a police officer in Rotherham, home of the grape gangs. No, gross. Ew. Blue Varo says this is why you should factory reset your phone weekly. Well, only if you're killing someone, I guess. Although, as a non-joke, if you have a personal habit of deleting your data every week, for example, some people like purge text messages and conversations like every week or day or month or whatever. Apps like Signal can do it for you, right? You can set it so any messages that come through after they're viewed, they stay for a day and then they go away. They're deleted on both ends. And so, if you make it a habit of doing that, then when something happens and they forensically analyze your phone, it doesn't look weird because your phone data is deleted consistently at the same time or on a schedule or whatever. If you suddenly start deleting things, it always looks fishy. And everybody's like, damn, I wish I would have started earlier. Just like investing. Not Cupcakes, welcome to Paralegal Status. Very happy to have you on the team here, the legal team here at Recato Law, the crack legal team. Hopefully you guys have your licenses while I don't have mine.
Are you going to listen to that testimony from the last trial about the crazy theory where he said John flew like 30 feet? And what was the name of that guy?
I may do that at some point. I don't know if I'm going to, I don't know if I'm going to do it today or anything. I don't remember the name of the guy. Someone said it on Friday's show from the chat, but I don't remember who it was. I don't believe he's being called as a witness this time. Probably because he just was not good for the state at all.
This is Oh, wait. I am too much of a douche to say this anymore.
Okay. So that was Nate, huh? I think that one needs some more. I think that one might need some more refinement or input or something. I have to figure out if we can do that. Here we go. Here's this one.
Nothing says, trust me, I'm a lawyer, like dressing like a lost rodeo clown.
Oh, man. Well, for all of the bitching about my lack of practice experience or whatever that people do, there are some people out there who never practice at all. Go for Big Guy 911 says, I tweeted you the Buffalo School BS unsubscribed podcast about 40 minutes long from Richard High from Angry Cops. Oh, okay. Thank you. So that's the Angry Cop stuff. I didn't realize those were the same two things. Michael, welcome to Paralegal Status. Happy to have you. Thanks for joining as members, guys. Always nice to see people supporting the channel. Making our full push back into reality. I've been living in unreality for about a year. Like something happened. I don't know. Not sure what that would have been. But one of the hard things is just not doing anything or talking about anything important for a year. It's you kind of get out of practice of even following along with stuff. Because if you're not talking about it, who cares? And that was a really tough thing for me. Like I don't do well with stagnation. I like to be going in a direction. Sometimes it's the wrong direction, right? Sometimes that direction goes towards jail, and you shouldn't do that. But that being said, it's once I was finally able to sit down and say, okay, now I can go in this way, and I could get back to streaming, it was very relieving. Gives you purpose. I don't believe that we're made to sit idle and stagnant. I think we're made to make things. We are created to create, and sitting around not creating was not good for me at all. Sometimes the direction is down south. You're going to quit. You hate trial streams. Okay. I mean, they're long, they're tedious, they're work, as opposed to just, blabbing on about nothing, which can be very fun depending on what you're doing. But I didn't stop doing trial streams because I didn't like them. I stopped doing trial streams because I just didn't have the ability to sit down and do them for 8 hours during the day. So I had a government mandated reshuffling of schedules. Not really, but kind of. Gave me the opportunity to try and reset some things. And one of them is having daytime availability, which at the time I was arrested, I didn't have. Schedule was terrible. This past school year, the schedule wasn't much better. Not that I was going to be streaming anyway. I mean, I wanted to at times, but it just wasn't going to work out in hindsight. Glad I didn't try and do it too much more. But that being said, you know, it gets sometimes boring to sit through 8 hours of yammering. But so, lots of work is boring. It doesn't mean I don't like them or I hate them. It meant and I said so many times, I would love to do them. I hate that I can't do them. It's a pretty big difference from hating them. But hey, it is what it is. Keep telling me more about myself. That's fine. So today we've got, just as a recap of what's been going on, direct examination of the forensic analyst from Cellebrite. Cellebrite is a software tools for data extraction and analysis used by law enforcement. I think it's created by law enforcement or former law enforcement people. And it's perfect. It's perfectly correct and accurate all the times when it's trying to make you guilty. But it's broken here on this one message. This one message, which should be exceedingly damaging to the prosecution's case. And the message is, hose long to die in the cold. Now they think she was typing how long to die in the cold. But we here know, at Recato Law, we know that this is hose long to die in the cold because these hoes ain't loyal. They need to get gone. And that's what they were talking about. But no, obviously, the how long to die in the cold search, you would assume would come from the suspected murderer, right? But it doesn't. It actually comes from one of the other people there, a person who, at the time that search was allegedly made, 2:27 a.m., would not have known that the person that was dying in the cold was missing, according to the official narrative. Wait, what the fuck? Anyway, they would not have known at the time that he was actually out there dying in the cold. They would be informed later that he was missing. So for that search to occur at that time is very suspicious. Now, why would someone make that search? Well, one, you're either concerned about someone dying in the cold and you're wondering how long it'll take them to die, which is a dumb question in the moment. I really, really, really need people to understand how stupid it is to ask how long someone is going to take to die when you think like they're like, unless you're going to quit looking. That's the only time that question becomes relevant. Well, we've been at this a while. I guess they're gone. Like, maybe that matters. But if they're missing and you think they're dying in the snow, finding out how long it's going to take them to die doesn't help you save them. So that's a dumb question. Don't ever ask it. Like, if someone sinks into the water, it's like, well, how long does it take them to drown? It doesn't matter right now. They're either going to drown or they're not. But if you could pull them out and you're busy texting on your phone trying to figure out how the fuck long it's going to take, then they're going to just die. It's just one of those dumb questions. But here's a time where it may not be so dumb. Oh crap, a man is dying in our house. How long does it take to die in the cold? We need to know how long to delay this thing. Can we plausibly throw him out there and, you know, make it look like he died? Like, is there time? There's this movie. Spoiler alert. This is a really fun movie to watch. It's called Minnie's First Time. It's got a great cast. It was an independent film, so it's like a smaller production. It didn't have a huge release, but it's long story short, someone gets killed and then they want to make it look like a suicide. So they put her in the car in the garage and they run the car, right? And then they call, oh my God, call 911. She's dead in the car from the suicide that she did. And the investigator eventually comes back. He's like, yeah, which is played by Luke Wilson. He's great. He's like, I had my guys look into it, and it takes 4 hours for that car to put out enough exhaust, enough carbon monoxide to kill someone. And that would take this much gas, but the car has more than that amount of, or has less than that amount of gas missing. Like, so can you explain that to me, how that happens? It's like, if you're that's the only time that it matters. Like, you should have figured out how long it was going to take, run the car that long, and then made your report or whatever you're going to do. That's when you would research this question, is find out how long it's going to take to make it look plausible. How long do we have to sell this thing? It doesn't make sense in any other context, in any logical way. It also, to me, makes even less sense that there's no results posted, which, as he said, and they just ignored this on the slide, it's either private browsing, which means she was typing that in and searched for it with private results because she knew that someone might look at her phone and see that. That's a problem, right? So it could be private browsing data that we're just overlooking. And that I think we'll probably see it on Cross, but the absence of them trying to head that off as a prosecution team seems silly. Like, you're bringing this guy in to address that message, which is pretty obvious. And you just have this lingering, this hanging Chad, so to speak, on the PowerPoint. Not a good look. Not a good look at all. Whole shirt. When do we get to the Karen Reed trial? They're just on a break, man. We've been on there all day. All day. Maybe she's been how long to die of embarrassment in the cold as her nips were rock hard and on display. Yes, I think that might be it. That could be. But I also like, he tries to make it out like maybe Apple's predictive searching would have produced some sort of result like that. Oh, but the other thing that he didn't really get into, and I don't know the answer to this. I'm not a forensic analyst for Celebrite. What happens if the only results the person gets are the results that display on the search result page rather than following through, right? Like, if you search on Google for how long to die in the cold, you'll probably get some little drop downs that have summaries of like Quora or Reddit, Quora answers or Reddit posts or whatever, where people have asked this question and then someone has responded to it. And for whatever reason, the phone thinks that that's the right response to help you out with your question. Google, of course, now has AI answers as well. Those weren't around when this happened. But, they would still have just answer pages that come up, and you don't have to visit those pages to get a summary of the outcome. If the summary of the outcome on how long to die in the cold is like a little synopsis of or an abstract of the Wikipedia article that says hypothermia can set in as fast as 2 hours or as long as 10 hours or something like that. You don't need to click on anything. You've got your answer. What the?
As executive chef, I've always wanted to create a space where people like me can just come in and focus on their craft.
They just
It's a seafood restaurant told through the lens of a lot of Ethiopian recipes.
Sorry about that. I had it just ended the stream, so I gotta go find another one. Clearly, my autoplay goes to cooking channels. Let's see. Oh, here we go. No, I'm not gonna. That's Hill. All right, Karen Reed trial. We go to live. Ew. Well, I was gonna go on the court TV one. Doesn't have they don't have closed captioning. We'll try this. All right, we've got the feed back up. Just waiting on them to come back. Do I miss Birch Gold? Yes. That was good money, man. I mean, for what it was.
I think that this stream is really enjoyable and more.
Wearing a cowboy hat was supposed to make me look rugged and desirable. Turns out it just made women cross the street faster.
No. Oh, no, Kurt. No, Kurt, do not do this. No Bronca today. No, so here's what happened. Bronca texted me yesterday. And he had just found out, he had made the link for today's show. And he found out that the Christopher Schur trial, who is a police officer who shot a man that he was wrangling, he shot him in the back of the head. And so this is a use of force trial. It also has a degree of racial intensity to it. It's a white cop. It is a black dissident. And it's pretty controversial because it's a gunshot to the back of the head. And that adds like a starting point. You go, okay, you've got a guy on the ground. You're pinning him down and you shoot him in the back of the head. I'm finding it hard to see the justifiable use of lethal force in that situation, in that way. But I'm willing to be convinced. I don't know. So the cop is on trial. That's Bronca's area of expertise is use of force. And it's a little bit more up his alley than the Karen Reed trial. So he said that he is going to cover that one. I don't know how long that trial will be. There are many less witnesses. It's much more straightforward. They probably have a couple experts. And I think there's only one eyewitness. And so you're going to have not a ton of forensics. I mean, they'll just have to do foundational stuff. Here's the bullet. Here's the entry wound. Here's the exit, et cetera, et cetera. But, the question is going to be, was this use of force justified? It certainly shouldn't be a 6-week trial, maybe a week. If Bronca wants to come back and join after he's done, go back to co-streaming, of course. I will welcome that proposition. But that is what he will be doing for the duration of that trial. He invited me to come with him. And I said, you know what? I think a big thing that people are looking for me coming back is consistency, which is something that I really, really lost control of at the leading up to my legal issues. I was not keeping a consistent schedule. I was canceling shows all the time. I didn't want to come right out the gate and switch to a different topic after a week. Because, if I'm going to cover a trial, I would like people to know that I'm going to cover the trial. So that's where we're rolling, and that's where we're staying, like Limp Bizkit or whatever. Shaq says he didn't have him pinned down. The cop never had control. See, and that's where the legal questions come in. Look, I didn't heavily research it. It's just my initial judgment is cop shooting someone in the back of the head. 1, I don't like cops that much. 2, I don't like them shooting people. 3, sometimes they need to. So I'm just open to interpretations, open to being influenced either way. But my initial assessment of cop shooting someone in the back of the head is a hard headline to get to immediate justifiable use of deadly force, right? The person's turned around. If you shoot someone in the back of the head, guess what? You're going to prison. That whole justifiable question, that's going to go out the window if you're not a cop. They're not supposed to be treated differently on that, but they are. You put a gun to the back of someone's head and pull the trigger. I don't care how in control or out of control they are. You're going to prison. Stream snipe Bronca. Get in there and review his legal analysis. That'd be kind of funny. Okay, so Not Cupcakes says, where's the line between representing the government's case against a defendant and defending a witness? Seems like Hank is defending Jen McCabe more than he's prosecuting Karen Reed. No, you got this backwards. He's attacking bad facts for his case. See, this is a thing we got to get rid of. Get this damn thing off my screen. I got to play this again, just so it, for whatever reason, the text ones don't come down.
I think that this stream is really enjoyable and more.
Oh my God. Rock and Never. I would love it if you covered the Idaho 4 murder and trial in August. Thinking about it, of course, it all depends. Everything kind of just depends on how life is going, if there's anything else I'm covering at the time, if I have time to do it. I know a lot of people want to see that Kohlberger trial. From my brief glance, it seemed like they were grappling at the time. Bad as the headline is, when you're playing Combat Twister, the barrel goes where it goes. Oh, of course, yes. My practical advice is very simple. Don't resist arrest in any capacity.
Whenever you're ready.
Nicholas says, is Joe going to join at some point today? If he wants to, he's welcome to at any time.
Mr. Whiffen, before we go into the next subject area, I'd like to ask you about the location data. Based on your review of the location data, do you have an opinion whether the location data throughout the evening is consistent with John O'Keefe's cell phone being near the flagpole the entire night?
I believe it is, yes.
No closed captions on the stream.
I asked
Sorry.
you whether you had an opinion, whether it was consistent with. I didn't ask you if you had an opinion to a reasonable degree of scientific certainty. Are there other things that you looked at that you will consider in addition to the location data to have a more certain opinion?
There is.
And is the next thing that you considered Apple healthcare data?
It's the Apple Health data, yes.
We asked about it, or I asked you about it earlier on, but I just want to talk about it a little bit before you show us and present.
This guy looks like he has location data on high school girls.
Is Apple Health data different than when you have like an Apple Watch?
No, it's the same Apple Health data recording on the phone or the watch. The only difference is the sensors being used to do that monitoring. So if you're just using the phone, obviously you're only using the sensors in the phone. It's limited to steps walked and to altitude climbed. If you're wearing a watch, it can also do those things, but it can also add things like blood pressure monitoring and things like that.
Does Apple Health data require an internet connection?
It doesn't, no.
So it's all self-survives on the phone itself?
It is.
So without having an internet connection, it will still store the data?
Correct.
If I have an iPhone, is it storing health data even if I didn't ask for it to do so?
Yes. Unless you actively turn the feature off, it will by default try to track movement.
Is it something that is hidden that I wouldn't see unless I look for it?
No, there's an application for Apple Health, and then the settings are quite obvious in the settings screen.
Apple Health data tracks movement of the phone?
Correct.
His sitting
when you were
posture is
considering the
garbage.
Apple Health data in this case, did you begin looking for the Apple Health data before Mr. O'Keefe's phone began approaching Fairview Road?
Yeah, I started again at around midnight and looked at the health data up until 6:30 a.m. on the 29th.
You got a fucking hungry hippo
The
now.
different points when you tracked Apple Health data, is that helpful even if you're only trying to isolate a certain point in time?
It can be.
Bro,
yes.
sit up.
Does it help determine
God,
whether
I'm
or not it
getting
was
self-conscious
working
now. I'm
properly?
gonna sit. Gotta sit tall.
It can determine whether it's working properly. It can determine an average kind of walking speed, for example, of a person, the average gait that the person may walk with, if that was important.
If a person has an iPhone and they're moving and it registers Apple Health data, and then they stop moving, and the healthcare data doesn't register because there's no movement, would the Apple Health data resume movement even if somebody else picks up the phone?
It would. The phone itself doesn't care who's carrying it. It just looks for movement.
So it doesn't identify the owner in order to register movement?
Correct.
Objection, Your Honor.
Does it identify the owner in order to register
Better
movement?
question.
It doesn't, no.
Could you turn to the next part of the data analysis that you did?
Yes.
Please.
So the two sources that I got the Apple Health data from were a database called healthdb_secure.sqlite. This, as I said earlier, is the typical database that's used to store long-term information about the health activity that's been recorded. So this database can have years worth of steps taken, flights climbed, and any other kind of health data that's been recorded. The downside to that is that the information is aggregated. So you see chunks of time and multiple activities can happen within those chunks of time. The cache encrypted C.SQLite database is much more temporary, but is much more granular. So we can see exact times that flights were climbed, for example, or at least you can see the exact time that the flight climb was recorded to the device. And then that information is aggregated into the larger chunk of time. So again, we might see within the cache encrypted C individual flight climb events that occurred, for example, 30 seconds apart. But by the time that information is written to the HealthDB Secure, you're now looking at a 10-minute time period with 3 flight climb events, as opposed to 3 individual flight climb events with individual timestamps. Typically, that source is not used because the data is not stored there for very long. The information I found on John's phone was essentially these 5 records. So between 11 minutes and 9 seconds and 21 minutes and 5 seconds, there were 170 steps recorded by the device.
Mr. Whiffen, I'm going to stop at each one and ask you some questions. At the time period between 12/11/09, 12/21/05, you don't have any independent information where John O'Keefe or his cell phone were, do you?
The location data that I showed to begin with on Washington Street was around 12 minutes after midnight. So the presumption is that's where the location was at that time. And then 21 minutes and 5 seconds, the device had already started using Waze. It was already driving along Denham Street or had turned onto Maplecroft.
What time did you say that Waze was initiated?
It was approximately 19 minutes and 30 seconds-ish.
Thank you.
Again, we see at 21 minutes and 10 seconds until 24 minutes and 22 seconds, there are 80 steps recorded. And again, if you compare this to the location data, we know that the device was in a vehicle at this time. Between 22 minutes and 14 seconds and 24 minutes and 37 seconds,
I've had a lot of
we
tracking
have 3
devices,
flight
and they
climb
do
events
not
that are
track
aggregated into that time period.
steps
And
in a
again,
car.
the location data shows that the device was traveling in a vehicle at that time.
Mr. Whiffen, you had showed us a slide of 2437 on January 29, 2022 in your PowerPoint presentation, noting at that time, 12/24/37, the phone in the car was still traveling at 1.4 miles per hour.
Correct. This is about a second before it came to a stop.
Can you conclude to a reasonable degree of scientific certainty that that period of 12/22/14 to 12/24/37, Mr. O'Keefe, or at least Mr. O'Keefe's cell phone, was still in that car?
Yes, the location data shows it was in the car at the time. And my next few slides will demonstrate why that was still recording a flight climb event while it was in a vehicle.
Thank you.
At 31 minutes and 56 seconds until 32 minutes and 16 seconds, there were 36 steps recorded. And then there was no further health activity recorded on the device for several hours until 4 minutes after 6 a.m. When 432 steps were recorded between the time of 6:04 and 6:11.
Let me ask you about that 12:31:56 to 12:32:16 time period. We can see larger ranges in the time period range. That is a smaller range comparatively.
Yes.
Okay. At 12:31:56, is that the beginning of the 36 steps?
Essentially, yeah, it takes the timestamps from the cache encrypted C, looks at when the first step occurred, looks at when the last step occurred, and aggregates the times based on that.
So 12:32:16 would be the last steps taken for that cell phone.
Correct.
And in between that time period, there's 36 steps. You shared earlier that it doesn't indicate the direction of the steps.
Correct.
Other than the movement that equates the steps, can it tell anything about what direction, the positioning, how the phone was moving?
It can't, no. It's just purely registered what it thinks are 36 steps.
Could it have been a straight line?
It could have been a straight
Could
line.
it have been somebody pacing?
It could have been.
Could it have been somebody moving and jumping?
Yes.
Did
Jumping.
he just say that
if they
phones
were
don't track
jumping,
orientation data?
forward, essentially.
After 12:32:16, when this phone took its last steps, it never moved again?
Objection, Your Honor.
Form of the question, sustained.
After 12:32:16, when this phone took its last steps, did it move again until 6:04:01 a.m.?
There were no more steps or flight climb or any other health activity recorded during that time.
Do you know what triggered movement at 6:04:01 a.m. of Mr. O'Keefe's cell phone?
I presume that the device was moving at that time, but I don't know the details of who.
Objection, Your Honor. Move to strike.
I'll strike it.
Please continue.
Okay. Regarding the flight climb events, looking at the cache encrypted C database, I was able to find more granular, accurate timestamps for these records. And I showed those timestamps on this map at the position that the device was, according to the location data at the time.
So you're going back to earlier in the evening now, 12:22:14.
Correct.
To 12:24:37 when the phone stopped near the flagpole.
Correct.
Okay, thank you.
So we have the first record at 22:17, a flight climb event was recorded. I've highlighted that with a red line, and that equates to the red line that shows underneath the timestamp where the location was, where the device was at that time. The second record is 22 minutes and 32 seconds, showed with a green line, which shows over here. And then finally, 24 minutes and 37 seconds after midnight, shows with an orange line down here outside 34 Fairview. I'd like to point out that health activity events are recorded upon the event completion. The device doesn't know that you're about to walk up some stairs. It doesn't know that you're halfway up some stairs. It has to wait until you've reached the top in order to detect that an altitude change has occurred. So that change only gets written to the database once the flight climb has ended. I tested approximately 8 different phones, different models, different versions of iOS, and found that on average, there was a time difference between 15 and 50 seconds between when I physically stopped walking up a flight of stairs and when the record was made. So it's just based on the time that the device takes to pull the altitude, detect that an altitude difference has occurred, and then write the data to the database. So then I took that average data between 15 and 50 seconds and plotted it onto this graph, which also plots the altitude of the device over time. So the red line here shows the time according to the cache encrypted C database where the first flight climb event was recorded at 22 minutes and 17 seconds. Working back 15 seconds from that to say that with the gap that I know exists between the flight climb ending and when the record's recorded, the flight climb event is presumed to have occurred within this red gradient area. The altitude information on the device shows that between those times, the altitude increased from around 41 meters to around 45 meters. You may recall earlier I said that it's a 3-meter incline that Apple considers a flight climb event. Therefore, the incline that occurred within this red gradient is sufficient to trip a flight climb event.
Wait.
When we look at the second record at 22 minutes and 32 seconds, this is shown on this chart as a green line, and again, working back 15 seconds and beyond to allow for the tolerance,
So
we see the green gradient area.
What?
This shows an altitude change of around 45 meters to 48 meters. Again, that would be sufficient for a flight climb event to be recorded because we have 3-meter
This
incline
is going to be.
change.
How do they explain the
We then
drop?
don't see an incline change for a while. All we see is the device going downhill until we
How
get
do
the
they get the
record right at the
downhill?
end there at 24 minutes and 37 seconds. And again, working back around 15 seconds to the orange gradient, we see an increase from around 25 to 28, 29 meters. Again, that would be sufficient to cause a flight climb event to be recorded.
I'd like to ask you.
Sorry, I'll go back.
Wait, how does the phone go down?
I then compared that information
Almost
to
30 meters.
a topology website from the area, according to a topology website data, and plotted that out here. We see the red circle now is related to the first flight climb, the green circle to the second flight climb, and the orange circle to the third flight climb. The gradients that we see here are the same gradients that were shown on the previous graph. So the presumption is that within this red gradient is where the flight climb event occurred. Within the green gradient here is where the second flight climb event occurred. And within the orange gradient here is where the third flight climb event occurred. The white circles show the altitude of that particular location according to the topology website. So again, we see that for the red gradient, there's an increase from 43 to 47 meters. Between the green gradient and the green number 2, again, we're going from around 47 to 50 meters.
Down to hell.
And then with the orange gradient at the bottom, we've gone from around 26 to 28 meters. So fairly consistent with the data that was recorded on the device in terms of altitude information. And I would suggest is the reason that these flight climb events occurred.
Mr. Whiffen, there's 3 different times. The first is 12/22/17. At that time, was the Waze data app initiated?
It was.
And did that indicate whether or not Mr. O'Keefe or his phone were traveling in a car at that time?
Appeared to still be traveling in a car.
At 12/22/32, was the Waze data initiated and active?
It was, yes.
And at that time, does the data indicate that Mr. O'Keefe's phone was in a vehicle and moving?
It does.
And you showed us a slide finally from 12/24/37 that the vehicle was still moving 1.4 miles per hour.
Correct.
And was the Waze data initiated and active at that time, 12/24/37?
If I remember correctly, Waze had closed about 5 or 10 seconds earlier.
Now, based on your study of the Waze information, the location information, the topography, and the healthcare data, do you have an opinion to a reasonable degree of scientific certainty whether the indication on the healthcare data reflecting flights of stairs, do you have an opinion whether or not that was registered as a result of a person holding a phone walking upstairs or for some other reason?
Based on the location data, the health data, and the research that I did and the testing, I believe it is more likely that the device was in a vehicle traveling on a road going up an incline versus
there is
the
no
location
way
data being incorrect
an
and
Apple
the person
device
being walking up physical stairs.
in 2022 registers driving up a hill as walking up a flight of stairs. There's no fucking world in which that's true.
So I'll address the idea of 3 clocks.
You know why?
which
Because you're
I
going
believe
like
was brought
30
up,
miles an hour, and
previously.
people
Let
don't
me
go up the
interrupt.
fucking
Sorry.
stairs at 30 miles an hour.
Why don't we just
The
explain to the
phone's not
jury
that stupid.
how clocks work in an iPhone?
They haven't done that.
Uh,
I mean, maybe the first.
that is kind of covered in the next
Fitbit
slide anyway.
odometers, like
Okay.
Maybe worth
would do
just
stuff
jumping
like
ahead to
that.
that slide.
Explain the idea of 3 clocks.
Yes. Essentially, there is one clock on an iPhone. It's the clock that you see. It's shown in the top corner, and all activity is related to that particular time. So when you receive a text message, the time that's shown in the database is related to the time that you can see on the phone. When you do health activity, it's related to the time that you see in the top corner of the phone. Everything is related to that time. The difference is within the current PowerLog databases. It's a subset of files stored on iOS devices. They use what's called a monotonic clock, but it's not a clock that can actually be trusted to see when events occurred. It's the way that the device records time. It's essentially a counter that's just counting seconds since the device was reset, basically. And I'm sure most people can recall a time where you would set a clock on a digital device, come back to it 3 or 4 months later, and the clock's now not quite as accurate as it was when you left it. Time starts to drift. It might drift forward and be faster. It might drift slower and be further behind. That essentially happens with the monotonic clock as well. So you have to take the values that the monotonic clock provides and add or subtract different values, which are essentially offsets, in order to get the accurate time. And that's what I'll be displaying in this slide here. The confusion with the idea of 3 clocks, I believe, comes from the way that Magnet Axiom product displays PowerLog data. They show a monotonic date and time, a baseband date and time, and a display date and time within the PowerLog records. As an examiner, it's really good to see this data and understand how the tool is determining these values.
The only tool
As an
determining
examiner, it
values
would be
is you,
really
buddy.
bad to look at these values and think that they are accurate timestamps at face value, because they aren't. And I'll start to talk
Hey guys,
through
did you know the
how
government will
this
send people
information
up on the stand to just
works.
lie?
So the other thing that
There's
Axiom
nothing you can do
shows,
about it,
as well
but
as the monotonic
discredit them,
baseband and
but only
display
if you
times,
can
is they show the location
convince the jury
where
that
this
the expert's
information
wrong.
came from. In this case, we have 2 tables. One is called PL Springboard Agent Event Forward S Block. And that is what this table is here. And you can see we've got an ID number.
Guys, he did a
timestamp,
3-week course.
and a
He knows
value
how
of locked.
iPhones work.
But we also show a second table
He did a
that's involved
3-week
called PL Storage
course
Operator Event Forward Time Offset.
Years ago,
And that's
before this version of the
table at the
iPhone
bottom
came
here.
out.
So again, we see there's an ID, a timestamp, baseband, kernel, and system values. These values all need to be read together in order to make sense of the data. So for example, if I take the timestamp that's shown here, the 1643 33687 number, if you treat that as number of seconds since the 1st of January 1970, it's what we call a Unix epoch. That will get you the timestamp of 29th of January 2022 at midnight, 21 minutes and 27 seconds, once you account for the UTC -5 offset. And you'll see that that is the same timestamp that Axiom shows here as the monotonic time, 12/21/27. What we need to then do is take that monotonic time and add it to the baseband value that we see in the time offset table. So now we have a value of 1643 3687.14954, and we add minus 183 point whatever this number is here to get this value. If we treat this value as number of seconds since the 1st of January 1970, then we get a time of 18 minutes and 23 seconds past midnight on January 29th, which is also the time that we show here as the baseband time. Finally, we can take the monotonic time and add the minus 181 seconds shown in the system, to get this value, which equates to 18 minutes and 25 seconds past midnight on the 29th of January, which is the same as the display time up here. So all this is essentially doing is saying that the counter that is built into the iPhone is registered the time of that we see in the top, the monotonic time. This is not necessarily the time that the event happened. You have to offset it with this value here in order to get the actual time that this happened. My own personal phone, when I was doing this testing, the time difference between the monotonic time and when something actually happened was over 2 weeks. There was a massive difference because my phone has been drifting so far since I originally bought and set up that phone. And again, when I was testing this, I can turn the flashlight on, turn the flashlight off. Both of those activities are recorded in the PowerLog database. If I just look at the monotonic time, it's off by over 2 weeks. If I do this process to calculate the correct offset, it shows exactly when I turned that flashlight on and when I turned that flashlight off. The calculation is imperative. Without the calculation, these timestamps are irrelevant.
This guy is why Scotland wanted independence.
And all Axiom is doing here is they're showing you the values that they use in order to calculate the final value. It doesn't mean that you can take the monotonic timestamp and read anything into it. It's completely irrelevant on its own.
Is it necessary to understand this process in order to ensure the integrity of the time that you're offering to the jury so you understand whether it's accurate or not?
It would be if we were discussing PowerLog data. PowerLog data only really encompasses things like battery level, the time and date that it's plugged in, button presses, camera usage, things like that. It doesn't count for location data. It doesn't count for Apple Health data. They both work on the system time. They both work on the same system time. So they're always going to be aligned.
Do you have an opinion to a reasonable degree of scientific certainty as to the accuracy of the location data times and the accuracy of the health data times that you shared with us?
They'd be consistent with each other.
I love that the experts get to determine that they have a reasonable degree of scientific certainty.
To summarize that, there's only really
neutral.
one clock that's in use on an iPhone for recording. The only difference is
literally
the monotonic time, which is how PowerLogs record information.
Forensic analyst for a company that caters to the state
to figure out
as
when
a client.
that activity actually happened.
They're not neutral.
And that you only have to offset those times for PowerLog data, not for health, not for location, not for messages or photographs or any other activity like that, purely PowerLog data.
Okay. Is there another subject that you looked at, that you analyzed in order to reach a conclusion about the time and location of John O'Keefe's cell phone over the night of January 29, 2022?
Yes, the next one is battery temperature.
Can you explain a little bit?
Explain me a battery's temperature.
Yes. So again, we have a temperature sensor built in within the phone, monitoring for if the battery temperature increases too high and becomes a danger, or if the temperature gets too low and becomes an issue. So it constantly monitors the temperature of the battery and records that information in the Knowledge C database.
Did you look into the battery temperatures from before midnight and after midnight and do an analysis regarding the temperatures of that cell phone battery?
I did, yes.
After midnight.
Throughout the evening of the
battery heats
28th of
up.
January and then the morning of the 29th.
Mr. Whiffen, that's going to be hard to read. Is there any way you can enlarge it?
Apparently not like that.
They have pills for that, my friend.
There we go.
Thank you.
Mr. Whiffen, you're so good at enlarging things for me.
So on the evening of the 28th, see an average temperature
Niels,
of
you ain't lying.
around
He is into
mid-80 degree Fahrenheit. I've got no understanding of where the device was at this time, whether it was in a pocket on a surface, whether it was in use or not. But I just wanted to get an average idea of temperatures of the device. By 13 minutes after midnight, we're still at 82 Fahrenheit. At 22 minutes after midnight, we know from the location data that the device was currently in a car, and we see the temperature has dropped to 77 Fahrenheit. By 37 minutes after midnight, we now know the device is already at Fairview. It's been at Fairview for approximately 12 minutes. And the temperature has continued to drop. It's now 72 Fahrenheit.
Mr. Whiffen, if I can interrupt you.
You didn't interrupt
At
him. He had stopped talking.
12:37, when the temperature drops to 72 degrees, is that before or after the healthcare data stops for that evening?
That's after.
Thank you.
45 minutes past, the temperature's dropped to 66 Fahrenheit. 53 minutes past, it's dropped to 61 Fahrenheit. 7 minutes after 1, it's dropped to 55 Fahrenheit. 1:36, it's dropped to 50. And then we have a large gap in the data, with the next record being made at 6 minutes after 6 a.m., when the temperature is 43 Fahrenheit.
Mr. Whiffen,
Come
if
on, ask the
a
question.
phone has any protection or coverage, well, let me ask it this way. Do you know what, if anything, happened around 6:02, 6:03 to trigger that 6-degree drop in temperature?
I don't know accurately, no.
You don't know
And
at
then
all.
you're
Not
now
just
at
not
6:14,
accurately. You
and it's
can't
37
possibly
degrees?
know.
Yeah, you're correct. This
You
is the
know-
coldest temperature recorded.
Do you know what, if anything, happened to that phone at 6:15:01?
I don't know.
Okay, please continue.
And then as of that point in time, from 6:35, we start to see an increase in temperature to 43 Fahrenheit. At 6:40, it's up to 50 Fahrenheit. At 6:48, up to 55 Fahrenheit. And at 6:56, up to 61 Fahrenheit. And then also plotted this out onto a graph just for visualization. Again, we can see on the evening of the 28th, the temperature is relatively consistent. It starts to drop as we know the phone is traveling in a car. And by the time it arrives at Fairview, we only see it drop until 1:36 a.m. We see a relatively modest drop over the next few hours, but no records recorded. We see the final drop at 6:14, and then we see an increase. But there are no increases occur prior to 6:14 that would suggest that the phone went from a cold environment to a warm environment or had extensive usage.
Between 1:36 a.m. and 6:06 a.m., is there any indication at any time that battery temperature
Asgard, when the other
went up?
stream ended, and I switched,
No, there's no
this one doesn't
records
have
related to
closed
battery
caption.
temperature
Try
at
and
all
switch
for
back
that
at the
time.
next break.
Thank you. Is there another area that you looked at for your conclusions in this case?
Yes, I was looking at device usage.
What is device usage?
Information about when the user unlocks the phone, what applications they're using, what they're using the device for, and when they lock the phone again.
Would device usage require an actual person to interact with the phone, or can it happen without user interaction?
Everything that I was looking at was related to physical interaction and manipulation of the device by a user.
Please continue.
So the three sources of data that I used for this were Knowledge C, a database I mentioned earlier that logs lots of different activity, including device unlocks, device locks, applications that are on screen. The Current Power Log, which I mentioned, which can track button presses. So specifically when the lock button is pressed and the times that I display have been offset appropriately. And Unified Logs, which is essentially a list of almost everything that's happening on that phone for a short amount of time. But it would be used, for example, if you had a problem with your device, took it back to Apple because it was crashing all the time, for let's say, they could look at the unified logs and figure out, well, what's causing these crashes to occur.
And it's probably
so
intentional.
Really granular.
We got to get really
we see that
granular.
At 12 minutes and 52 seconds after
The
midnight,
critical part
the device
is just
is
getting
unlocked
this stuff on the
using
record.
biometric Face
We're at
ID.
a closing argument.
The
which is
SMS
6 weeks
application
away.
is on screen for about 5
6
seconds
weeks
before it's
from now,
closed.
the jury doesn't
And
care
then the
what he
user
said.
presses the
Just
lock
want an
button at
impression.
the side of the device to lock the phone.
that statement didn't
13
happen.
minutes and 54 seconds.
They want to be able to
biometric
say
Face
that
ID
she
is
didn't
used again,
search for it.
and the SMS
in
application
closed.
is opened.
And that's they're going to
And
introduce.
at 14 minutes and
the ability
29
to do
seconds, the
that.
lock button is pressed again, causing the device to lock. 15 minutes and 46 seconds, the device is unlocked using Face ID. The SMS application is already on screen because that's the application that was on screen when the device was locked. And the device is locked again at 16:03. At 17 minutes and 59 seconds, the device is unlocked again using Face ID. The SMS application is still on screen from before. And at 18 minutes and 12 seconds, the lock button is pressed, causing the device to lock. At 18 minutes and 25 seconds, the device is unlocked using Face ID. The SMS application is already on screen from the previous usage. And at 18:31, the SMS application is closed. At 18:34, the phone application is opened by the user actively pressing on the phone icon on the home screen. At 18:36, they're now in a call, and this causes a different screen on the phone. And at 19:23, that phone call ends. At 19:29, the Waze application is opened by the user pressing on the icon on the home screen. And that's open for approximately 5 minutes, closing at 24 minutes and 26 seconds. 2 seconds later, at 24 minutes and 28 seconds, the device is locked by the user pressing the lock button on the side of the phone. At 24 minutes and 59 seconds, the device is unlocked using Face ID. The SMS application is opened using the icon on the home screen. And at 25 minutes and 9 seconds, the lock button is pressed by the user to lock the device. At 27 minutes and 45 seconds, the device is unlocked using Face ID. The SMS application is already on screen. And at 27 minutes and 50 seconds, the device is locked using the lock button. 29 minutes and 52 seconds, device is unlocked using Face ID. SMS application is already on screen from the previous usage. And at 29 minutes and 53 seconds, the lock button is pressed to lock the device. 32 minutes and 4 seconds, the device is unlocked using Face ID. SMS application is already on screen from the previous use. And at 32 minutes and 9 seconds, the lock button is pressed by the user. And that is the final interaction with the device. It's the final unlock of the device using Face ID. And it's the final logged button press on the device as well to lock the device.
So the final interaction with John O'Keefe's cell phone that night?
Correct, up until 6:15 a.m.
And 12:32:09 was the last time before the phone moved again the next morning?
Correct.
Is there one more area that you engaged in analyzing to help reach your conclusions in this case?
There is. During my time looking at the unified logs that were mentioned, I found a record that appeared like it could be interesting that was called Doppler. This was the pocket state that I think I mentioned earlier, and it detects when the user takes the phone out of a pocket, or at least removes the item that's blocking the camera. There were hundreds of thousands of records within the unified logs that I was able to filter down to just the Doppler records and to filter and aggregate down into a more digestible number, which is what's shown here. So again, whenever the device receives a phone call, or whenever the device is picked up in a particular way, the camera activates and it actively looks for a face. If it finds that the camera is blocked, it records the fact that it's in a pocket state. And it will continue to record pocket state until either the obstruction is removed, so the device has been removed from a pocket, or until whatever is calling for the Doppler check to be completed. So, for example, if I make a phone call, it will continue to check and look for a face up until the phone call ends, or the ringing ends. So in this case, at 12 minutes and 37 seconds, see a small amount of time where 4 Doppler checks were conducted. And that ended at 12 minutes 37 seconds with a pocket state cleared event. At 12 minutes and 39 seconds, there was a 7.5 second period where 108 Doppler checks were conducted. Again, that ended with a pocket state cleared event at 12 minutes and 46 seconds. At 25 minutes and 8 seconds, there was a single Doppler check that resulted in a pocket state. And at 29 minutes and 37 seconds, for 5.5 seconds roughly, there were 97 Doppler checks. The 97th check resulted in a pocket state cleared event at 29 minutes and 42 seconds. At 31 minutes and 52 seconds past midnight, there was an 11-second period where 155 Doppler checks were made. The 155th Doppler check resulted in a pocket cleared event at 32 minutes and 3 seconds. At 33 minutes and 14 seconds was the start of a 5-hour and 20-minute period where 26,500 Doppler checks were conducted. Every one of those checks came back to say that it was in a pocket state. There was never a pocket state cleared event during that time. At 2 minutes after 6 a.m. And 41 seconds, there was a 12-minute period and 20 seconds where 417 Doppler checks were conducted. The 417th Doppler check showed a pocket state cleared event at 6:15:01.
Mr. Whiffen, as a result of your analysis of John O'Keefe's cell phone, considering the location data, including Waze data, and considering the healthcare data, the pocket state information, the battery temperature, did you have an opportunity to create a timeline putting all of these different important pieces of data together so you could show them to the jury in chronological order?
I did, yes.
Would you share with us now your timeline and explain it for us?
Of course. So again, this combines all of the information from the previous slides, just showing it all within a timelined view. So at 18 minutes and 25 seconds, the device is unlocked using Face ID. We see the SMS application is in use.
Forensic data
for
testimony
around
is
11
so
seconds.
hard to
A
follow.
phone call is made.
It's all about
from John to
what they can
Jennifer
get on the
McCabe.
record, though.
Phone
so they
call
can
lasts
bring
36
that
seconds,
closing
starting
argument.
at 18 minutes and 47 seconds. That call ends at 19 minutes and 23 seconds, and the mobile phone application is closed at 19 minutes and 24 seconds. At 19 minutes and 29 seconds, the Waze application is loaded on screen. And at 20 minutes and 49 seconds, which is what this location on the side relates to, we see an incoming message from Brian Higgins saying, "You coming here?" At 22 minutes and 14 seconds, this is the start of the 3 flight climb events as the device is driving along Oakdale Road, I believe that one is. At 24 minutes and 26 seconds is when the Waze application is closed and the device is locked via the lock button at 24 minutes and 28 seconds. At 24 minutes and 37 seconds, the three flight climb events comes to an end. And at 24 minutes and 38 seconds is the first record that shows a speed of 0 meters per second. At 24 minutes and 59 seconds, the device is unlocked using Face ID, and the message, "You coming here," is read at 25 minutes and 8 seconds after midnight. At 25 minutes and 9 seconds after midnight, the device is locked using the lock button. At 27 minutes and 33 seconds after midnight, a text message is received from Jen McCabe saying, "Here." At 27 minutes and 45 seconds after midnight, the device is unlocked using Face ID, and the "Here" message that was just received is read at 27 minutes and 48 seconds. At 27 minutes and 50 seconds, the lock button is pressed by the user, causing the device to lock. At 29 minutes and 37 seconds, we start to get some Doppler checks, and at 29 minutes and 42 seconds, the pocket state cleared event is written. At 29 minutes and 44 seconds, there's an incoming call from Jen McCabe. This is answered and lasts for 7 seconds, ending at 29 minutes and 51 seconds. At 29 minutes and 52 seconds, the device is unlocked, and a second later, the lock button is pressed, causing the device to lock again. 31 minutes and 47 seconds after midnight, a message is received again from Jennifer McCabe saying, "Pull behind me." And at 31 minutes and 52 seconds, the Doppler check records a pocket state.
So the reason they want to get the
31 minutes and 56 seconds
to establish
start the health event that
the
shows
phone was
36
outside and all that
steps were
stuff, and
taken.
that the health events stop.
And at 32 minutes
is
and
they
3 seconds,
do not
there's
want
a pocket state
people to
cleared
realize he
event.
went inside the house.
At 32 minutes and 4 seconds, the device unlocks with Face ID. And again, I'll point out that makes perfect sense if the Doppler state clears because it's no longer within a pocket, and then it unlocks a second later. That makes sense with the logic that's been identified. At 32 minutes and 5 seconds, messages applications on screen, and the message "pull behind me" is read. 32 minutes and 9 seconds, the messages application is closed, and the device is locked for the last time. At 32 minutes and 16 seconds, the 36-step health event is ending. At 33 minutes and 14 seconds, we have the first of the 26,500 Doppler state records that all record pocket state. This is followed by several phone calls at 33 minutes and 35 seconds, 34 minutes and 9 seconds, 34 minutes and 38 seconds, 35 minutes and 9 seconds, 35 minutes and 35 seconds, and 36 minutes and 9 seconds. All calls from Karen. Call were all unanswered, and all resulted in pocket state being detected by Doppler. At 36 minutes and 9 seconds, and again at 36 minutes and 40 seconds, 2 more phone calls received from Karen, again showing unanswered calls and resulting in pocket state being recorded by Doppler function.
Sometimes I
37 minutes past midnight, battery temperature has dropped to 72 Fahrenheit. And at 37 minutes and 8 seconds, a further phone call, again unanswered, again resulting in a pocket state recorded by Doppler.
Sorry, forgot it was on.
37 minutes and 31 seconds, a 3-second voicemail received from Karen. And at 38 minutes and 21 seconds, another incoming call. And at 38 minutes and 26 seconds, another incoming call, both unanswered, both resulting in Doppler pocket state being detected by Doppler.
CW's
and I've also
Commonwealth.
showed some of the locations that were recorded at around this time by the device. 40 minutes and 31 seconds, a message received from Jennifer McCabe saying, "Hello, this is the first iMessage or SMS message received by the device, which is unread." This is followed up 2 minutes later, 42 minutes and 9 seconds, by another message from Jennifer McCabe saying, "Where are you?"
Non-naming testimony, I think.
And at 42 minutes and
The real
35
trick will be,
seconds, there's
can,
a 40-second voicemail received from Karen.
Can Alessi hammer home to the
43
jury that
minutes
this guy's
past
just spouting
midnight,
off
the
BS?
battery temperature has now dropped to 66 degrees Fahrenheit. At 45 minutes and 53 seconds, another incoming message from Jennifer McCabe saying hello. And again, we can see location data at 53 minutes and 7 seconds, placing the device on the front yard somewhere, kind of around the
Fletcher boy, everybody but
the
I can
flagpole
drink
area.
tequila during this boring testimony.
55 minutes and
I
31
wouldn't drink
seconds,
tequila anyway.
a message received from Karen
Hate it.
stating, "I'm going home." 55 minutes and 50 seconds, a follow-up message saying, "See you later." Another location data, this is the location that's shown bottom left. And at 2 minutes past 1 a.m., another message from Karen saying, "Your kids are cooking alone."
Way different context if that was from the witch and Hansel and Gretel.
Mr. Whiffen, based on your analysis of John O'Keefe's cell phone, keeping in mind some of the data points you shared with us, that wave was initiated around 12:19, that the car reached the flagpole around 12:24:37, that the only health data during that later time near 12:30 was from 12:31:56 to 12:32:16, that the last interaction was at 12:32:09, followed by an overnight pocket state, and an increased reduction
Objection, Your Honor.
So I need to hear the question first.
including a increased reduction in the battery temperature. Do you have an opinion to a reasonable degree of scientific certainty that after that phone stopped in the car at the flagpole area of 34 Fairview, whether or not that cell phone remained near the flagpole the entire night until after 6 a.m. the next morning?
Objection, Your Honor.
I'm going to allow it.
The location data that shows accurate tends to show around the flagpole area. There's no further health data other than 36 steps that were taken that suggest that it moved after 32 minutes and 16 seconds after midnight. The battery temperature data never indicates that the device went from a cold environment to a warm environment, which I would expect to see if the device went inside a building. And the Doppler state information suggests that the camera was blocked for at least the majority of the 5-hour period, with no records showing
Hear
that
me
the
out.
camera was
He goes in,
unblocked during that
dies,
time,
and gets
which
put
would
outside.
typically happen if you were to pick a camera up and move it around.
Does that lead you to a conclusion to a reasonable degree of scientific certainty?
Yes.
Whether that phone remained in the
Or the
flagpole
phone
area
fell out of
from
his pocket
around
outside.
24, 33
So
until the next
There's an
morning at 6
objection.
a.m. or after.
That's
the
my
objection's sustained. Ask the question in a different form.
Why'd you let him finish
Do you have
asking
an
the question?
opinion where John O'Keefe's cell phone was from around 12:24:33 on the evening of January 29, 2022 through at least 6 a.m. and after that morning?
Yes, based on the totality of all of the information that we've described, my opinion is that the device never moved far away from the flagpole.
I have no further questions. Thank you.
All right. Mr. Leslie?
May we approach Your Honor, please?
Okay.
All right. So
Sure,
we're going to have
feel free to stand
Alessi on cross here. He's there to take care of experts. Let me hit these real quick. We've got one moment. Precision is the number of steps ever exact. Where is the device? A pocket, jacket, or carried or dragged will offset data. Distance and speed can compensate, but it's not exact. Yeah, no. These location data is not precise. It doesn't need to be perfect. Here we go. Hold on.
The reason Kurt hates Megan Fox is because she is charming and aged gracefully. I have negative 1 billion charm and look like an overripe plum.
I just look like a plum.
That face picture, Ryan, you bastard. The infinity collar. His collared shirt has a gorget on it. Oh my God.
Binger. I don't drink beer. I drink malt liqueur.
Liqueur. I drink malt liqueur.
If I may have a moment, please.
Okay.
I will never get over. Like, I feel bad for how Sean looked at that picture.
Mr. Whiffen, I should have told you you can feel free to stand up and stretch if you want to as well.
He looked like a villain from Lord of the Rings. Let's see. Bulge deep in vagina says, old Nick Gers to see you. Gers, good to see you. Old Nick Gers, good to see ya. There we go. Bulge deep just sounds very Indian to me. Nicholas Zernal, is Joe going to join at some point today? Joe's always welcome. I haven't talked to him today. Oscott says, I need a summary. I'm lost. Unless he's going to clear it up for us. Oh, he just ate some certs or sucrets or something. This guy's toast. Blue Varo says, I would love from someone to Apple to come in and testify. Debbie says, aloha, Nick. Hey, aloha, Debbie. Glad to see you doing a trial again. Keep at it. Stay consistent. Your viewer numbers will return. You're the best to watch a trial with. Thank you. Thank you. Yeah, I figure people will figure out I'm streaming at some point.
Thank you, Your Honor. May I proceed with the administrative matters?
3150 right
May I
now
approach?
between YouTube and Rumble. I'm not disappointed in that.
Your Honor,
I'm very
pursuant
happy
to
to
a
have anybody
stipulation
watching.
with the prosecution,
been a
I
minute.
would like to mark and enter into evidence 3 documents. These are each portions of a March 2025 report prepared by Mr. Whiffen. The first one.
So, yes, they can come into evidence. They can come into evidence. There's a stipulation. So
And
we
so-
can mark it as the next exhibit.
Mark it.
If we can, that's page 29 for the next exhibit. Separately, please. The next exhibit will be pages 77 and 78 of the same report.
Okay.
Exhibit 41.
The third and last is page 43 and page 44.
Exhibit 42.
Okay, all set.
Thank you, Your Honor. May I, Your Honor?
Yes, please.
Ellie Van, there wasn't any numbers or math involved.
Good afternoon, Mr. Whiffen. I don't
Timestamp.
believe we've had the pleasure of meeting.
Uh-oh.
Good afternoon.
Uh-oh.
Cell phone data,
get worried,
when correct and when correctly analyzed, can help tell a story of what may have happened under various circumstances, correct?
Correct.
And in cases like this, literally seconds on cell phone data can be significant, correct?
Correct.
What I'd like to do is to go back to your PowerPoint presentation.
What I'd like to
and
do is
specifically
destroy your
go
testimony.
to the timeline that you had gone through with Mr. Brennan, and rather than repeating everything, there'll be select aspects of the timeline I'm going to reference. And with the court's permission,
Yeah,
we will
this guy went
put
full
the timeline
defensive
back
mode. He
on that's
turtled
already in
in.
evidence.
Okay.
Thank you.
His balls tucked up into his butthole.
So what I'd like to do is to start with page 70, which we have as 78 of the deck. If you could, Mr. Wolf, go to that. And what I'd like to do, if I could please, Mr. Whiffen, is draw your attention to the very last entry, which says at the bottom, location 122438, and it indicates description, first location record showing speed of 0. Do you see that, sir?
I do.
And this is the arrival of John O'Keefe's phone at 34 Fairview, correct?
Correct.
We could go to the next page, please. We have up at the top 122459, about 21 seconds later after arrival, we have device unlocked with Face ID, correct?
Correct.
Is it possible for anyone other than John to unlock that device with Face ID?
If a secondary user was set up.
Do you have any indication that a second user was set up on John's mobile phone?
I never looked at that.
I'm sorry.
I never looked to see if a secondary user
You didn't
was
even
was set
look?
up.
You didn't
In
even
terms
check?
of the next
Why?
entry, 122508.
It's relevant.
It says, read message, you coming here? With 3 question marks. What I'd like to do, because you did not note who that was from, but I want to go back a few slides so we can identify who that message was from. We could go back to 76, please, Mr. Wolf.
Yes.
So in the last line there, message reading left to right 122049, it says message received from someone listed in context as Brian Higgins. Do you see that?
Correct.
So if we could go back to slide 80, excuse me, if we could go back to slide 79, that phone reading the message, you coming here, is reading the message from Brian Higgins, correct?
Correct.
But you didn't note that in the timeline that was from Brian Higgins, correct?
No, I was just highlighting the fact that a message was read and that the contents of the message were you coming here.
But you didn't note in this entry when it was read by John that message was from Brian Higgins, correct?
Correct.
Now, the next entry, lock, again, I'm always going to be reading left to right unless otherwise indicated, sir, is a time of 12:25:09. And it says device locked with lock button.
Yes.
You see that, sir?
I do.
That requires human volitional conduct. In other words, someone has to actually manipulate their phone and hit it, right?
Correct.
Now, at this particular point, isn't it correct that in your report that you mentioned in your March 2025 report, that you had more of a description of what was happening at this time with the phone, namely, device bearing shifts to a westerly direction as location records also show the device moving west from the roadside towards the house. Isn't that what you had in your report?
Yes, that's covered in the location section of this report, the PowerPoint.
So there is no statement in this timeline under any type where you had concluded that at this time the record showed that the device was moving west from the roadside towards the house, correct?
The location latitude, longitude was moving westerly, but at the same time, the accuracy was increasing. So it didn't intrinsically prove that the device was moving.
My question, Mr. Whiffen, is straightforward in this sense, that I'm just looking for an answer of whether on this timeline you included the analysis that you had in your report that the device at this time was moving west from the roadside towards the house. Did you include it in that timeline?
No, I left that out of the timeline.
Next entry, 2733. That's 12/27/33. You note that there's a message received from Jen McCabe. Here, exclamation point, question mark. You see that, sir?
Correct.
Now, at this point, you have two people in just 2.5 minutes Brian Higgins and Jen McCabe trying to find out if the John is coming to 34 Fairview. Is that a fair conclusion?
It appears so.
I'll allow it.
Is that a fair conclusion?
It would appear so, yes.
So just because of the colloquy that occurred, I want to repeat the question. Now you have, at this point, at 12:27:33, you have two people, Brian Higgins and Jennifer McCabe, in just 2.5 minutes, trying to find out if John or the phone is coming to or if John is coming to 34 Fairview.
Objection.
Sustained. Ask it differently,
I
Mr.
thank you,
Lesser.
Your Honor. Now, at this point, you have two people trying to find out if John is coming to 34 Fairview, correct?
Objection.
Sustained.
Mr. Whiffen, in terms of the information at this stage, there are two communications with Mr. O'Keefe on this phone, and that is they're trying to find out, I'll rephrase it. There are two communications, one from Jennifer McCabe and one from Brian Higgins, correct?
Correct.
Now let's go to the next deck 80, please, Mr. Wolk. This is 12:27:45. Device unlock with Face ID, correct?
Correct.
And then right under that is 12:27:48. It says read message, which it says here. And is it correct that that is the message that was sent by Jennifer McCabe?
Correct. I'd just like to point out it says read message, not read message.
Read message, thank you. And
But
that
technically says both at the same time.
the fact that Jen McCabe sent that message and that it was read was not indicated in your timeline at this point, correct?
Sorry, repeat that question.
Yes, you did not, it does not appear in that timeline that you've drafted that message that was read was from Jennifer McCabe, is
Correct.
it?
Correct.
Next entry, 2750, device locked with lock button. Next entry down that, 2937, Doppler pocket state. And I want to be clear. Does Doppler pocket state mean that someone takes an iPhone? Because up above, there's read messages we went through on 2748. So if somebody reads the message and then it goes at 2937 into Doppler pocket state, does that mean someone has, for example, put it in their pocket?
No.
What does it mean that it's a pocket state?
So the only times that I was able to cause a pocket state to be recorded is when the camera was blocked and when the device received a phone call or was picked up in a particular
Where'd you shove that to test it
way
out?
so that the device thinks that you're about to try to use it. If the camera is not blocked from the outset, then nothing's recorded at all. And in order to get the pocket state cleared, the camera must be blocked to begin with. So again, you have to receive a phone call with it in your pocket and remove it in order to get a pocket state cleared.
Thank you, because that helped me, because that's exactly where I was going with the next question, which is pocket state cleared. What did you conclude from 2937 to 2942 that it was in pocket state and then pocket state cleared?
There was some activity on the device that caused the pocket state to be checked. The device was in a pocket state up until 2942 when whatever was obstructing the camera was removed.
Next entry is a call at 12:29:44. And that, you state, is an incoming call from Jen McCabe. So there you do indicate the name. And you say answered 7 seconds, correct?
Correct.
Is the phone at this time that there's an incoming call from Jen McCabe that is answered out in front of 34 Fairview?
Yes, it would be according to the location data.
Right.
Jenny G,
So,
correct. Setting your phone on a seat could cause
Now
a
we
pocket
have
state.
at
Or on a counter, table,
12:29:44.
anything
The
where
phone's
the
out in front of 34 Fairview.
camera is blocked from
There's an incoming call
being
from
able to
Jen
see a face.
McCabe. It's answered. 7 seconds is how long the duration of the call was. Is that correct?
Correct.
And then 12:29:51, incoming call ends, and that's end of that 7-second duration.
Correct.
So you've concluded that this was a call that was indeed answered by the user of the phone, correct?
Correct.
Now let's go to Mr. Wolk 81, which is starting up at the top of 12:31:47. There is, as you indicate, an iMessage received from someone with a contact named Jen McCabe. You see that, sir?
I do.
Can you just state for the jury what an iMessage is?
An iMessage is essentially a text message sent primarily from iPhone to iPhone via the Apple servers, not like an SMS message which goes through carriers.
And is it correct that the message that was received from Jen McCabe said, from a contact, Jen McCabe says, "Pull behind me"?
Correct.
I don't think this guy has ever
And
not
then at
yelled in his entire life.
12:31:52, we're back to Doppler pocket state, correct?
Correct.
Now let's go to the next entry, which is Deck 82. It's under health type. And what I want to do is see if we can clarify. The Commonwealth on direct examination, and multiple times referred to this as healthcare data. Do you remember hearing that healthcare data term?
I do.
Is that a correct term? Is it healthcare data or is it health data?
It is health data.
So it's incorrect to refer to this as healthcare data, correct?
Healthcare data is encompassed within Apple Health, but primarily if we're talking about steps being taken, it would just be health data.
Right. So the correct parlance is health data,
Yes.
correct? Particularly when we're getting to steps. Is that correct?
Correct.
It's important to be precise about the parlance.
Yes.
So in this entry, 12:31:56, you state that there's the start of health event, quote, 36 steps / 25 meters, correct?
Correct.
Is it accurate to say that because we're in the United States and we don't work on the metric system, that 25 meters is about
Nobody
84
works on the
feet?
metric
Are you
system.
able to make that calculation?
It's approximately that, yeah.
Right. Would you accept approximately
That makes
84
sense.
feet? So as we discuss meters, we can go to feet and
Yes.
about 84.
I would accept it approximately 3 times 25.
Right.
But
So in your report of March 2025, isn't it correct that for this time, you stated that the device began moving for a period of 20 seconds, correct?
Yes.
So again, your conclusion from your analysis is with these 36 steps, the device at this point began moving. Correct?
Yes, correct.
Next entry. 12:32:03. Pocket state cleared. Correct?
Correct.
So does that mean that there's some human activity going on, interaction with the phone, or not?
It could have been a received phone call. It could have been movement of the phone to be lifted.
But something has happened.
But something's
correct?
happened, yeah.
Next, 12:32:04, device unlocked with Face ID, correct?
Correct.
And then at 12:32:05, it states application focused messages.
Yes.
Can you clarify what that means
Uh-oh.
in terms of what is happening with the phone for the jury?
Yep.
It's focusing
so at
on
32
messages.
32 minutes and 5 seconds, the messages application was in focus on screen. So it was the application that was being used by the user at that time.
Now, the next entry is message 123206, and it states red message, quote, pull behind me, close quote, correct?
Correct.
Now, you don't indicate who that message is from in your timeline, but that's the message that was sent by Jennifer McCabe at 12:31:47, correct?
Correct.
Next entry is application lock at 12:32:09, and you've got here end application focus, and then you state device lock with lock button for the last time, correct?
Correct.
So that's again pressing the side button on the iPhone that locks it.
Correct.
And that requires human conduct, human interaction with the phone, correct?
Correct.
And then the next entry under health data at 12:32:16, that is 7 seconds after the lock. It's the end of the health event of 36 steps, 25 meters, and as we agreed, approximately 84 feet, correct?
Correct.
So in terms of the steps, I want to turn to some further information with regard to your previous, the report that you mentioned on direct, which is the March 2025 report. Your Honor indicated a time for the break, and I'm going to go into a little bit of different area. Would you like me to keep
All
continuing?
right, Mr. Leslie. Folks, we'll stop.
We'll stop.
Turn on the lights, please.
We'll stop. All right, we're going to have a little break here.
Jurors, we're going to recess for the day. Please
For the day?
do not discuss this case with anyone. Don't do any independent research or investigation into the case. If you happen to see, hear, or read anything about the case, please disregard it and let us know. And please be very careful with your social media use. All right? We'll see you tomorrow morning.
Jury's out. I think we're going to have...
I'll see counsel at sidebar.
I think they're going to have voir dire the ARCA guy or whatever coming up. So that's a wrap for the jury. I seem to recall the judge saying that they were going to voir dire the ARCA guy, which means she's letting the jury go. Voir dire of the ARCA guy is going to take the rest of the day, but that can't happen in front of the jury, so no reason to keep them around. So that should be still fun for us to watch. I will still be here. I'm going to probably step away to the bathroom in just a second and grab a beverage because I drank my Gatorade. But I didn't drink enough Haterade. No, we'll do that and then come back. And then, I might actually like to go back to opening arguments, or I want to go back to that objection from a couple days ago that I've talked about a couple times because I want to watch it again. Now that I've said a whole bunch why I think it was a big miss by the defense, I want to go through it and watch it with you guys without Branca or I commenting over it and wondering what the hell was going on. So we'll probably do that. I don't know if we'll rewatch opening statements today or at some point in the future, but I'd kind of like to go do a pulse check on where the prosecution is on their opening statement. I said that my huge criticism of it was narratively it was garbage. But if their narrative is based heavily on the fact that they're going to say, well, she says she did it, and the forensic data is close enough. I mean, they are laying the case that happened. So that's, that should be good. Are they doing going to voir dire? I believe so. But they're probably going to have a lunch break first. So it's probably going to be about an hour. Yeah, you can barely hear the opening statement. We could go back and I can boost the volume on it too. So we've got some options on how to fill this next hour. And I think we'll have a good time. Hey, while we wait, so just a reminder, new super tip voices were added, and we'll have more of them coming as they're hilariously available. I would like an Alessi one because he just talks like he yells at everybody. I think he'd be a good one to have. I don't want to have infinity, right? Like you don't want every single character from the trial. Most of them aren't useful, but I mean, should probably do a Karen Reed voice. But here we go. Here, just a reminder of what we got. We added Sean in here.
I want to finish building my model submarine, but I keep eating the pieces.
So we've got, it's not a sandwich. You damn chonker. So it's Spectre says, seems like we're getting paperwork for court hearings for recording in the no First Amendment zone outside the courthouse. Ooh, that could be interesting. Can you do super tip on iPhone? Yes, you can. You can do super tips on on any device. It just goes through a browser. So we added Kurt, Nate, and Sean from LawTube. Maybe we'll add some other LawTubers at some point. Gross. We also added Ronnie O'Neill. I could maybe play one of these. Let me write up a Ronnie O'Neill clip here. Let's see. Let's see what we got. Let's see. I don't know how the Ronnie O'Neill voice works, but we'll give it a shot. We'll give it a shot here.
The evidence will show that LawTube is a bunch of silly bullshit.
Okay, that worked just fine. Oh my God. That one works. I did not know how that was going to turn out, because you don't know. You just upload a bunch of audio into the engine apparently, and the AI thing generates the voice. But that one, I mean, it nailed it. The evidence will show. Oh my God. Oh. Kermit or Jordan Peterson. See, does the same voice? Well, look, when you're on benzodiazepines, maybe you make some decisions that you wouldn't otherwise make. Young men are out there fighting for the freedom of their own societies, dying in droves on meme forums, sacrificing their very lives on Twitter, and no one's out here fighting for the men. So I'll be the woman to do it. Oh my gosh. So yeah, that's in there. Oh, wait, we got a couple super chats here. Should grab these. Jonah John. Brooks Houck case is a murder case starting trial on June 24th of 2025. I mentioned it Friday, but forgot to say it's a future case. All right. I'll have to, again, as it comes up, it's going to depend on time. You know, if this case is done, if there's another case starting, who knows? Nice podcast. Stupid says Massachusetts government, court, and state police equals corrupt. #free KR. Winton Dupree. I'm putting together a Judge Beverly Cannon ASMR compilation for anyone interested. I don't know, like we could get her voice in there. She just doesn't talk very much. Miku Huntu says using meters instead of feet, shady prosecutors. Johnny Rocket says, who would win in an eat-off? Sean or Vito? Prize is a little boy. Vito would be highly motivated in that one, I guess. I guess that's how that works. Oh my gosh. Angela says unbreaded man. We have him. Matthew Harris is in there. He's one of the voices that's available. So again, you can go to supertip.gg/RL and you can look at all the voices and you can actually, you can play samples of them. I don't think that you can you can't play a sample of your own. You can't hear how your own is going to sound until you buy it, but there are little sample things that you can click on to hear all the different voices and how they sound with a sentence that was pre-written by Ryan, I guess. Yeah, the Nate one needs work, Nardo, in my opinion. The Nate one needs a little bit more. I'm not hearing Nate come through it. What you got though, you got to be watching that Karen Reed trial. So, that'd be good. Let me pull this stream back up just in case it comes back on. I'll be right back. I'm going to grab a drink. You guys grab a drink and then we'll start in on going back to that argument. Cause I want to go back to that objection and argument over the video clips. And, I want to talk about why that was such a disaster, in my opinion, for the defense. But we've got plenty of coverage left for today. So don't hang up. Don't go anywhere. Just hang out for a minute and we'll be right back. Where is my window? Here it is. All right. See you guys in just a second. Okay, we're back. Sorry about that. All right. Got to get my headphones on. Okay, so while we wait, I am going to pull up another video here. Where are we? Here we go. So I think this was on what? Wednesday? This was on day 2, I believe, right? I didn't change my shirt this time. No, why was it? Was I supposed to? Let's see. Here we go. I think it was, so now I have to find the, I wonder the fucking timestamp. I just need to find wherever Alessi looks like he's screaming. Okay, there's Grandma. All right, I'm almost there. Okay, I think it's here. Sorry for the delay. We'll get this switched over. This should be it. Let's give it a shot. Let's give it a shot.
Okay.
17.
Okay, wait, I think this is
I don't know what they are.
Okay, so they're going to argue about what they are. So it's a bit too far. I think this is a better place to be.
Jury's action, please proceed.
All right, so I'll watch the first one, then I'll hear your argument, Mr. Brennan and Mr. Jackson. So, Ms. Gilman, if you'd play that first one, please.
They had pulled into the driveway before me, so I was presuming she saw my cracked taillight and was thinking, did you hit my son? I could sense from her that she was looking at me very warily, and then when John's nephew came.
Look at this guy's face. Where did they find this guy? Oh my gosh.
I just wanted to see him and squeeze him. It was quite uncomfortable. I said, Dad, come upstairs to the master bedroom. I said, I think I need to leave because I think John's mother thinks I did something to John.
All right,
that's so the first clip. Tell me why I should admit that clip.
You should admit this clip because it demonstrates consciousness of guilt.
Right at the gate. Right at the gate.
On the morning of John's death, Miss O'Keefe sees her son at the hospital and goes back to Mr. O'Keefe's home. In the driveway is the alleged murder weapon, the Lexus with the broken taillight. It's the middle of a snowstorm, and a prelude to that, is there is a phone call from the defendant's father to the Dighton police looking for a ride to go in and see his daughter at the Good Samaritan Hospital. He's looking for a police ride because the weather conditions are so terrible. When the Dighton Police Department declines that ride, he gets the assistance of his son and his son's wife pick him up and bring him to the hospital. At the hospital, there are a number of comments made. I think I hit something. There is evidence we have where the defendant, her mother, and her father admittedly discuss in different ways the broken taillight. It is an issue that is primary on their mind. In this tumultuous, grieving moment, the taillight is central between these parties. Uninvited, the defendant and her father go to the O'Keefe house without invitation. They knock on the door and they ask to come in.
Okay.
They go into the house. There does not seem to be any interaction, at least with Peggy O'Keefe. And curiously, they go upstairs for 15 minutes.
Ooh.
They stay at the house for less than an hour. This is a family that's grieving the loss of their son. Less than an hour, they go back outside. Instead of leaving in the one car, they take the alleged murder weapon, they get into two cars, and they drive away and remove the Lexus with the broken taillight from the scene. That is clear consciousness of guilt evidence.
How?
Removing the murder weapon from an area where witnesses can see, photograph, identify the damage. In fact, despite the other evidence about the cracked taillight in the testimony, it is a centrally contested issue in this case. The defense is already questioned and confronted, as they have a right to do, about the shape, manner, and extent of that broken taillight. The removal of it is helpful for the defendant.
How?
And so,
how is the removal helpful for the
fact
defendant?
that they stay for less than an hour, remove the Lexus from the scene, is important. This statement by the defendant is clearly an attempt to create an excuse, a ruse, for why they removed the murder weapon from the scene. It is an attempt to suggest that she somehow is targeted. She somehow on that morning is victimized. She somehow on that morning is the intent or the object of something that is abusive from Peggy O'Keefe. And so this evidence will demonstrate a key part of our consciousness of guilt evidence on this issue, that there was no viable reason to take that evidence from the scene.
It's a car.
Other than to obscure it.
What if she had to go
It was
anywhere?
not because Peggy O'Keefe yelled at her or intimidated her or threatened her. This was, again, a central conversation between her, her father, and her mother in those early morning hours. This is what was foremost in their mind. And so that's why it's not only relevant, it is an extraordinarily strong piece of the consciousness of guilt evidence. And inevitably, the defense may or may not try to provide some type of explanation or excuse, but we have a right to the full force of our proof, and this is part of it.
Thank you, Mr. Jeff.
Okay. It's right out the gate. See, this we had Joe on the other day. I love Joe very much, but I had a problem with his analysis here because his analysis focused on how prejudicial the video clips, well, the second video clip in particular, was because of how it makes Karen Read look, like how she actually looks. She's yelling at the camera. She's she's got a crazy eyes look on her face. The type of woman you don't text back, as Bronca might suggest. But no, she looks physically bad, and he believed that clip is prejudicial in that way. And maybe it is a little bit, but the far bigger risk is laid out right at the start. These clips show consciousness of guilt. They don't. To be exceedingly clear, these clips do not in any way show consciousness of guilt. Getting in your car and driving anywhere for any reason is not consciousness of guilt. If you want to have a consciousness of guilt argument, then you have to show that they went somewhere or they drove for a specific purpose because of their consciousness of guilt, that is the impetus for their driving. But in this case, all we have is an allegation that there was a conflict maybe between the victim's mother and Karen Read, some nasty exchange, and she wanted to leave the house. Okay. That doesn't mean she killed a man. It doesn't mean she killed a man with her car. It doesn't mean she's trying to cover up anything. And it's really not an effective cover up because, to my knowledge, like, the car doesn't vanish. She doesn't dispose of the evidence. It's not like a pair of scissors that got lost at the craft store or something. This is just someone driving their car, and without evidence tying that activity to the consciousness of guilt, you shouldn't have the argument. That's fine to say, but the defense doesn't say that at all. These clips are not about making Karen Read look bad. The prosecution has 3 weeks to make Karen Read look bad. They're going to bring in person after person. They'll play these. They've got other clips that make her look bad. She already looked crazy from her first interview clips. Anytime they put a clip up, she's going to look bad. They're not going to play a clip if she looks good. Simple rules. Very easy to follow. So they're going to play clips in which she looks bad. They don't need help from these 2 clips. What they needed was that legal argument that he just made. And as annoying as he is, and as good as Karen Read's defense team has been, he kicked their ass here because they didn't even see it coming. And he told them exactly what he was doing. It's not like he said he was doing one thing and then nefariously snuck it in. First thing, this is about consciousness of guilt. And then he lays out the argument. That argument is not objected to. He can say the same exact thing at closing arguments, and the jury isn't going to remember the clip. They're not going to be like, you know what, that clip, that's kind of, he's just going to tell them, we saw how Karen Read got into a car, effectively the murder weapon, and took it away from the scene so it couldn't be viewed. We saw that she did this because of her consciousness of guilt, because she felt guilty about her own actions, about what she'd done to John O'Keefe. And it's already been presented to the defense and the judge, and both of them allowed it. That's a huge miss. That's the prosecution's case isn't actually based on good forensics. We know this, right? And it's not based on witness testimony. We know this. No witnesses to the crime. There's forensic data that is disputable, but I guess conceivable, maybe. But their main argument and thrust is how guilty Karen Read looks and how guilty she describes herself. And they lock that down right here. And they get to say it on cross, and there's nothing the defense can do about that except counter it. Countering it brings more attention to this consciousness of guilt idea. Well, maybe, yeah, you know what? And she did say, I hit him. I remember that right at the beginning. Something about that she said she hit him. She's asking people about things. It's very confusing. She ran right to him. Their entire narrative, which they didn't lay out very well at opening, but is forming actually pretty well. I'm gonna say the state's actually doing okay in the narrative elements that they want to hit. Karen Read's admissions. Admissions go longer than data. Admissions go longer than witnesses. Admissions are poison to a criminal case. There's almost no way to get around them. You have to overcome the fact that someone says they did something wrong and acted like they did something wrong. Now, again, I don't think Karen Read acts like she does something wrong in those 2 clips, but the state gets to say she did. And the jury may not remember what clips they're talking about, and they're just going to generally go, yeah, she's acting like she's doing the wrong thing all the time. She even said she did it 3 times. I hit him. I don't know, man. That was sneaky. That was a. Let me say something very clearly here. I don't think anybody should go to prison for life because the state had good lawyering. I think they should go to prison for life if they're found guilty beyond a reasonable doubt based on the evidence, not procedural moves, not sneaking legal arguments into irrelevant video clips. But that's what they've done, and they're doing it effectively. And that's why they're doing it. Make no mistake. It's not to make Karen Read look bad. It's not for any of the other purpose. When the state tells you what they're doing, just listen. Because they have so many damn advantages that they can be honest. They don't have to have some like crazy tactical approach, like, oh, we're going to do this and wrangle this. Sometimes they can just go, here's what we're saying. Here's what we're doing. They have a feeling the judge is going to side with them on the objection. And then let's hear the objection, because it is more limp-wristed than I am.
Thank you, Honor.
With regard to the first clip, which is clip 4.
That's the only one we're discussing right now.
Then in that case, now that I look at it and I see the transcript, I'll withdraw an objection. I don't care. It's not, I don't,
It's
I don't
terrible.
agree with anything Mr. Brennan just said. It doesn't go to consciousness of guilt. As a matter of fact, I think it very clearly shows the opposite. But
Okay, so there's no objection. So there wasn't an objection until I said, is there any objection to this? And then you all.
So again, terrible art. He says, I have no problem with it. I don't care. He's like, I know he says consciousness of guilt, and I disagree. If you disagree that those show consciousness of guilt, object. Make the argument, make the judge rule on it. You've withdrawn the objection. You don't get to appeal this. And this is a critical element of the state's case. This is very frustrating to me because there's no reason for him to withdraw the objection. He should say that the state has made no tangible connection between this video and a consciousness of guilt. As Andrew Branca laid out on the show when we saw this live, consciousness of guilt requires that there be no other plausible, reasonable solution or cause for the action that takes place. She's not doing this because she's conscious of being of guilt. She's doing it for any other purpose in the world. It's an automobile. It's not something that needs to be secreted away. It's not something that doesn't have a legitimate, obvious purpose that is used all the time. You have the freedom to travel anywhere in this country within the bounds of property lines. You can just go. You don't have to have permission or a purpose. Your purpose could be, I want to drive. I need to clear my head. I want to drive. I want to clutter my head. I want to go to the store. I want to go to the movies. You could go anywhere and do anything. So to suggest that she would have some other purpose to move the car, use the car, drive the car, give the car to someone, anything like that, any other purpose than I want to, you got to sell me on it. And I don't see anywhere where there's some sort of indication that she did this because of guilt. He just says it because that's what they want to say later. And again, having the defense team just say, you know what, I don't care. Well, you just let it all in. You can argue with him at close, but you should have at least maintained the objection, objected to his characterization, his consciousness of guilt, and make the judge make a harder ruling on it than okay.
All came to sidebar. I mean, they were just going to play. So there's no objection to the first clip, right?
yes, correct.
Okay, so let's hear.
I made an objection to sidebar on the floor.
Okay, so Mr. Brennan, play the second one, please.
Yes.
And his mother leans over the kitchen island and says to me, I think he looks like he got hit by a car. He looks like he got hit by a car.
That voice is grating. I needed a second because that voice is grating. Listening to that would drive you insane.
Okay. So tell me how this comes in.
Similarly, consciousness of guilt evidence, the defendant making what we allege is a false statement to try to excuse her conduct of removing evidence of a crime from the scene. This has additional import. It has two facets to it. One, equally as important for consciousness of guilt in the first part, as I supported for clip number 4 or 5. Secondly, it is important because we've heard testimony from Peggy O'Keefe that this claim never happened. So we now have direct testimony that she did not have a conversation with the defendant, did not make these claims to the defendant. And so while also conscious of guilt evidence, it has additional support from the previous clip.
All right, Mr. Jackson.
Thank you. With this video clip, Your Honor, it's very different. It has absolutely nothing to do with consciousness of guilt. The argument is baffling. How could that possibly be consciousness of guilt if...
Think he realized it in real time there? Oops. Why did I let the first clip go? Don't know, man. This guy's a great lawyer by all measures that we've seen so far. His opening was solid. His cross-examination was precise and devastating to the witness's credibility. He's great. He's thorough. He's prepared. His courtroom presence is fantastic. He speaks clearly. He's understandable. I think he realized he missed it on that clip. He's now going after this clip. It doesn't matter. The consciousness of guilt thing's coming in either way, whether this clip gets in or not. But now he's like, wait, this doesn't show consciousness of guilt. Neither did the last one.
My client is simply reiterating something that she believes somebody else said. This clip is obviously, very obviously, and strategically being used to try to vilify my client with something that's completely irrelevant. In Massachusetts, you can't call a witness just for the purposes of impeaching them. What this clip would be doing is purporting to impeach Mrs. O'Keefe, who just testified. I never said that. I never said it. I never leaned over the island counter. Never happened. So bringing this in would be used to impeach their own witness. And that's what can't be done in Massachusetts. With regard to consciousness of guilt, how does my client reiterating or stating that something that the victim's mother may or may not have said, how does that relate to consciousness of guilt? It doesn't. This is simply a wolf in sheep's clothing. They're trying to get it in because it makes my client look bad. They've just put on a very, very sympathetic and empathetic witness, John O'Keefe's mother, and they're trying to make my client, Ms. Reed, look bad by saying something what they perceive to be pejorative in a tone that's pejorative about that very same witness. He's trying to, at this point, there is no issue about whether or not Peggy O'Keefe leaned over and said something about the car, being hit by the car. He's trying to create the issue so that he can put this video clip in. It has nothing to do with consciousness of guilt.
No, but he's created the issue to get the clip in for the purpose of introducing consciousness of guilt. That's...
It's not for impeachment of Peggy O'Keefe. We don't take the position that Peggy O'Keefe is lying. This is a statement of the defendant. It's in the form of an admission or a statement, which qualifies for admission substantively, not for impeachment purposes. The defendant should not be able to pick and choose which of her statements do not look good for her and do not look bad for her. She made the statements, they're relevant to this case. It's not unfairly prejudicial. It's a statement that they embraced and they chose and they publicized, and it goes directly to the issue of consciousness of guilt. just because it hurts, just because it's incriminating, just because it's difficult for the defense is not a basis to preclude it. It is an admission, a statement of the defendant. It's admitted substantively.
If that were true, Your Honor, then they would simply put in the transcript. They wouldn't need to play the video. Transcript.
I agree. They should put in or they could put in the transcript. That's what the judge should have ruled, because it serves the same purpose as the video does. Although I would argue, if I were the state, that Karen Read's demeanor in the video is critical to understanding the consciousness of guilt, because there's so little being said in the actual statements that are there. But the key part was getting the consciousness of guilt in at all. And they've got it. They've got it. This is, he tried to keep it out and got toasted on that one. The judge could have allowed it for other purposes than consciousness of guilt and limited that instruction, but she asks him if he wants that instruction in a minute, and he's going to say no.
It's one line. And his mother leans over the kitchen island and says to me, I think he looks like he got hit by a car. He looks like he got hit by a car. Sorry. I think he looks like he got hit by a car. It looks like he got hit by a car. They can just put that statement in. They want to play this because of its prejudice, because of the tone that it sets. It's not in evidence at this point. The witness who supposedly said the statement has denied having said it and said it never occurred. This is far, far more prejudicial than it is probative. If they want to simply use the transcript, that's one thing. But playing this video is simply being used to vilify my client because of the tone of voice she used in the clip. That's it. That's what's not allowed. That's overly prejudicial, and it's not relevant.
All right. So what I'm going to do is I'm going to think about this. And if I decided to let it in, you can let it in first thing tomorrow morning. I'm not going to let it in now.
May I ask for a ruling in the morning?
Yes.
May I introduce the one that was not objected to?
Yes. Do you want a consciousness of guilt instruction, Mr. Jackson?
No, we don't believe that
So you're in agreement that statement just comes in?
we're not objecting. I'm not trying to introduce it. Don't put words in my mouth. I'm not trying.
No,
to
I said you're okay.
But I'm not objecting that it at this point that it shouldn't come in.
Okay. We'll bring the jurors back and we'll do that. Tony, can they come right in, or is it going to be 5 minutes? Can they come right in? Thank you.
So there we go. We have this we have the judge being completely indecisive on an issue, although maybe the judge was giving them a split the baby style win because she doesn't allow it right now following the emotional testimony, because that does those clips were supposed to directly follow the testimony of the victim's mother. And, she got up there and cried a whole lot. The defense didn't ask her any questions, as is the proper strategic thing to do. But those clips coming in were slid in for the purposes of consciousness of guilt. The state is very honest about it, and they should be taken at their word on this one, because that is the damaging aspect of them. Karen Read already looks bad in her interviews and in any video clips that they play. She looks crazy. That's not a knock on her. Her life is in jeopardy at this point. The entire police and legal community feels against her. She's facing down a prison sentence that will, be horrifying to serve, will completely destroy her life. Her life is already in shambles from what's been going on. Her looking crazy is expected in any of those interviews. She should not have been doing them, but I get it. Believe me, I get it. She spent a year basically before she had her first trial. She gets out of the first trial with a hung jury, which means she was not found guilty. Not found not guilty, but she was not found guilty. And so she's got a little bit of leeway. Now she's seen the state's case. She wants to talk. She definitely wants to talk about how much she didn't kill someone. And it must have been difficult for her to not do that anymore. So she gave some interviews. She doesn't look good in them. She looks wild-eyed. She looks like someone who is under intense stress and pressure, which she is. And that makes you look bad. It makes you look like a killer, which is not fair. It just is. So she shouldn't have done them. But the reason that those clips shouldn't be there isn't because of what she said. It's not because of how she looked. It's because of the legal argument that gets to come in at close and sounds really bad. Well, she moved the murder weapon from the scene because of her consciousness of guilt. She knew she did something wrong. She knew she did something bad. She couldn't stand it. She had to get in her car, drive it away. And they get to say that on close. That's devastating for the defense. Like I said, in my opinion, that is the main purpose that was brought in. But hey, I think it was, again, a big miss for them. So just to let you know, I do still have the courtroom pulled up. The courtroom camera is still going. So they didn't come out and make an announcement, but I'm going to assume that they're having a lunch break that'll go till about 1:30, and then we should get that arc of voir dire. But maybe they'll have it. Maybe it'll only go till 1 or something like that. What do we got down here?
Come on, you friggin' lollipop. You know Sean, Uncivil, and Nate are just jealous that they can't get your high-quality trolls.
I think that is another win for the toe.
I don't know. If you're asking a question, I'm not sure. I'm not sure what a win is anymore for the toe or otherwise. But no, look, I didn't think anyone was jealous of me in particular until they said so. And they said so when I was away. I wasn't in the place to really respond to what people were saying. I wasn't streaming. I had legal issues. Every time I opened my mouth, I'd get like 45 messages from people. You need to be quiet. You need to shut up. And then people would be like, you need to talk about your situation. It's like one or the other guys. Neither one really worked. It doesn't. It does matter. In my case, it didn't matter that much. There wasn't much to dispute. The only thing I had to do was not make admissions and not make any claims that I would later have to defend in court or would foreclose the ability to make a different claim or use an avenue of defense. And so I was able to navigate that pretty well from a legal standpoint. It became non-navigable from a personal standpoint. So which is why I didn't stream very much. Anytime I got to a place where I thought maybe I could, manage a stream and kind of get things back going, something would come up. It didn't work out. I think when you hit a bowl with a sledgehammer, it takes a while to pick up all the pieces and put them back together. And even when you glue it all down, like you may be missing some pieces. And so that you think the bowl is set and it's not. And so, that's mostly why I didn't stream. Let's go back to the opening statements. Let's go back. In case it wasn't clear that that would come in, that clip does get brought in the next day. So let's Karen Read, trial day 1. Here we go. Oh my God! Please stop doing that. That was horrid. Okay. Oh, it's regardless. I was not ready for the accents in this case. All right. So yet again, we have, we're revisiting these opening statements. I mean, I was here when they were going. I was a little bit out of sorts, out of focus. I was getting back into watching these DM trial streams, and it was in the morning. I was tired, all that stuff. So I want to go back, rewatch them. We've got time to get through at least a good portion of Hanks. And I want to see, we've seen a week now of the state's case. And that's why I want to start with that one rather than going to the defense's opening was better to me at opening. But a week in, the state is now making its case. I want to revisit it, right? And if you guys want to bear with me on that, that'll be fun. But hold on. We've got, Kimmy Joe says all of Spain and Portugal are without power and they don't know how long it will be out. Baby boomer time again. Oh, wait a minute. Oh, since all the lights are out in Spain and Portugal, everybody's going to be banging it out. That'll be great. James Gartner sent 5 gift memberships. Thank you so much. Love to see that. Shiloh W. Good morning, all. Got a story out of Buffalo. The school district is burying cases involving kidnapping and abuse of students. Angry cops dropped the story. Let me just, without knowing anything about that case, let me just say this. School districts are garbage. Government schools are terrible. Yes, your children are in danger in a government school. They are. I don't know why we do this as a society still. We used to look at government services as the low thing, the last ditch, the safety net, everything we did ourselves. In fact, schools were community efforts, not government efforts in a community, but community efforts themselves. The schoolhouse would be built. You'd have a teacher, someone from the community or someone that the community hires to teach the children through lots of grades until schools became bigger, because of, government bloat and the increase of the capacity to effectively educate and manage children for periods of time. And then, of course, with the shift towards industrialization and post-industrialization, you have classrooms becoming more important to teach, to provide non-trade related education and non-skills-based education. Now, I know we probably need a return to some skills-based education, but it became less necessary to have that. It became more necessary in society's greater opinion or whatever to start educating with almost like a liberal arts style high school education process that would then lead into liberal arts and sciences education that would follow for post-secondary education. All right. But we used to just do it as a community. Government cheese was a joke forever, right? It was the last cheese you want. Government healthcare, I don't want it. Government anything, I don't want. But for some reason, we started saying that as all of these education needs changed and shifted, we said, well, we want the government to do that. And we want that to be the primary way people get education. In fact, now private schooling and homeschooling, homeschooling has made a resurgence in popularity, which started in the 80s, but only became slightly close to not being weird in the past decade or so. We've seen this shift where we suddenly wanted government to be the big thing. And we stopped wanting to do it ourselves. We stopped wanting our communities to educate our kids. We stopped wanting to educate them ourselves individually. Instead, we want to collectivize them and put them in a government school. We expect it to be good. But everything government does is terrible. It should always be the safety net and the last-ditch effort. So for someone to drop a video that says, yeah, in the public school district, your kids are in danger. Yes. Yes, they are. The public school system is dangerous. It's more dangerous than a private school system. It's more dangerous than a homeschool system. It's more dangerous than community education. It's more dangerous than really anything. The public school system is awful. It should be the lowest bar, but we're trying to make it equal to, high-end private schools or whatever, which won't happen. So we try to make the private schooling illegal or whatever. But yeah, I don't know. I don't know how else to say it. I hate the public school system entirely. So, and I'm fully opposed to it in all of its iterations. You won't find any sympathy from me on the public school system. Okay, so we got one of these, and then we'll get back into the opening argument here.
Hey, Nick, this is Coach SCOTT. while April's under your desk. Tell her to plug in your Ethernet thingy cord.
I have not seen April since January. That's very many months. Confusion. And I don't have any contact with her or anything like that. She is moving on with her life, and people should leave her alone because she's clearly gone from the internet. So that being said, people who aren't on the internet shouldn't be the target of anything. And I know we've had a little moderating going on in the chat, and there's some conflict, I guess, over what is appropriate levels of moderation. I've been kind of toying around this idea, and I think it's a good time. I've been back for a week. People have had a week to say whatever nasty shit they want, and it has gone largely unpunished or undealt with. I don't really care what people say about me. I'm on the internet. I'm a public person. I've made bunches of bad choices. So go ahead and make fun of me all you want. It doesn't bother me. I don't care. Guys, when the government takes your kids away, the internet doesn't really bother you. Like when they say, aha, you're a drug addict or whatever. It's like, okay, fine. You can't take my kids away. So that's, I guess, say that I'm not threatened by that statement. That said, though, I've probably let some things go that should not be let go. And I'm going to follow Andrew Branca's lead on this. If you have disrespectful things to say about Lady Rackets or my children, some of the stuff that's said in the chat today has been well beyond what is acceptable in any circles. If you said that to me in public, we would have a different discussion. That said, yeah, I don't care if my mods ban you after you suggest what people are suggesting about my children. I don't have sympathy for you. You can go free speak wherever you want. But you can, again, say whatever you want about me, my choices. I'm the one out here dealing with it. You talk about my wife and kids like this more, and I guess we'll just keep removing you, because I know you'll keep making new accounts. It's fine. But it'll become less and less profitable for you, I suppose, at some point. So yeah, I don't care or have any fucking sympathy for you at all. In fact, if your house caught on fire, I'd probably pour gas on it. Anyway, that being said, go shut up a different chat if you don't like it. So as we get back to this, let's watch this opening argument.
Well, and the defendant according to the evidence and the law. If you follow that oath, approach this case with an open mind, and make your decisions fairly and without prejudice or bias or sympathy for anyone, then you will arrive at a true and just verdict. And that's all we ask of you. So it's now time for the opening statements. Mr. Brennan.
Thank you, Your Honor.
I'm hearing the camera quality is bad. I have no idea.
On January 29, 2022, the alarm bell sounded in the Canton Fire Department. Firefighter paramedic Timothy Nuttall knew what that meant. His heart skipped a beat. He raced to his equipment, and he picked up his bag, which was meticulous. There was a sign and a signal, and then there was a voice commanding that there was cardiac arrest. The most serious of calls for a firefighter paramedic, that means that a person's heart has stopped. He didn't know who it was. He didn't know where it was. He took his bag. He had just gotten to the station, and he rushed to the ambulance. He was one of the most senior paramedics that morning. Another paramedic, Anthony Flamati, would be running this mission. He jumped in the back of the ambulance, the door shut, and they headed off to 34th Fairview Road. As they drove, firefighter Nuttall could not see anything. He couldn't hear anything. other than the engine of the ambulance. He could feel it sliding across the road. It was near blizzard conditions. He calmed himself, he steadied himself. This is what the firefighters and paramedics are trained to do, to focus. And he focused on his task. He looked around the back of the ambulance to make sure all the tools were in place. The ambulance was meticulous as well. This was Anthony Flamatti's ambulance, and it was well stocked. He calmed himself, and he thought about what was going to happen. What should he be looking for? What is his next steps? He played the scenarios through his mind, and every calm was above him. As the car pulled up to 34 Fairview, the ambulance, he stood at the back door, the doors open, and he stepped out into bedlam. He could hear a woman screaming and shrieking, the cold, hard air slapping on his face, and the wind, blizzard conditions swirling around him. You will hear him tell you how he trudged towards those screams in the darkness to snow, and when he got there, he saw 3 women surrounding a man lying, not moving on the ground. He walked up to the man, and he reached down, and he tried to find any signs of life, pulse, anything, and he found nothing. And he got up and he walked over to the woman, and he walked over to that defendant, Karen Reed.
That
and he
one,
told her that he thinks
that defendant,
that man was gone. And then he heard the yell from Anthony Flamatti, the chief, and he said, "Come back, let's go." Because you'll learn that in the cold, even if somebody's heart stops, even if they are presumed to have passed, sometimes you can still save a life. So you'll see on a dash cam video, you'll hear through testimony, he went back to that man who's John O'Keefe. He went back to him, and that crew, coordinated effort, they did everything they could to save his life. They got on their knees, they began CPR, and firefighter Nuttall will explain as he kneeled over John O'Keefe. He looked up, and the defendant approached him, and you'll see it on the video.
you'll see it.
Now, he wanted any information, because when you're trying to save someone, you want to know, are they on drugs, medication, do they have a heart condition? And he looked up at Miss Reed, and he said, "What happened?" And you'll hear her words through firefighter Nuttall. She said, "I hit him, I hit him, I hit him."
All right. Dramatic pause. I hit him. I hit him. I hit him. Again, the narrative from the state. This is a critical element of it. Also, you'll hear it. Did we hear it? I don't remember hearing I hit him, I hit him, I hit him. I remember hearing testimony about it. But I don't know. What do you guys think? What I found interesting was when Joe joined the stream the other day and we were talking about the opening statements. This is what he described from it, was saying, I hit him, I hit him, I hit him, when he wasn't thinking. But then I asked him, tell me like 3 things from the opening that you like about the opening statement. Cause he said he liked this guy's opening. He said he liked it, thought it was pretty good. I'm starting to agree a little bit with Joe there. I think it's effective in what it's trying to do. It was just very confusing as to what it was trying to do coming into this trial, completely blank. And if I'm confused, I would assume the jury's confused. But hey, here I think is where it lands, though, is that I hit him, I hit him, I hit him, and then that's what the first witness that they call is the guy who testifies to that. They really care about this. They really care about that statement. This should tell you that the state's case is based on admissions heavily, probably more so than facts, which is weird because admissions can be all sorts of things that have nothing to do with the actual factual occurrence. But they're equally devastating. It doesn't matter where the admission comes in. It's just, in fact, having them come in out of context is usually very useful because there may be context that explains the admission. But here we go.
And it was at that time, through the words of the defendant, that she admitted what she had done that night, that she hit John O'Keefe. Now, those words didn't mean anything to firefighter Nuttall. They weren't in context. They didn't reconcile with the injuries. It didn't help him in his treatment, so he ignored it. Now, firefighter Nuttall is not a police officer. He is not an investigator. He is not a detective. He's a first responder. And so he takes that information that was useless to him. He continues to work on John O'Keefe, trying to save his life. You'll see the team put him on a stretcher. And when they lift him from the ground, even though there is snow accumulating, underneath John O'Keefe is simply grass, hard, brown, frozen. And beneath his body,
Even if there was snow and he laid there dying, he would
they
melt
bring
the
him to
snow.
the ambulance, and while they're bringing him to the
For a
ambulance,
while.
show the videos that other first responders speak to the defendant. One first responder, Mr. Flamati, she will say, I hit him, oh my God, I hit him. And then she was interviewed or asked questions for background information, not a criminal investigation, just background to try to help John. And she was asked questions about his background, and during that conversation, you won't hear her see the defendant was a person by the name of Jen McCabe and a firefighter McLaughlin. And she tells Fire McLaughlin, the third first responder, I hit him. They bring Mr. O'Keefe to the Good Samaritan Hospital, and his body is cold. The doctors work feverishly. They treat him, trying to save him. They try to warm his core. And unfortunately, firefighter Nuttall's first instinct is accurate. John O'Keefe passed.
His first instinct of finding someone buried under
So why are we
snow.
here today? We are here today
Probably dead.
because John O'Keefe
Past
was
medical
killed
school.
by the actions and conduct of that defendant, Karen Reed. You will learn through this case, through facts, science, and data, you will learn that on January 29th, 2022, when the defendant and Mr. O'Keefe were in front of 34 Fairview Road, all the way to the left side in a dark corner near a flagpole, you will learn that Mr. O'Keefe got out of the car. He got out and he stood by the side of the road after an argument with the defendant. That argument, that anger fueled by heavy intoxication, you will learn from the science and data as he stood by the side of the road, the defendant in her SUV drove away. She drove at least 35 feet away. The argument was over. It had ended. But then she stopped. She stopped. She put the Lexus into neutral, and she waited for 2 seconds. And the facts and the science and data will tell you that despite the fact the argument was over, she then put the Lexus into reverse, put her foot on the gas pedal, and began to press, not 25%, not 50%,
Not 25 or 50.
75% acceleration.
75%.
There was a light dusting of snow. The Lexus tire spun backwards. She went backwards at least 70 feet. She clipped John O'Keefe. He fell backwards, hit his head, broke his skull. And there he lay at the corner of Fairview Road, on the ground, lying on top of his cell phone, alone. And then the defendant will later tell that when she left, he didn't look mortally wounded. Yet he was. And she simply drove away. Now, before I tell you about the data and the facts and the science, and I walk you through that, I'd like to tell you a little bit about John O'Keefe. John O'Keefe was a young man, a local kid, very well liked, loved. John O'Keefe is the son of Peggy O'Keefe, John O'Keefe Sr., and the brother of Paul O'Keefe. Grew up in Canton, worked hard, he became
It's so. First of all, this guy sucks at telling a story. he is just balls deep in being bad at it. That said, what is this 75% pedal thing? Nobody like furiously almost slams the pedal down. Like they're going to furiously, cautiously press the pedal almost as far as it needs to go. But these facts don't ultimately matter. Like it's this, he's going to push 75% down. It really doesn't matter how hard she pushes the pedal. I mean, the fact that they want to make something out of it at 75%, it doesn't matter what the actual number was. She only pushed the pedal down 25% to make sure she could hit him, right? Like it's the caliber of bullet argument. All of this stuff is the caliber of bullet argument. There is no proper caliber of bullet to shoot someone with in self-defense. All of them are dangerous. You either used a small caliber because you only wanted to wound them and cause them pain, or something stupid. You use a large caliber because you glory in the large wounds that it would leave, or whatever it is never the right caliber of bullet. There's no amount of pedal pushing that would have been the right thing. The most obvious one would have been her slamming all the way down because she's angry. That fits the anger narrative. But it doesn't matter, because even if she had barely pressed the gas pedal, it would have been somehow geared towards killing this guy. And this is how the state works especially on murder cases. They develop a theory and then they work backwards from that theory. And it's kind of the practical way, trying to aggregate all the evidence, not knowing what is relevant at the beginning and coming to a deductive conclusion. That would be a more effective way of finding out what happened, but it's not a very effective way of law enforcement. And so what we have is law enforcement. They make their assumptions based on experience, based on training, based on kind of just a feel for it. Remember that they're interviewing these people. They see their interactions or their reactions. They read their body language. We only get transcripts, maybe videos sometimes, but that's all happening live for them. For us, we're kind of left over here. So they make a bunch of inferences and they make a bunch of assumptions, and then they come to a conclusion, and then they work backwards trying to fit the evidence together. It works most of the time. Most of the time, the evidence, if you have enough of it, is going to get you to the conclusion that of who done it. But there are times where there are parts of the evidence that suddenly don't make sense. And the problem is when the state has to push through that. And that's what this whole thing is, why they have to explain away this random text message that's very, very threatening to their case. Why they have to come up with some theory as to how and why she backed into this guy without causing hardly any injury, but enough to leave him dead on the ground. When it looks much more like an accidental death in some way to me. It looks like, I heard a noise from the court, so I switched over, but nothing's happening. It looks to me like perhaps there was a fight. There was not an intentional killing. There is a sad incident that occurs, and the injuries are limited to those things. I feel like if you're getting hit by a car hard enough to die, one way or another, there's more than just a bump on your head. Like a bump up here from a car hitting you and some scrapes on your arm from glass bursting out like a bomb somehow. None of that is congruent to me with an actual collision with a 6,000-pound vehicle, allegedly going somewhere close to 30 miles an hour. Like what, 24 miles an hour, I think they said she got up to. 24 miles an hour with a 6,000-pound vehicle is a lot of force to go into any part of the body, much less just like a doming of the guy. Lolita Smile says, drunk fight, accidental death, and the cops freaked. They said, fuck Karen Reed, and here we are. You know what? I don't even know if they said fuck Karen Reed so much as incidentally on the circumstances, she just kind of naturally fell into the place of being a viable suspect. Like, because again, I think people get a little overzealous with the way conspiracies form and the way that groups of people act against another. It sometimes it just falls into place that way, and that's what you're stuck with. It's almost like the movie Very Bad Things. But of course, that movie, the problem that you had was Christian Slater, right? Like the whole time, he's the one making things go bad. But these guys all find themselves in circumstances, and they're like, "Holy shit, we have to solve this problem." They didn't set out to kill the hooker. Nobody ever does.
A police officer, but what you're going to learn, the fact that he worked with a Boston police officer, as a Boston police officer, was just a fraction of his life. It was a small, really unimportant part, because the biggest part of John O'Keefe is he was a family man. Not in the traditional sense. You see, John O'Keefe never had biological children. John O'Keefe was never married. But John O'Keefe had a sister, and she had 2 children. And when the children were 6 and 3 years old, his sister unfortunately died. And shortly after, his sister's husband died. And John O'Keefe was at home. He didn't sit by. He saw these 2 recently orphaned children, and he stepped in and he said he was going to raise them. So he put aside his career, he put aside his job, and he moved in with the children and raised them like they were his own.
Hold on. We got action in the courtroom over here. We're back to live.
For the record before the court is Commonwealth versus Karen Reed, 22 CR 117. The parties are present. The jury is not present.
All right, thank you. All right, so we know that the Commonwealth has filed a few anyway, or repeated motions trying to get the defense to comply with reciprocal discovery regarding the ARCA witnesses. Previously, about a month or so ago, maybe longer, I found that there was a violation of the defendant's obligations for reciprocal discovery, and I found that it was deliberate. The Commonwealth filed additional motion, a motion to compel reciprocal discovery of the ARCA witnesses or to exclude their testimonies. Upon that, I believe I issued an order last week for certain discovery to be provided and to be provided by ARCA. On the day of opening statements, it was clear to me that there was another violation of the defendant's rules, defendant's obligations under our rules of criminal procedure. And based on that, especially given what the defense has failed to deliver, I would not permit the defense from mentioning ARCA in their opening. So today we're going to have an evidentiary hearing on your motion, Mr. Brennan. So I expect that we will get through both witnesses by the end of today. If not, we'll have to have them back, but I expect we can get through them. So Mr. Brennan, who are we going with first? Dr. Wolf?
Please.
Okay.
All right, so Dr. Wolf is about to get voir dired. Fletcher Boy says, can we still debate the importance of pants or lack thereof, asking for a friend? Again, pants are discouraged. And then Tara Rayner says, the distance has changed since trial 1. Remember, nothing in trial 1 matters unless someone is impeached with information from trial 1. Trial 1 did not happen outside of statements that were made that might be brought to show a lack of truth in the present. Cast doubt on the credibility.
All right, go right ahead, Mr.
Thank you. Good afternoon, Doctor.
Good afternoon.
Did you become aware there was an order from this court to produce records?
Yes.
Did you receive a copy of that order?
Yes.
Who did you receive a copy of that
So
order?
we need Dr. Wolf to identify himself.
Please identify yourself for the record. Spell your last name.
Daniel Wolf, last name spelled W-O-L-F-E.
I feel like I know this guy.
From?
I believe it was in an email forwarded from Miss Little.
I mean, I don't.
Did you read it?
Yes.
Did you understand that there was a request for certain communications?
Yes.
Did you understand that you were supposed to turn those records over to the Superior Court?
Yes.
Did you turn records over to the Superior Court?
I provided a copy of that production notice to Miss Little.
Did you provide the records to the Superior Court?
I didn't directly email that to the court, no.
Did you indirectly email it to the court?
It was my understanding that it would be passed along to the court.
So you did not, pursuant to the order, provide the records to the Superior Court, did you?
Not directly to the court, no.
When you read the order, you understood what the order was requiring you to provide, correct?
Correct.
It was requiring you to provide all text messages.
Yes.
Did you provide all text messages?
I don't have any in my possession.
Did you look for any text messages that are not in your possession about this case?
Wait, what?
Yes.
Okay. Did you find any?
No, sir.
What did you do to look?
So I went through the phone that I presently have, and
I don't
as
have
I
the text
informed Miss
message.
Little,
Did you look for ones you
last
don't
year
have?
I was under T-Mobile was my carrier. Subsequent to that, I then switched to Verizon in, I believe it was November. So I made an effort to contact T-Mobile as well as get access to my T-Mobile account hub. Unfortunately, I was unable to get access to it or get any records prior to, or at least from my T-Mobile carrier. Then I went through my Verizon records that I have from 2025. That was, I could only go back 3 months, and I provided those records.
How about emails? You didn't change email carriers, did you?
No, sir.
Did you provide all your emails from when you first were contacted by the defense?
Yes, sir.
And you provided every one of those emails to who?
It would have been in the file that I put together for the production.
How many emails did you find between you and the defense?
I'd have to look at the order, but it was probably 6 to. Are you talking about present day or just from last year?
Anytime.
It was probably around a dozen or so.
Who did you correspond with by email on the defense?
Again, can you specify a time frame?
At any time. Who did you correspond with by email on the defense?
It would have been Mr. Jackson. Miss Little might have been on one of those emails. There might have been a couple other members. I don't remember off the top of my head.
Well, how about Miss Reed?
I don't believe she was on any of those emails.
You've never emailed or been on a correspondence with her by email?
No, sir.
And how about Mr. Yannetti?
He may have been on one of the emails. I don't know as I sit here today.
You communicated by phone with the defense, didn't you?
Yes.
And that began as far back as March 2024?
After our report was issued, yes, in March.
Back in March of 2024, you spoke on the phone to Mr. Jackson?
Yes, sir.
A number of times?
Yes, sir.
And as you spoke, you began to become familiar with him and his role in this case, didn't you?
We corresponded about, again, our expected testimony here at trial, yes.
I'll ask it again. Did you become familiar with him and his role in this case when you spoke to him?
I understood him to be the defense attorney on the case, yes.
Did you speak to Miss Little by phone?
I don't believe so, no.
Did you speak to anybody?
Hold on 1 second, please.
Hank is excited. This is a critical element, critical time for the prosecution.
Pardon me.
They get rid of the ARCA testimony,
Did you speak to
then
anybody
their experts get to
other than
testify
Mr. Jackson
without
about
challenge.
this case before the first trial?
I don't believe so, no.
Did you speak to anybody since then on
Yes.
the defense team? Who?
I believe Miss Little and Mr. Alessi.
Okay, and how about Miss Reed?
No, sir.
Did you ever have any conversations that weren't on a regular telephone? You have a Zoom?
Yes, we have had, I believe it was a Zoom or a Teams meeting. We've had a couple.
When was that?
That would have been more recently to go over some of the testing that we've done.
Did you ever have any Zoom meetings before the first trial?
No, sir.
Did you ever have any group conferences before the first trial?
I don't believe so, no.
Were you ever on the phone before the first trial in a conversation where you and Dr. Rentschler both were on the call?
There may have been an instance of that. I just don't recall.
Well, think back.
I don't recall.
I don't recall.
Try again.
At some point,
I
you
want
were
you to
contacted by
recall.
Mr. Jackson and you decided or you learned that you may be part of this case as far as a witness?
Yes, sir.
When you learned you were part of this case, did you have contact with Mr. Jackson before you testified at the voir dire?
Did I have communications with him?
Yes.
Yes.
And in those communications, you spoke about your role?
I think we spoke about logistics and coordinating my arrival here for the voir dire and certainly the trial.
Well, when you spoke on March 20th, 2024, didn't you talk about more than coordination of logistics?
I'm sorry, what was the date?
March 20th, 2024?
So I believe that would have been the very first phone call that I had with Mr. Jackson.
Right. Was that more than about logistics?
Well, I think we were trying to figure out what should we do. I will note that this was a very abnormal situation for me, being involved in a federal investigation and then ultimately being called as a witness.
No.
Well, I'm trying to answer your question.
But you're not. Did you talk about more than
Whoa.
logistics?
So are you finished with your answer, Dr. Wolf, or are you still answering?
I was still trying to answer.
Go ahead, finish.
Thank you.
I'm like, holy shit.
So as I mentioned, again,
Why
the
is this lawyer
situation
so
was
ass-mad?
was abnormal. I didn't know if we could get involved. I didn't think Mr. Jackson knew we could get involved. In terms of a path forward, would we be able to do more work? Could we review additional material? How could we work together moving forward? There was a lot of unknowns, so there was a lot of uncertainty.
You done?
Yes, sir.
Did
Holy
you talk
shit.
about more than just logistics?
No, sir.
Did you talk about fees or structures?
I described to him our typical procedure when we intake a criminal defense
He's done.
case, right? There's typically a contract and retainer associated with that. So I described our normal procedure that takes place. Yes.
So you talked about fees and scheduling and costs, what you charge.
I did talk about, yes, the contract and the retention letter.
When you talked about that contract, there was a discussion, wasn't there, about them hiring you, paying you, or retaining you?
Potentially, again, I prescribed our standard procedure.
Why was it you were talking about fees and schedules if you didn't think that you were potentially going to get hired?
Again, I prescribed our normal operating procedure. I had no idea how it was going to work moving forward, which is why ultimately, immediately after that phone call, I contacted the Department of Justice to get clarification on that.
We'll get to that, but I'm asking you specifically, why were you talking about fees and scheduling and being paid at that point?
Objection, Your Honor.
I'm going to allow it.
Again, because Mr. Jackson was interested, I believe, in calling us to testify at trial. So I explained to us the normal process. When a client reaches out and wants to engage us for trial testimony, that's typically, again, the procedure that we prescribe at ARCA. So that's why I had that explanation to him.
So you were talking to him about details about potentially being hired. Isn't that fair to say?
I don't know about being hired. I think, again, him utilizing us in the trial as expert witnesses.
Well, what's the difference between him utilizing you and paying you for that utilization and him actually hiring you? What's the difference in your mind?
Well, I think there is a difference because ultimately, after I got clarification from the Department of Justice, they indicated that they could not, the defense that is, sign any type of contract. There could not be any type of agreement or retainer.
I'm not asking what you determined later. I'm talking about the conversation you had on March 20th, 2022, when you were speaking to Attorney Jackson. That's what I'm talking about, okay? Understand?
I don't know that I understand your question then.
Okay. When you had a conversation on March 20th, 2022 with Attorney Jackson, you discussed potentially being hired, paid, compensated by Attorney Jackson or the defense for this case, didn't you?
We did, like I said, I did explain to him our typical operating procedure when a client reaches out for trial testimony. I went over that with him, yes.
I'm not talking about a client. I'm talking about this client. Did you talk about them potentially hiring or retaining you for work in this case? That's the question I'm asking you. On March 20th, 2022, not the 22nd, not the 24th, March 20th, 2024, did you speak to Attorney Jackson about them potentially retaining or hiring you for this case?
I spoke to him like I speak to any other client that would be interested in calling us as a witness.
Okay. And so after you spoke to them, you spoke to representatives of the United States Attorney's Office, and you wrote an email back saying that you were going to put the conversation on hold. Is that fair to say?
Correct, until I got clarification from them.
And at some point it was on hold, right? At some point it resumed.
Yes.
When was that?
That would have been towards, I believe, the end of April.
The end of April. How was this relationship resumed? What was the contact, the conversation between you and anybody on the defense that resumed that relationship?
I think that I reached out to Mr. Jackson. Like I said, I think it looks like about a month had passed. And I had let him know that I had spoken to the DOJ and got clarification on moving forward.
So in April of 2024, you reached out to the defense and said that you had permission or a green light to move forward in the relationship with the defense in this case.
I had clarification from the Department of Justice, yes.
And that clarification allowed you then to work with the defense on this case.
Not work with, we could be called on the defense's behalf to testify. And for that matter, the Commonwealth could have also contacted us and utilized us at trial as well, if they should please.
So when did you become an advocate for the defense?
Oh my God.
Interesting.
That's an
Do you
objection.
feel like you're an advocate for the defense?
No, sir.
Are you sure about that?
Sir, I'm on the
Asked,
science and the analysis that I've done. That's the side that I'm on.
You sure are. Because after that 424
Holy
call,
shit.
letting them know that the United States Attorney's Office
Judge is
gave
just letting
permission
the
for you to be called as a
letting
witness.
tee off on the witness.
You called them again that day, didn't you? Or they called you on the main line.
We may have exchanged a couple calls that day, yes.
Well, you did exchange a couple
You did
calls that
exchange
day.
it. You did.
We have at least
I know that.
some records.
You did. You
And when you
scumbag.
called later that day after telling them that you had permission, they could use you as witnesses. What did you talk about?
Do you have the records that I could take a look at just so I could see what you're referring
Do you
to?
remember having calls after you called Attorney Jackson and said you had the green light from the U.S. Attorney's Office? Do you remember having further calls that day?
I think we had a couple brief conversations, yes.
Okay. When you think about it, do you remember them, or are you just saying you think but you don't know?
I don't remember. I remember that there was one conversation, I believe in early May, that I had with Mr. Jackson, in which we engaged in a conversation where I gave him more information about my background, who ARCA was as a whole. I think we even got to talk a little bit about my family, my 4 kids and things of that nature, but it was a call about background and qualifications.
We're still back in April. You're moving ahead to May when you first started billing. I want to talk about back in April. Do you remember having conversations on April 24th with Mr. Jackson? Do you remember that?
I'm going to allow that.
I remember that there were conversations, yes, specifically what they were to. I remember, I think they were brief, but I don't remember the specifics of them, no.
Well, in the brief conversation, what do you briefly remember about that brief conversation, Doctor?
Well, as I mentioned, I think I had finally received clarification from the DOJ, so I think I was letting him know that I had received that clarification.
Sir, you said that was the first call. There were more than one call. There was then 2 calls to the main line. What did you discuss with him during those calls?
Well, to be honest with you, the call to the ARCA main line, I don't even know if I spoke with him. That's just to the main line, not to me directly. So he could have spoken to a receptionist who then tried to get a hold of me, right? So I don't know if that specific call to the main line was to me or someone else at ARCA.
Well, this is a new relationship, right? You were working on a contract with the federal government. You have only spoken to Mr. Jackson, according to you, twice. You don't remember the early conversations with them and what they were about?
I'm sorry, are we talking about now at the end of April
Yeah,
still?
we're still talking at April 24, 2024.
Yeah, as I just discussed with you, from what I recall, it was relaying to him the clarification that I got from the Department of Justice.
Right, but that doesn't take more than one call, does it?
It did.
I don't know. He may have been in court. There might have been some phone tag. I don't know, sir.
Well, there was a 9-minute call on April 24th.
9 minutes.
And then there's 2 calls to the ARCA main line, 3 minutes and 2 minutes. Do you remember any of those calls?
Again, when you say
speak
3
the
minutes
3
and 2
minutes,
minutes,
2
that
minutes
makes it sound like, in all likelihood, he contacted the ARCA main line, got a hold of a receptionist or my project manager, and couldn't get a hold of me.
Are you just making that up, or that's what happened?
Sir, that is my best guess. I don't recall from a year ago.
We're not asking you to guess. I'm asking for your testimony.
That's what I recall, sir.
Do you recall him calling a secretary on the main line? That's what you recall?
He very well could have. I just don't know, sir.
But you're making a representation that you recall him using a secretary in the main line.
No, he's
asking
not.
what you actually
He didn't
did
make
and
that
actually said.
representation.
Do you remember speaking to Mr. Jackson, Mr. Jackson or anybody on the defense team after that initial call back on April 24th, 2024? Do you remember those 2 phone calls?
Objection, Your Honor.
So let's get an answer.
I don't remember those phone calls specifically, no, sir.
Next
Do you
question.
remember the phone call on April 30th, 2024? Do you remember that one?
I don't remember that call, sir.
Do you remember the call on May 1st, 2024?
I don't have the records in front of me, but was that a longer call by any chance?
It was 40 minutes long.
Okay.
Yep.
So then, yes, as I just described earlier, that would have been the call in which I went over with Mr. Jackson a little bit more about ARCA, my background, my education, qualification, the kind of casework that I do, things of that nature.
And did you discuss issues regarding this case?
No, sir.
So during the 40 minutes you spoke, you never discussed any of your findings that had already been made?
No, sir.
You had never discussed any of your testing in this case during that 40-minute conversation?
No, sir. And it was all laid out in the report that was issued in
I
February.
understand the report. I'm asking you, did you have any conversations about it with the defense?
No, sir.
So in that 40-minute conversation, you talked about your family, your pastimes, ARCA, but never, ever talked about this case.
Objection, Your Honor.
I'm going to allow it.
Correct.
You billed for that time, didn't you?
I believe that I kept track of that time, yes.
Okay. When you kept track of the time, did you submit that time and ultimately get money for that time?
Again, I routinely keep track of my time when I'm working on a project. So yes, that time was kept track.
That's not what I'm asking you. Ultimately, that time that you kept track of, did you then submit it and get paid and compensated for that time? That's what I'm asking you.
Well, first off, I'm a salaried employee, so I don't get direct compensation when an invoice goes out. That old invoice, when it's sent, ultimately comes back to ARCA. That doesn't come back to Dan Wolf.
Okay. So in order to get paid for that, you would have had to submit that time through ARCA to then forward it, wouldn't you?
Objection, Your Honor.
Going to allow it. Is that true?
Yes. I keep track of my time so that my boss knows what I'm doing. Yes.
Okay.
Your Honor, can you approach, please?
Who asked me that?
Me, Your Honor.
Come on over.
Me, I'm Tucker. Sorry, that's a call back to greatness. This is Hank sounds like such a bitch here, man. Like, oh yeah, really? Okay, you on the phone 9 minutes, 9 fucking minutes, 9 minutes of my time. My time? It's not your time. Next on this question, who cares what he's getting billed for, or what Look, I got news for you. Like if you're talking to a contractor and you choose to spend that time, that is the contractor's time, talking about something other than the project, that's still the contractor's time. Like depending on their billing policy, like, hey, I'll be your therapist, I guess, but I'm $250 an hour. Like they may not be talking about the issue or the thing there, but you are using that company's time to make that phone call, and that's on you and what you'll end up paying for in your billing. I mean, I don't know how else to say it. That happens in the professional world all the time. It's not fraudulent. It's not anything like that. Now, if I don't know if you've got some scheme to act like you're doing work and then bill it out and you're engaged in a conspiracy to defraud, that's a different thing. But, talking about something other than work with a contractor that uses the contractor's time still uses contractor's time. And if they bill for phone calls, then that's just being billed for phone calls. So, I don't know. He sounds petulant and just completely shitty here. But there's no jury, right? Like, so this is done outside the presence of the jury. So he gets to be a little bit more aggressive.
Doctor, again, to focus you, we're on May 1st, 2024. May 1st, 2024, you had a conversation with Attorney Jackson.
Correct.
And at some point, did you submit the time you spent and forwarded it so that could be billed?
Yes, and I will note that all of that time was actually tracked under the same project number that the work that was done for the Department of Justice was under.
So at the time you had that conversation, you were keeping track of hours, correct?
Something I routinely do, yes.
And do you know who ultimately paid that bill for that day, May 1st, 2024?
The Commonwealth.
I know now that it was the defense, yes.
Oh, there we go.
Now, when you billed, did you bill for the entire conversation?
I don't know.
You said most of the conversation was background, talking about ARCA, talking about your families?
Yes.
Right. Do you typically bill clients when you're spending time talking about families?
Again, that wasn't the entirety of the conversation. I think you just briefly asked me about my family.
Oh, now it's brief. Okay.
Oh, okay. Now it's brief.
No comments, please.
Do you typically charge when you're talking about non-related work matters?
This is the kind of shit you expect in deposition?
Sir, I think the
Not
majority of that
stand?
phone call was related to, again, work-related topics.
work-related, it took that much time to talk about ARCA?
And my
9
background,
minutes?
certainly.
Yeah, okay. And how much was the majority?
Sir, I don't know that I can parse it out in individual segments or minutes for you.
And so after that May 1st conversation, did you communicate with the defense before June 9, 2024?
I don't believe so. I think from what I recall, next up was, I think, the voir dire. I think Alan contacted me letting me know that the court wanted to do a voir dire of myself and Dr. Rentschler.
And you mean Alan, you mean Attorney Jackson?
Yes, sir.
Okay, so you became friendly.
Alan Jackson.
I guess first name basis, is that what you're referring
No,
to?
I'm saying, did you become friendly?
No, I wouldn't say that we were friends.
I didn't ask if you're friends. I said, did you become
God,
friendly?
this guy is such a cockhole.
I talked to him like I talk to all of the attorneys that I work with, sir.
What would you call me if you were going to address me?
Probably Mr. Brennan.
So, do you remember the next time you spoke to Alan?
As I mentioned, it probably would have been sometime in early or mid-June.
Going into June, you were keeping track of all your communications with Attorney Jackson or anybody from the defense, weren't you?
I don't know if you mean, what do you mean by keeping track?
Well, do you have a folder where you make notes when you have communications with an attorney and discuss issues?
No, sir.
You don't make notes?
Not for brief phone calls, no.
For your billing, do you save phone records or text messages so you have some collateral evidence about the billing?
No, not when it's things about, again, logistics and traveling and scheduling. No, sir.
And by the way, when you put together your phone records and text messages that you sent to the court in response to the court order, did you have actual records?
What do you mean in terms of actual records?
Well, I see like a summary chart that was developed. Who developed that summary chart?
So that was, again, as I mentioned earlier, I was unfortunately unable to pull anything from T-Mobile. I just could not get access. Then what I did is I logged into my personal Verizon phone records, and I was able to go back for 3 months. I couldn't get back to December, and then I downloaded the spreadsheets, and I extracted those rows and provided that.
Did you provide the actual records or just the spreadsheet?
Well, I provided the spreadsheet, which was pulled from the records. I would have had to redact a lot of phone numbers if I was to put in the full extraction, if you will.
So you didn't provide the full extraction?
I provided the full extraction as it relates to all of the contact between myself and Mr. Jackson and Miss Little.
Did you ever delete text?
From last year?
Yes.
Yes.
After you had text messages with the defense, did you delete those texts?
Yeah, after the trial concluded, I mean, that's something I routinely do. I'm not going to keep texts from Mr. Jackson, especially now that we're past a year. I would have no reason to keep those, sir.
I'm not asking for the excuse. I'm asking if you did it.
God,
did you delete
such
text?
a cock.
Again, it's something that I typically do. I communicate with attorneys all the time, whether it's for
He already said he
trial
did it.
or inspections. I don't have a habit of keeping a text chain about scheduling or meeting or, hey, can we meet at this time?
Remember what I
or
said
show
earlier?
up here. I just don't have a habit,
Have a habit
keeping
of
that
it.
type of text.
So
He's
you-
not my friend, sir.
So you didn't delete texts?
I think I just told you that, yes, I did delete the text.
No, you didn't tell me, but you just did now. Thank you.
No, he did.
So next question, no
Okay.
comments, Mr. Brennan.
He definitely
How
said,
many
yes,
texts
I deleted text.
Did you delete in communications with the defense?
Yeah, I delete them all the time.
I don't know the number, sir.
You don't know the numbers?
I don't have the text. So you're asking me over a year ago almost about text messages. I don't recall
People
how many
don't
there
text
were.
Hank.
Right.
He's
Was it
lonely.
10, 100, 1,000? How many were
1000?
Of ones that I sent?
Was it 1000?
Either, no, not just what you sent. Either way, back and forth.
Probably, I don't know, maybe around 100 or so.
And when did you delete those over 100 texts between you and the defense?
As I mentioned, I think the last text that I remember was Mr. Jackson texting me, just thanking me for my time coming up here after the trial. Again, that was at the end of June. And then I didn't hear from him. And at some point, I don't know specifically when, it would have been last year, but I deleted those texts. There was no reason for me to keep those, sir.
Do you remember about when you made the affirmative intentional effort to delete around 100 text messages between you and the defense?
It would have been sometime after the trial, probably before I got my new phone in November, but it would have been probably in the month or two after the trial, sir.
Where were you when you were deleting this text? Were you at your office, at home? Do you remember
I was with your
sitting
wife.
down and deciding intentionally you were going to delete over 100 texts? Where did that decision happen?
I have no idea, sir.
You can't remember deleting over 100 texts? Where you
Sir,
were?
I just said I delete text routinely. You're asking me to specifically give you a location and a time when I deleted those. I don't recall that.
You said it was after the trial.
He said it was probably after the trial. He actually didn't say
out
it
of
was.
the 100 texts or so, who were you texting on the defense team?
I believe it would have just been Mr. Jackson on that.
100
Did you ever communicate by any other means, like Signal or an application?
During the time of the trial?
Anytime.
Yes, sir.
With the defense?
Yes.
Is it typical for a biomechanical engineer to use an application like Signal to talk to an attorney on a case?
Yes.
Sure.
Very much.
You know the benefit of Signal, don't you?
Privacy.
I mean, it's a messaging platform, yes.
Well, it's an encrypted app, isn't it?
What was that?
Encrypted?
I don't know, sir.
Damn near every
keeps no
messaging app you
record
use these days is encrypted.
Of the communication when you use an application like Signal, does it?
I don't know, sir.
Well, you used it.
It's not
Did you have it
required
on
to
your phone
keep
that
the
you were using it with
communication.
other people?
No, I don't believe so.
So the only time that you use Signal in your career is when you were dealing with this defense team?
Yes, it was earlier this year. Mr. Jackson had communicated with me, indicating that it was his preferred method of communication. So yes, we did exchange some messages on Signal.
Yeah, use Signal
But this
when you
was at no point in time during the first trial.
routinely are
using the Signal
with the
app. Was
government.
that your suggestion?
No, again, I think it was Mr. Jackson that said it was his preferred method.
Is that standard in your industry to use Signal when you're talking to clients?
I don't know that there's a standard out there, sir.
I'm asking about your standard.
No,
Is it
you
your
asked about the
standard to
industry.
use an encrypted app when you're talking to attorneys.
If the client has that preference, I don't have a problem with it, sir.
How many times have you done it other than this defense team?
Again, as I just mentioned, it was the first time.
How many conversations
This means
do you
it was
think you
special
had
for
with
him.
the defense team?
He'll take it
by
with him
Signal?
forever.
Again, it would have been just Mr. Jackson. And like I said, it was really, I think, just in the month of March of this year, but it was brief. I know that I think we exchanged a couple phone calls, and I remember the call quality was terrible. So we really didn't use it that much.
Okay, you're saying a lot of things. You're saying you think. I want to know your best memory. I don't want you to think. If you don't know, you don't know. How many times did you use Signal with the defense to talk about this case?
Objection, Your Honor.
Going to allow it.
From what I recall, it was probably a handful of times.
When you say if what you recall, are you purposely being vague in case there's records, or do you not remember?
I don't remember, sir. As you mentioned, it doesn't keep a log of it, so I just don't recall.
Well, you don't have to rely on a log. You can rely on your actual memory.
Right. I'm telling you that I didn't keep track of it, so I don't know the specific number.
How many times do you think
How
you
many
talked
text
by
messages
Signal?
did you send on
As
your
I just
Signal?
mentioned, I think it was a handful of times.
I don't know what a handful means. I don't
Probably
know what that
around,
means.
probably 4 to 5.
Well, was it 4 or was it 5?
It was probably 4 to 5. It's the best estimate I can give you.
How long were the conversations on Signal? The 4 to 5 times.
I think they were pretty brief. I'd say probably around 5 minutes or so.
You think each one was 5 minutes?
Probably 5 minutes,
Were you
yes.
putting it on a timer? Each one had to be a maximum of 5 minutes?
No, I'm just giving you my best estimate, sir.
How certain are you that the Signal calls were 4 to 5 minutes?
Again, I just told you I'm providing my best estimate.
How confident are you the times were between 4 and 5 minutes?
On a scale of
That's the best answer I can give you, sir. I'm giving you my
I don't
best
even know.
estimate.
I'm asking you how
1 to
confident
10,
you are.
1 to 3.
You answer that. How confident are you, Dr. Wolf?
I can't answer that anymore.
Okay.
When
Next
you were
question.
required by court order to provide all of the records to Your Honor, you knew that one of the important things you need to respond to were communications between you and the defense for Her Honor to consider, right?
Yes,
And Signal is a communication, isn't it?
certainly.
You looked at all your
If they're not
records.
there,
you knew
they're
it
not
listed the
there.
text messages and the phone calls. You knew that, right?
Yes,
You knew that was going to be a representation that you were making to the court about your communications with the defense. You understood that, didn't you?
yes, sir.
And you wouldn't want to mislead the court, would you?
No, which is why I told you.
I asked. You didn't put anywhere in your response to the court order that there were communications beyond text messages and phone calls. You never, ever alerted the court or anybody to that, did you?
Again, because I have no record of it. I have no way of being able to tell when those took place or how many there were.
The question I asked you is when you responded to the court order to provide all communications, and you responded by offering text messages and you responded by listing phone calls, you knew that your signal calls were communications, didn't you?
I provide everything that I had in my possession, sir.
That's not what I'm asking you. You knew the signal calls were communications, didn't you?
Yes.
Okay. And you never
You're not ordered to
informed
produce
in your
things you don't
response
have.
that there were phone calls through Signal as part of your communications, did you?
Again, because I didn't have any record like I do with the Verizon entries as well as the emails. I could not, there's nothing I had in my possession, sir.
You've read this court order, haven't you?
Yes.
Did you understand when the court was looking for all communications, it meant all communications?
And I've provided everything that I have in my possession, sir.
During those 4 to 5 Signal communications, did
Sure
any
you
of
did.
these occur before the end of the last trial?
I'm sorry, can you repeat that?
Did any of these Signal communications happen before the end of the last trial?
No, like I said, they were all this year.
You sure about that?
Yes.
Now, at some point, did the defense send you a retainer agreement?
For this year?
Nope. Prior to the end of the last trial, did you ever get a retainer agreement?
No, there was no contract and retainer for the
Not
first
that there wasn't a contract. Did you ever receive a retainer agreement?
No, I don't believe so.
Retainer agreement is a contract.
When you came out to the last voir dire and the last trial, did you have an agreement with any entity that was going to pay for your costs?
No, sir.
So you had no agreement that you were going to be refunded or compensated for your costs?
No.
Did you have any agreement that you were going to be compensated for your time?
No.
So when you were asked to come out and testify in this case, tell me, did you think that the defense was going to compensate you for the cost of you coming out here?
I had no idea who was ultimately going to pay the invoice, if an invoice was even sent.
Did you think that you were coming out here to testify for free?
He's salaried,
Again, I don't
bro.
know who was going to pay the bill. I'm not.
That's not what I'm asking you. I want to know, after having these
Want to know.
conversations with the defense, and they asked you to come out here, did you expect to be compensated for your time?
Again, I'm a salaried employee, so it doesn't matter to me. I'm sure my boss would like us to get paid, but no, I did not know ultimately who would pay an invoice if an invoice was sent after the trial.
Well, you were keeping track of your billing, weren't you?
I was keeping track of my time, yes.
And you kept track of your costs, didn't you?
The company does that, yes.
Did you?
Again, I enter my time so that the company can keep track of my time, yes.
When you came out here and made travel arrangements, did you have any conversations with anybody from the defense?
About the travel arrangements?
Yes.
Yes.
And as far as the travel arrangements, who on the defense was trying to help you with travel arrangements?
I believe it was Mr. Jackson.
Was there other people, associates, colleagues that were helping you as well?
None that I had direct communication with. I don't know if he communicated with others after that.
Needed help with his travel? What is he, a poor?
I believe that, yeah, she may have escorted me into the courtroom, I think.
Well, you don't believe, because that's a pretty particular name. So when you use words like you believe, you know. So did you meet a person by the name of Kat?
I'll allow it.
I think when I arrived here, yes.
Well, without the qualification, the simple question is you've met Kat, haven't you?
I think I met her. It was either at the voir dire day or the trial day, yes.
Now, does Kat work for the defense?
I have no idea who she is.
Well, how did you know who she was? How was the introduction? How did that go down?
I just mentioned, I think she escorted me here to the courtroom.
Escorted you from where?
I think I drove here and I arrived, I believe, in the church parking lot across the street. And I think she walked me over. And then ultimately when I was done, I think she walked me back to the lot.
Do you have conversations with anybody for the defense about how you'd get here and why it is in particular you would park at the church parking lot?
Because I had no idea where to go.
But who told you where to go?
Like I mentioned, I communicated with Mr. Jackson, who provided that information to me.
And did you have any significance about the church parking lot? Did that mean anything to you?
No, he had just indicated, I think, that they had reserved it and it was a spot that I could park my vehicle.
Okay. And when you got there, did you meet with anybody from the defense?
I can't recall if they were standing out there and we walked in together. I don't recall.
Well, I'm asking if you've met them, not whether you walked in together. I'll ask it again. When you arrived after these plans were made, did you meet with the defense before you came into court?
On the voir dire day, I don't believe, I can't recall if the defense was out there. I think on the day of trial, I think I met Mr. Jackson and maybe a couple of other members of the defense team.
Well, when you say you think, this was a pretty remarkable event coming to this trial, wasn't it?
Yeah, I mean,
pretty remarkable event, this trial, wasn't it?
It's unique, yes.
Yeah, it's unique. And so when you came here, having had all these conversations with Attorney Jackson, you don't remember if you met him before you came in for voir dire or came in for trial? You don't remember if you met him?
Well, like I said, I think for the voir dire, I think he was already, I believe, in the courthouse. So I think the first time I actually shook his hand and met him was the day of the trial, if I'm not mistaken.
Okay. And tell me, is that near the church parking lot that you met with them?
I'm sorry, what was your question?
Was it near the church parking lot where you met with them?
Yes.
Okay. You shook his hand.
Okay.
Meeting face to face.
Yes.
Right?
Before God.
Yes.
Did you have a conversation about the case?
I don't believe so, no.
When you say you don't believe so, do you think you had a conversation about the case?
At that point in time, no. I was getting ready to take the stand, so I don't think we had a conversation about it.
You were speaking to the defense or Attorney Jackson on June 10th, 2024. That was before your voir dire testimony, correct?
I believe so, yes.
And do you remember what those conversations were about?
I presume it was about the logistics of when we were needed. And then I know that ultimately I served as kind of the primary point of contact where I think Alan would reach out to me. He would give me some information about the scheduling and kind of when we would be needed. Then I would check in with Dr. Rentschler, and then I would get back to Mr. Jackson. So there was kind of that channel of communication to try to figure out when we were to arrive and where we're supposed to go.
You're not saying that all your conversations with Alan were just logistics, were you?
I believe for the most part, yes.
So it took hundreds of texts, 100 texts for logistics?
Absolutely. I could certainly go into the day before my trial testimony, which was a very extensive travel day where I don't even think I left the Philadelphia airport.
We're going to get there. We're going to get there, but there's a lot more communications before we get even close to that.
We're not even.
Do you remember on June 10th?
We started talking about talking yet.
Having.
What are we talking about?
Conversations with Attorney Jackson.
I do remember that there was conversations,
Okay.
yes.
Now, June 10th is 8 days before your testimony. Did you ever talk about an outline of your testimony or what your testimony would be?
No, sir.
You ultimately have more conversations on June 16th. Do you remember those conversations on June 16th?
Not specifically, no.
You don't remember them specifically? Do you remember whether or not you talked about the case with Attorney Jackson on June 16th?
We did not talk about the case, no.
Did you ever email with Attorney Jackson around that time?
In June 10th?
Before your voir dire.
Hey, Attorney Jackson.
I don't believe so, no.
Where's our
So
email?
everything from your mind was just logistics at that point.
Yes, sir.
Okay. And then you came in for June 17th?
I believe the voir dire was the 18th.
Okay. Do you remember having phone calls on the 18th with Attorney Jackson?
The day of the voir dire?
Yes.
I could have to let him know that I arrived.
So you check in with a client, tell them you're on their way, even though you're not going to meet them?
To let them know that I'm coming to court?
Okay. And so when you testified in the voir dire, then did you have further conversations with Attorney Jackson?
After the voir dire?
Yeah.
Yes.
And did you talk about the case?
No, sir.
You had to testify.
Hank can't
you
imagine
testified
people talking to him about
on
anything
the
other than
24th?
cases.
That sounds right.
You had a number of phone calls before the 24th. You had a series of phone calls on the 17th, 2 on the 18th, 2 on the 19th. Do you know what any of those were about?
I think it was about the logistics of arriving here because I know that I was going to, as opposed to driving, I know I was going to fly in this time.
Okay. How about the 21st and 23rd? There's a call on the 21st and 2 on the 23rd. Did you talk about the case?
No.
And so when you came into trial to testify, you were just relying on the opinions you had already provided in the past?
That were written in the February 12th report of 2024?
Yeah.
Yes.
And you had not talked about the case with Attorney Jackson or any member of this team?
No, it was all in the report, and that's ultimately what I testified exactly to at the time of trial in the voir dire, sir.
And you did not talk to Attorney Jackson or anybody else about the case?
No, sir.
May I approach?
Yes.
So if you're just joining us, this is voir dire of Dr. Wolf from ARCA. ARCA is a key witness for the defense.
Email, do you recognize that?
The state is trying to exclude
Yes.
their testimony
To Mr. Jackson.
based on alleged discovery violations.
Labeled as,
Wolf Direct.
and that's before you testified on trial 24.
It's at 6 p.m. the night before I testified, yes.
So it's before you testified.
Yes.
Okay. Let me show you this document.
Let me show you this document. Let me show
Yes.
you this.
What's that?
That is the attachment to the email.
Crazy thing is, nothing that they've talked about is in any way
Yes.
Do you recognize discussing
even questionable.
you testified on June 24th?
There's nothing suspicious in what's been said so far.
I never discussed this with him. This is something that I sent to him, that I did on my own, and that I sent to him. But he never asked this of me, and we never discussed it.
So you sent him what you thought would be the best questions and answers for him to ask you when you testified.
So this is something I routinely do when I work with attorneys, okay? I prepare this on my own to prep myself and prepare for trial.
Can I take that, please? There's an email with a document I'd like to attach this as an exhibit.
Okay. Exhibit 1. 1.
So you assisted the
Hold on.
defense before your testimony.
Hold on.
Thank you. So you assisted the defense in anticipation of your testimony by sharing with them the questions and answers you thought would be most helpful.
Again, as I mentioned, this is something that I do internally to prepare. I sent that to him the evening before I testified at 6 p.m. I presume that he already had his direct examination done at that point. So I sent that to him, yes.
That's a lot of answers other than the one for my question. The one for my question
Hold the comments, please.
my question was, you had communications offering information to the defense before you testified in a way that you thought would help the testimony, didn't you?
Well, first off, I have no idea if he even read it or utilized anything from it.
But that's not really answering the question I just asked, is it?
Can you repeat the question?
Of course I can.
Of course I can. I can do anything.
So when you sent a
this
direct
guy on coke?
examination to Attorney Jackson before your testimony, you communicated with Attorney Jackson, providing information that you thought would best help your testimony in court.
Well, I think ultimately it's to help the jury understand my report and my analysis.
Do you think it's helpful not answering the question and just diverting every time I ask you something? Do you think that's helpful?
This is insane. Like,
do you want to answer my question or do you want me to move on?
I think I answered your question.
I don't think you did, so I'll ask it one more time.
All right, no comments, please.
the judge
think that
needs
providing
to step in
a direct
here. It's
examination to
insane.
the defense before you testified is in any way assisting preparing for your testimony?
Again, I don't know if he even utilized it, sir. And certainly if the Commonwealth had reached out, they could have gotten a copy of that as well. It would have been the same exact outline whether I testified on behalf of the defense or behalf of the Commonwealth.
You don't want to answer my question?
He just did.
Did you ever make any comments or discuss the outline that you provided to the defense to help better the testimony for the defense?
I did put comments, yes.
When I just showed you that document and you said you just sent it because this is a standard thing, why didn't you just tell us that you made comments that would assist the defense? Why didn't you share that when I just asked the question?
I don't understand your
You
question.
don't understand my question. I asked you about the outline, the direct examination you provided to the defense
And he told you he provided
and you gave
it.
me a response that this is something typical, but it's just an outline. You wouldn't answer whether it would help the defense or not, but the reality is you were assisting the defense, isn't
You
it?
were.
Objection, Your
I'm
Honor.
going to allow that.
You were making suggestions to help the defense, weren't you?
Sir, it wasn't to help the defense. It wasn't to help anyone but the jury understand things. As I just mentioned,
Good answer.
that outline, if it was asked if I had sent one to the Commonwealth, you would have gotten the exact same copy.
You didn't send one to the Commonwealth.
The Commonwealth never reached out to us, sir.
So what you said in this is there was a question about, so not being able to inspect the vehicle is something that is not uncommon in your line of work, and you wrote back, absolutely not, correct?
Correct.
And you made a comment
That's
to
just a
assist the jury,
fact.
according to you, only to assist the jury. Not sure if you want to put this somewhere in the direct examination. I have a feeling they are going to argue I didn't personally inspect the vehicles. I had enough information from the material I reviewed, so it wasn't necessary. Need to show jury it doesn't matter in this case.
It doesn't matter in
Those
that
your
case.
comments to the defense before your testimony?
Absolutely. And it would have been the same argument probably from the defense if you had called me a witness about not being able to inspect the vehicle. I wanted the jury to have an understand that for the analysis I undertook, it did not matter that I did not physically inspect the vehicle, sir.
So when you're telling us here under oath before this court that you did nothing to assist the defense, you do not think that you making these suggestions on how to better the testimony for the defense, you don't think that's helping the defense?
No.
Okay. You said, not sure if you want to put this somewhere in the direct examination. So you're making suggestions to the defense about what
You're
you
actually
think
saying
would be
he's
helpful
not
in the direct
sure.
examination, correct?
So there were never any conversations between me and Mr. Jackson about what questions to ask, what not to ask.
Just a second. I don't know why the hell that happened.
Defense, not sure if you want to put this somewhere in the direct examination. Weren't you trying to help, sir?
No, Rumble Studio just
I don't believe so, no, sir.
And then when you wrote, I have a feeling they are going to argue I didn't personally inspect the vehicles.
it'll
Who's
be right
they?
back.
Well, it would have been the prosecution in this case.
But you're not taking sides. You're totally objective, right?
Sir, that is a question that's routinely raised when I testify about whether or not we inspected the vehicle. So I know it would be a potential issue that would be raised by either side.
So you were alerting the defense that you thought that this may become an issue, weren't you?
It was more or less to make sure the jury had an understanding that because I didn't physically inspect the vehicle, it did not matter for my analysis, sir. I wanted to make sure the jury understood that.
Don't hide behind the jury. I'm talking about your communications with the defense. I'm asking you specifically about your conversations
He's
with the
telling
defense.
you why he put the note down.
Ask one question.
You wrote, I have a feeling they are going to argue I didn't personally inspect the vehicles. That's what you wrote, correct?
Yes.
Objection, Your Honor. The tone in the argument teacher.
Did you write that?
Yes.
Right. And when you said they, you're referring to the opposition, the Commonwealth, correct?
Correct.
Right. And you offer an explanation or a way to deal with what the Commonwealth may confront you with, don't you? You make a suggestion to help the defense, don't you?
Again, it was to help the jury understand that because I did not physically inspect the vehicle, it did not matter for my analysis. That was the point I was trying to make.
I had enough information from the material I reviewed, so it wasn't necessary. Need to show the jury it doesn't matter in this case. That's what you wrote.
Right.
Yes.
Need to show the jury. That's what I was trying to make sure that point was understood, to the jury.
In your collaboration with the defense, that's not all you wrote, is it? You gave them discretion about things that you should or shouldn't say in front of that jury who you say you want to hear everything. Didn't you?
There were other comments, yes.
If you want the jury to hear everything, you wouldn't be relying on the defense to tell you what to say and not say, would you?
What?
I don't know if I understand your question.
Okay, you'll understand if I read this.
You'll understand
Number
it now.
19.
You'll fucking get
Would
it.
it be fair to say that because you do a lot of nighttime visibility work, your cases frequently involve pedestrians? You remember that one?
Yes.
And then you wrote back, yes, unfortunately, there is a direct correlation between the time of day and pedestrian fatalities. You remember that?
Yes.
Statistically speaking, most pedestrian fatalities occur during the evening and night hours. You remember that?
Yes, sir.
So my specialty in the area of lighting and human factors results in a lot of my cases involving pedestrians. Yes?
Okay.
Yes.
And then do you defer to the defense, not the jury, trying to give the full story to the jury? Do you defer to the defense in exercising discretion on what you will or will not say to the jury back then?
Well, allow me to explain, if you will.
I'm asking you a question.
Well, let me explain.
No, I'm asking you.
answer.
Answer the question first.
Did you defer to the defense on what information they wanted you to put in front of that last jury or not?
I didn't defer to them. The reason for that comment is a few reasons, sir.
Let me read it, and then you can give any explanation you want.
Hold on. Question, Mr. Brennan,
You
and
said-
then you answer, Dr. Wolf.
You said, if you don't want me to say this, that's fine. Are those your words?
Yes. Allow me to explain. Because, for one, I want the jury to have an understanding, again, the jury to have an understanding of my background in lighting and human factors and how it relates to me seeing a lot of pedestrian impacts, right? So I want them to have that understanding. At the same time, I don't want them to get caught up in a statistic that just because there's more pedestrian impacts at night, that this alleged incident must have occurred because of that statistic.
Question 31. Have you been qualified as an expert in court before? And you wrote back, yes. Remember that?
Yes.
And then you made another comment. Do you remember that?
Yes.
I realized in my testimony, I said about 20 times when you asked how many times I've been qualified. You were referring to your voir dire testimony, correct?
Correct.
I misinterpreted your questions, which was my fault. But in looking at my D&T lists, it's 11 trials and 7 depositions. 18 testimonies total, correct?
Correct.
Not sure if you want me to clear this up or just leave it. Wouldn't you want to clear up a misstatement when you realize you had made a mistake? Wouldn't you want to inform the court, I stated qualifications I didn't have, it was unintentional, but it was a mistake?
Well, that's exactly why I put the comment in there, sir.
You put the comment, you didn't put the comment to the Commonwealth, did you?
Again, you all never contacted us, sir.
Did you comment to the court who you made the representations in front of? Did you let the court know that you made a representation that was inaccurate?
Again, that's why I put the comment in there to...
Did you inform the court about your misrepresentation?
No, I did not inform the court.
You relied on the defense and gave them the discretion whether they were going to clarify the record or not. Correct?
But I provided the clarification, yes.
Mr. Brennan, could you move along, please?
As you sit here today, you don't really know how many communications you had with the defense before your last testimony, do you?
For trial one?
Yes, trial one.
I think it's all memorialized in the records and the emails that were produced.
The ones that were produced, but not things that were lost or destroyed or deleted, correct?
Again, there are records, even though the physical texts aren't there, there's certainly records of the calls, incoming, outgoing, as well as texts.
Do you remember when you testified in the voir dire, you were asked that before that morning when you walked into court, you had never met Attorney Jackson face to face?
Correct.
But you met him in court that day, right?
I believe I met him that day, yes.
You were asked whether or not you had ever discussed at trial now, after the voir dire, on June 24th, you were asked whether you ever discussed the substance of any of your testimony. Do you remember that?
Correct.
And so when you shared questions and answers and suggestions by email, was the statement under oath, you and I have never discussed the substance of your testimony. Is that still truthful?
We never discussed it, sir. Again, I sent it to him on my own behalf. There was no discussion that took place between Mr. Jackson about that.
You made comments after this was exchanged.
Made comments.
That was sent with the comments, sir.
And then you were asked whether you had ever been paid by the defense. You said no. You were later paid by the defense, weren't you?
ARCA did send an invoice afterwards, yes.
Did you talk to ARCA about that? About the billing in this case?
I am ARCA.
No.
You submitted your bill? Yes?
Yeah, no, he
ARCA
didn't.
submitted the bill?
Yes.
Yes.
Mr. Klein, he was involved in the testing you did, wasn't he?
Yes.
Why is it that Mr. Klein didn't come in and join you? Who made that decision for trial?
Well, I think it was around, again, when we were talking about those June calls, I think that there was some discussion between Mr. Jackson and myself about Mr. Klein's involvement. And ultimately, he's also an accident reconstructionist. So it essentially would have been duplicative testimony. So we didn't feel, or Mr. Jackson, I don't think, felt it was necessary to call Mr. Klein as well.
That sounds like a little bit more than just scheduling, doesn't it?
I would describe that as logistics, sir.
Logistics. You had to describe what Mr. Klein's role was or wasn't in that report, didn't you?
Again, I went over his background as an accident reconstructionist, yes.
Well, so you only talked about background, and from that the decision was made not to call him, or did you talk about his role in your testing and in your opinions?
I didn't talk about his role, sir. I think ultimately the decision obviously was made by Mr. Jackson, not
I
me.
understand that, but I want to know what the conversation was that led to the decision not to call Mr. Klein. It wasn't simply logistics. What was the discussion you had?
Well, I told him that, again, we're both accident reconstructionists. Dr. Rentschler is a biomechanical engineer, so there would have been essentially duplicative testimony from both of us.
Well, your report's never very clear who did what. Would you agree with me that the report is a general report that has yours, Dr. Rentschler, and Dr. Klein's name on it? Would you agree with me?
All three of our names are on it,
It
yes.
doesn't distinguish who did what in that report, does it?
Correct, but I think it certainly was testified to at the voir dire in the time of trial.
You're right back.
Before the voir dire. When you spoke to the defense, did you explain to them what the different roles were for the different people that led to the decision not to call Mr. Klein?
Again, we went over our backgrounds, and I think from that you can deduce that.
I don't know what that means.
Well, if you're familiar with what an accident reconstructionist does and you're familiar with what a biomechanical engineer does, then you would be able to understand that.
Well, it would be easier to understand if you could just tell us what the conversation was. That's what I'm asking about.
Objection, Your Honor.
I'll allow it.
When you had a conversation with the defense, did you tell them the role that Mr. Klein played in your investigation and in your conclusions?
Again, I told him that we are both accident reconstructionists.
Okay. And he chose you instead of Mr. Klein. Did you say there was a difference between you and Mr. Klein and what you did?
No, again, we were both a part of the testing. We were both a part of the review. So we had exactly the same role, essentially.
Did you tell him that?
No, I told him that we were both accident reconstructionists.
And you remember that's all you said about it?
Yes.
During the voir dire and the trial, did you get to watch any of the Commonwealth's experts?
No, I don't believe so.
Did you ever communicate with the defense about any questions and answers that could or should be asked?
No, but I will note that during the entirety of the first trial, the Department of Justice was closely watching it, and we had certainly a direct line of communication with them that they were giving us and providing us information about the trial as it was ongoing.
Did you ever communicate with the defense about questions and answers to ask?
No, sir.
Did you ever see anybody's testimony at any time during the first trial?
I might have seen a few news clips, but I didn't watch any specifically, no.
Did you ever watch anybody's testimony? Did you ever watch any of the reconstruction's testimony?
No, sir.
Did you, after the trial, spend any private time with the defense?
No, I left town.
Okay. You didn't go to lunches or parties or anything like that?
No, I went straight to the airport.
And, sir, is there any other communications that you've had with the defense that you didn't tell us about outside the text and the phone calls and the signal calls? Or any other communications that you can think of that you had with the defense?
No, sir. I've provided everything I have in my possession.
I have no further questions.
Mr. Alessi, do you have anything?
I sure do, Your Honor. Thank you.
Are we going to get to Dr. Rentschler today or not?
Well, you know how much time Mr. Brennan's.
I'm just asking you.
I hope so, Your Honor.
Okay.
May I approach the witness?
Yes.
Your Honor, may I approach the witness for the document?
Yes.
Thank you. Dr. Wolf, I am providing you with a document. Do you recognize it?
Yes.
What is it?
It is the order for production of records.
And is that an order from this court?
Yes, sir.
And is this the order that you were provided with in response to recent matters with regard to this court and what you should or should not be keeping in terms of records and what you should be producing with regard to records?
Yes.
Could you please read the Excuse me, at this time, Your Honor.
I have it in front of me.
Okay, well, I understand. So if Your Honor has it, I would like to be part of the hearing.
Sure, we can mark it.
Yeah, that's exactly. Thank you.
Exhibit 2.
Thank you. I offered it into evidence, Your Honor.
Okay.
May I allow the witness to have that,
Yes.
please? Thank you. Take it. You're with me, Your Honor.
I'm muted. There we go.
Dr. Wolf, I realize that the court has a copy of this, but I'd like you to please read the first sentence in the indentation at the top after following.
Okay. All records within ARCA's or its owners, partners, employees, or representatives' possession, custody, or control in whatever format kept that reflect or in any way relate to work performed or contemplated and related in any way to billing, payment, compensation, and or reimbursement of any kind in connection with Commonwealth versus Karen Reed.
Did you, and to the best of your knowledge, everyone associated with ARCA comply completely with this order with regard to the records that are requested in it?
Yes, everything I had in my possession and that ARCA had in our possession, we produced.
No further questions, Your Honor.
What I'd like to do is to go back in time
Good
with
Lord,
regard
Leslie,
to
stop it.
your interactions with the United States Department of Justice in February of 2024. Was ARCA under a contract with the United States Department of Justice?
Yes, sir.
Was there a contract number assigned to that contract?
Yes.
Was there an internal number at ARCA for which all time was billed for your work on that matter in February of 2024?
Yes.
Did that contract number that began in February of 2024 ever change in ARCA?
Let me just clarify something real quick. So the original case, when it came in from the Department of Justice, was in the year of 2023. So when that project was opened with the Department of Justice, we assigned a project number to it. That project number from the original case with the Department of Justice remained the same all the way through the trial.
And now let's go from in the trial in June of 2024, correct?
Correct, yes.
From June of 2024 to the end of December of 2024, did that contract number ever change?
No.
To your knowledge, when you were entering time under that contract number for your work, did you understand that that time was going to be billed to that contract number with the U.S. government?
That was my assumption, yes.
Did you have from any time in 2024 any understanding that any of your time that you were entering was to be billed to the defense team in this case?
No, sir.
let's now go to your first
Guys, trials make me want to eat.
interactions with the defense.
Get as fat
As
as the
I
rest of the lawsuit
understand
soon.
it, well, why don't you tell me what was the first date of your understanding of interactions with the defense?
I believe it was sometime in mid to end of March of 2024. Again, that would have been over a month from when we issued our report to the Department of Justice.
Your Honor, may I approach the witness? Thank you. Your Honor, what I have is the entire production that ARCA made. I think it would ease in terms of the.
Sure, he can have it.
Thank you. Use that pursuant to the subject of the Honor's permission to answer any of my questions if you need to.
Okay.
Now, in March of 2024, had your final report been issued, the final report that you prepared for the U.S. government?
Yes, that was issued on February 12th of 2024.
From February 12th of 2024 until you sit here today, has there been any change whatsoever to that report?
No.
Have the conclusions in that report stayed the same since it was finalized for the U.S. Department of Justice in February of 2024?
Yes, and that was testified to at the voir dire and certainly at the time of trial.
Did the defense at any time have any discussions with you about the substance of that report to the United States Department of Justice?
No, we had no idea who the defense was or the Commonwealth for that matter.
And when you took the stand in the voir dire testimony in the first trial, before you took the stand, did you have any discussions with any member of the defense about the substance of that report?
No, sir.
Did you have any discussions with any member of the defense before the voir dire testimony other than discussions about background and qualifications?
Other than, again, some logistics about how to get up here, where to go, things of that nature. But beyond that, no.
Other than logistics, how to get up here, when you were coming, background qualifications, did you have any discussions with any member of the defense of any kind with regard to the report to the U.S. Department of Justice?
No, sir.
Did the defense ever try to get you to improve or change any aspect of the report you had issued to the Department of Justice?
No.
At the time that ARCA was working for the United States Department of Justice, do you know whether ARCA could have been retained by any other party for any aspect related to the February 2024 report?
I'm not sure I understand your question.
In 2024, did the federal government prevent ARCA from entering into any contract with any other party with regard to your report of February of 2024?
So we were, again, because we were still under contract with the Department of Justice, we could not have any other formal agreements, contracts, retainers, anything of that nature, because we were still under contract with the Department of Justice.
Now let's go to the emails that were discussed with you starting with March 20, 2024, and then the subsequent email of March 22nd, 2024.
I mean, this is a lot to just say, and they have to because the prosecution was so thoroughly ass mad. This is a lot to just
Okay.
say
Are you there,
we
sir?
don't
Yes, I
have the
think so.
records. We
Okay.
provided
Well,
everything we
let's
had.
test to
There's
make sure.
nothing else to
March
have.
20, 2024, 10:49 a.m. from Alan Jackson to Daniel Wolf. Do you have that?
Yes.
And that email states in substance, thank you so much for taking the time to get on with the phone this morning. Pursuant to our conversation, please feel free to forward an engagement letter to this email address. I will get that countersigned and returned to you forthwith along with your retainer as required. As of March 20th, 2024, was there any understanding that ARCA would be compensated by the
This is just
defense
how Alessi
for
talked,
any
John.
aspect of current or future work?
No.
Was there any understanding or discussion that ARCA would receive any reward or payment or compensation for any contemplated work with the defense?
No.
The discussions that you had with Mr. Jackson that are the subject of this March 2024 email, were there any inducements to ARCA from the defense?
No, sir.
After that email was received by you, did you have any understanding or expectation of any kind that ARCA would be compensated for any work associated with this case?
No, sir.
What was, briefly, the essence of that conversation that's discussed in the March 20, 2024 email?
Well, if it correlates to when I'm looking back at this phone record log, there was an incoming call to the ARCA main line on March 20th, 2024 at 7 a.m. And that's Pacific Standard Time. So that would have been at 10 a.m. Eastern Time. So that call lasted for 39 minutes. And as I mentioned earlier with Mr. Brennan, I think that was a conversation about Alan trying to get in touch with me, letting us know that, hey, we've received your all's report as part of this federal investigation. You know, how can we go about utilizing you guys to come testify at trial? Can you guys come testify at trial? So, and then as I mentioned, I went over him with our typical, protocol for when a case comes in and a client wants to utilize us to testify, which is certainly outlined in that email. But obviously, given the very unique nature of this case, I had no idea if that was something that was okay, if it was allowed, what to do. So subsequent to that email, I then reached out to the Department of Justice to get clarification on what the guidelines would be to move forward.
I'm going to come back to these emails, but I want to go right to the July invoice from ARCA to Worksman Jackson Firm. So can you locate that? Is that in your production? It's the July invoice.
Yes. I have it located, yes.
Did you ever have any discussion of any kind with any member of the defense team about that invoice before July 12th of 2024?
No, sir. And I will note, I am not a part of the invoicing or accounting at ARCA. When a bill goes out, how much it goes out for, who it goes to, I'm not a part of that at all.
For each and every entry on that invoice, did you have any understanding that the defense team, as you're making each of those entries, any understanding that the defense team was going to be paying for any of that work?
No, again, I think my boss wants to know what I'm doing with my time, right? What am I working on? Am I sitting there twiddling my thumbs, or am I working on a case? So that's the purpose of tracking time, sir.
So can you please describe
My boss got busted
how
for
it
house
is
cocaine,
you
so-
enter time and what it is, what your thought process is as you're entering each of those time entries. Not each one, but just collectively. How do you do it? Why do you do it? And how does that work in your firm?
So again, there's usually just a spreadsheet. Sometimes I'll write it down. Maybe my project manager will enter it. But ultimately, I keep track. If I've got, an 8-9 hour day, right, I'm working on multiple cases that day, right? So I figure out, all right, did I have a telephone call? Did I work on a report for this long, right? So I keep track of my time in a spreadsheet so that ultimately, again, my boss and the accounting department knows what was Dr. Wolf doing on this day, this month.
Let's take the first entry on May 1st, 2024. You see that?
Yes.
Did you have any understanding when you made that entry that the defense was going to be paying for that time?
No.
6/9/2024. Did you have any understanding when you made that entry that the defense was going to be paying for that time?
No.
For any entry on this invoice, did you have any understanding that the defense was going to be paying for this time?
No, sir.
When you're entering this time, if you had any understanding, was your understanding that this time was under the contract with the U.S. government?
Yes, because that's the project number that I put that time towards.
So at the time you're making each one of these entries on this entire invoice, what project number are you billing to, and which one do you have in mind at that time?
I don't recall it off the top of my head. I know it was the project number for the Department of Justice case, though.
Right. I'm sorry. I wasn't asking about the specific number,
right,
but the ultimate client, when you're making each of these entries, who is it?
It's the Department of Justice.
Is it the defense in this case?
No, sir.
Did you ever have any discussion at all with any member of the defense team that this invoice was going to be sent to the defense?
No.
For any entry on this invoice, did you ever have any belief that you were retained or engaged by the defense?
No, and as I mentioned earlier, again, the Department of Justice forbid that. So we could not be retained or in a contract with the defense.
I would like to now go back to the emails we were talking about. Specifically, we left off with the March 20, 2024. I want to now go to the March 22nd, 2024 email. I'm just going to shorthand that, refer to it as the pause email. What had happened between March 20th, 2024 and March 22nd, 2024?
Do you have the tab for that, the email that you're looking at? Sorry.
Tab 1, please.
Tab, okay. Right. So the first email that we were talking about on March 20th, 2024 from Mr. Jackson to myself, it looks like the next email was from me to Mr. Jackson 2 days later, March 22nd, 2024 at 6 a.m. I sent in the email saying, "Hi, Alan. Subsequent to our conversation on Wednesday, the U.S. District Attorney's Office has asked that we pause on any further conversation until we receive additional information from their office regarding our involvement moving forward. I will provide you an update when I have it." So what it sounds like, and from what I recall, is that between March 20th, 2024 and March 22nd, 2024, I had reached out to the U.S. Department of Justice and the U.S. Attorney's Office to get clarification on, again, moving forward with potentially testifying in the case.
And what did the United States Department of Justice tell you?
They said to wait basically until they internally figured it out.
So what was your conclusion from that conversation as to whether you could do any work on this case at that point?
At that point, I didn't even know if we were going to be allowed to testify. I know that from my conversation with the Department of Justice, I knew that there was a great deal of confusion on their end on whether or not, as expert witnesses involved in a federal investigation, if we would be even allowed to testify in the state matter. So their legal teams were trying to, I think, figure out what the road forward looked like.
And were you entering time under that U.S. contract matter in March of 2024?
Yes.
And do you know where that time was being billed to?
It would have been the same project number as the Department of Justice one, right?
That time was not, to your knowledge, being billed to the defense, was it?
No, again, there was through the entirety from, again, when the case from the Department of Justice came in 2023 till the trial concluded, all of the time was put to that one project number.
In March of 22nd of 2024, was any engagement letter sent to the defense?
No.
As of March 22nd, was there any retainer sent to the defense?
No, there was never a contract or retainer sent to the defense in 2024 at all.
So in terms of the discussion in the March 2024 email about engagement letter and retainers, were any of those ever sent?
No, we were not allowed.
And let's go back to that discussion of March 20th about engagement letter, retainer letter. Was that discussion where you were talking specifically about what you were going to do with the defense in terms of that relationship, or was it a general specific type discussion of the policies and billing procedures of ARCA?
Certainly, as is alluded to in the email, I prescribed to him our typical operating procedure for when a case comes in. But again, I remember a part of that call, there was a great deal of confusion about what do we even do from here.
So as of March 22nd, 2024, can you just briefly describe whether there was any further activity at all by ARCA with regard to the defense?
No, I don't believe so. I don't think that there was no communication, I don't think, until about a month later in April, after I had received that clarification.
Now let's go to April. Let's go to the voir dire hearing of April. When you sat on the stand under oath for the voir dire hearing, had there been any substantive conversations about the topics in the February report to the Department of Justice?
No, sir.
None at all?
None.
What briefly were the substance of the conversations you had with the defense team as of the moment you sat for the voir dire hearing in April of 2024?
Again, they were all scheduling, logistics. And when I look at these records here, I see a phone call for 3 minutes, 5 minutes, 6 minutes, 6 minutes. There's a few that are for 1 minute, which I think, again, we were maybe just playing phone tag. But again, these calls are very short in nature. So again, it was just trying to figure out, obviously I know that this was a large trial, a lengthy trial, a lot of witnesses, things are fluid. So I know that Alan ultimately, I think, would reach out to me. And then, like I said, he would give me an idea. Hey, can you come this day, right? And then I would relay that to Dr. Rentschler and say, yeah, that works for me. So that I would get back to Alan. So that's what those conversations were. Again, coordinating our testimony to appear for the voir dire.
It might appear to some that there were a number of conversations before in communications with the defense before you sat for the voir dire hearing. Were those conversations about logistics, background and qualifications, or did those conversations entail other topics?
No, it's what we've covered. Again, that March 20th, 2024 phone call, the very first one of 39 minutes, again, was us trying to figure out what the heck to do. The May 1st phone call, which was 40 minutes, again, was me going over my background, the work that I do, my qualifications, education. Other than that, there are very short phone calls, like I said, of 6 minutes, 3 minutes, 1 minute, 9 minutes, right? And again, that was in preparation to appear in terms of scheduling, logistics, timing for the voir dire.
Yes.
At the voir dire hearing, do you recall the Commonwealth asking you any questions at all about whether you were being compensated by the defense?
I don't recall a single question by the Commonwealth on that, no.
Did the Commonwealth ask you any questions at that voir dire hearing about whether you had any substantive discussions with the defense about your February report to the United States Department of Justice?
I don't believe they asked, no.
Did the Commonwealth at that voir dire hearing ask you any questions about whether you had any promises or inducements from the defense before you sat down for that voir dire hearing?
No.
No. No, the state didn't ask anything, and they're pissed off about it, so they're trying to rely on the judge to get these
Now
guys
let's go
banned because
to-
the judge is biased towards the state.
The next tab, with regard to the
Hey, thanks, Angelia.
outlines that you were asked on direct examination by Attorney Brennan. You've described this situation. Well, you described how it is you viewed this situation. Have you ever been in this situation before where you're under contract with the federal government? There's rules of the road, so to speak, as what you can do, what you can't do. And then you've got a private defense team. Have you ever been in that situation before?
No, I think it's truly one of a kind, and I don't know that that'll ever happen again.
And have you ever been in a situation like that since?
No, sir.
Did that cause you to have more or less communications with Mr. Jackson to figure out what it is you were going to do or not do?
Sure, yes.
In terms of your outlines that you sent to Mr. Jackson, did he ever broach in any way at all any idea of you sending him an outline?
He never asked, no.
Was there even any discussions that you might send an outline?
No, as I mentioned, it's something that for me is customary as I'm preparing internally for trial, right? I'm not going to come to trial, not review anything, not look over my notes, right? It's something that I do internally so that I can have an understanding how do I want to try to answer questions that might be posed to me such that I can have the jury understand how did I arrive at my opinions.
Was it important to you before you sent that email with those outlines? Was it important to you that the jury got a fair and accurate presentation of the work you had performed in association with your February report?
Yes, I think that this is my job.
Was there any other motivation that you had in sending that outline and that email to Mr. Jackson other than making sure testimony was elicited that would make your perspective clear to the jury?
No, that was the only reason.
Were you trying to in any way favor the defense, give the defense any favor with regard to that trial?
Absolutely not.
What was your goal, both with sending the
Inform the
outline
jury. He
and
already
the
did this.
testimony at trial?
I already said this.
What
Come
was
on.
your goal?
Again, as I mentioned, I think it's to help the jury understand the report, the analysis, what I did, what I reviewed.
Did the defense ever ask you to communicate to the jury about any aspect of your report in any way?
No, sir.
And did you, in fact, communicate to the jury what it is you intended to effectuate the goal that you just explicated?
I think so, yes.
And with regard to the comments that were in those outlines, what was your intention in putting in those comments?
Again, is to provide the jury, again, like for example, with the nighttime pedestrian statistic, right? It was to have them have an understanding that I wanted them to have an understanding that I do a lot of nighttime invisibility work, right? So therefore, I see a lot of pedestrian impacts. But again, I don't want them to take that statistic and say, well, we have this alleged incident. There was bad weather conditions. It was nighttime. Therefore, we should give that more weight.
And is that desire of yours in your mind to help the defense more than to help the Commonwealth?
No, it's impartial. And I will note, I give numerous presentations. And I think slide 2 or 3 on presentations I give, it's going over that very same statistic. I would never shy or hide away from that statistic. And I believe I testified to that very statistic or that comment at the voir dire and in my trial testimony.
In terms of after you sent the emails with quals and issues pertaining to direct testimony, did you ever have any communication of any kind whatsoever with the defense team?
No, he didn't. Mr. Jackson didn't even respond. And I think when I sent the direct outline, it was Sunday evening before I hopped on a plane. And I think by the time I got into Boston, it was like 1 a.m. So I didn't even have a chance.
When you took the stand to testify the next day in that trial, had you had one word of a conversation with Mr. Jackson or any other member of the defense team about the substance of your upcoming testimony?
No, sir.
So you went and sat during that trial and gave testimony to the jury without ever having talked to a member of the defense team about the substance of your February 2024 report?
Correct.
Do you recall any member of the Commonwealth asking any questions at all during your trial testimony about whether you had been compensated by the defense?
No.
Do you recall the Commonwealth ever asking any questions at all whether you had communicated with any member of the defense with regard to your testimony while during your trial testimony?
I don't think that was asked. No.
Do you recall any questions from the Commonwealth about whether back in March or any other time you had been promised or induced by the defense? Do you remember any of those questions?
No.
Do you remember any questions by the Commonwealth at either the voir dire or the direct testimony about whether you had had conversations with the defense?
No.
Do you remember any questions of the Commonwealth at all before you sat down and after you sat down for trial about whether you had any text communications with any members of the defense?
No.
At the end of the trial, did you have any understanding whatsoever that ARCA was going to be compensated by the defense?
No.
At the end of the trial, did any member of the defense ever say to you, we're now going to compensate you for any of your work up to the time of your trial testimony?
No, and the records certainly reflect that I never spoke to Mr. Jackson after the trial in 2024. There was no conversations between us.
Well, let's go beyond Mr. Jackson. Let's go to any human being. Did you have any discussions with any human being as to whether the defense was going to compensate you for any work, travel, expenses, disbursements that you had or incurred up to and through your trial testimony?
No.
And at that time, were you still under contract with the United States Department of Justice?
Yes.
Now let's proceed to December of 2024. Were there any conversations from the end of the trial until December of 2024 other than logistics? Was there any conversations of any kind? And please summarize briefly what they were. Or texts.
The only communication I had with the defense was Mr. Jackson. After I took the stand, I think that he sent me a text just thanking again for my time traveling up here. I said it was great, and then we left, and that was it. I did not communicate with Mr. Jackson for the remainder of 2024.
Yay.
Now let's go to recent communications. In 2025,
I don't know how many times like he has to establish that he
any
didn't talk about this.
with any member of the defense with regard to the potential? Well, let me go backwards. Let me go to the invoice. Let me go to the July invoice.
Okay.
how did you learn that that invoice was paid? If you learned at all, how did you learn that that invoice was paid?
I didn't learn. I didn't know that it was paid. I didn't even know it was sent.
Dun, 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 dun. I didn't know.
Now let's go to this year.
I thought we were already at
the
this year.
defense approach ARCA to see if they might be able to testify in this trial that's currently pending?
Yeah, I mean,
well, I think that the first communication
problem is the judge is
of
going to find a
2025 that
discovery
happened between
occurred.
myself and Mr. Jackson
And all this is
was
going to be for naught.
in February 13th of 2025. There was 2 calls, 25 minutes and 5 minutes, but it looks like just because there was a disconnect. So it was about a 30-minute call with him in February of this year.
And what was the substance of that call?
Well, I think back to that time frame, I became aware that I think that there was a motion or two regarding ARCA and potentially excluding our testimony for the upcoming trial. I also know that around that time, unfortunately, I ended up getting a significant amount of harassment
because of the federal
through
involvement
emails,
here,
and unfortunately, even spread into my personal life where my wife was affected. They were posting pictures of my 4 kids all over the internet. So
appellate issue if the judge.
It was somewhat of a difficult time on my end,
them.
and I think what prompted me to reach out to Mr. Jackson was to figure out what's going on. Why is my family all over the internet? You know, why are they talking about me? Why am I getting all these hate emails? So it was I think a conversation to figure out, hey, you know, there's been several months that have passed. It looks like there's some motions pending against us. I'm getting a bunch of harassment. What's going on?
Do you have an understanding of why you
after
were
this.
getting hate mails, hate emails, hate communications, your wife, your children? What did you conclude was the reason why you were receiving that?
I honestly don't know. I presume it was about comments made to me in court or that were represented about ARCA or myself.
So just so I'm clear on that, it was, you believe, regarding comments about ARCA and whether and what? Can you be a little more specific what your understanding was?
Well, I know that I received several emails that, you know, insinuated that I perjured myself on the stand. Like I said, and a lot of hateful comments just about me and the work that I do. So I received several emails with respect to that.
Sir, do you believe you have ever made an untruthful statement at all with regard to this matter?
No, sir.
Have you done your best to try to provide accurate and truthful information in this matter?
Yes.
Now to the last part, which is, did the defense contact you with regard to potential further work? I want to separate out now and move on from the work that you did with regard to the
pause for patrons.
US Department of Justice,
I think
your February
the state is relying on the bias
report.
of the judge.
We went all the way through the trial in that matter. We went to the end of 2024. Now I want to
really
come
need
to 2025
to win this
in a
case
different
through
subject
lawyering
matter,
because they
which
don't.
is communications with
They
the
don't have it
defense
on fact
about doing further
law at the
work
moment.
for this trial.
Yes.
What was the nature of the communication? And so we can move through this rather quickly, but importantly, I want to get it complete and accurate. Just describe what the communications were on a timeline basis, subject matter, and with regard to your understanding of why you were contacted.
So subsequent to that February 13th call, as I mentioned, Mr. Jackson had indicated that he preferred to utilize Signal to communicate. So we exchanged a few messages and phone calls on that. Like I said, they were rather short.
I'm going to interrupt you for there a bit. Was there any discussion about the reason for Signal because the prosecution had been subpoenaing the phones of Mrs. and Dr. Reed, subpoenaing and seizing the phone of Miss Reed, that phones of defense attorneys had been requested to be looked at? Was there any understanding in your mind that there was a need to go to Signal to protect the defense and the integrity of the defense?
I didn't know that was happening, but But like I said, I did not have a problem with communicating. To me, it was just another messaging app. I know people use all different types of applications, so I didn't have a problem with it.
Was there anything
like,
in
I
your
usually
mind
message my
nefarious
friends
or
through OnlyFans.
underhanded about using Signal?
No.
And my understanding is this is
Like
the
long
first
distance
time
pay per minute.
you used a Signal app with regard to a matter professionally. Is that correct?
Correct, yes.
Did you get any understanding from communications with the defense that there was anything at all untoward about communicating through Signal?
No, I was not aware of any issue with using that communication.
Was there any communication whatsoever that you can recall on Signal that you have any concern about as you sit here today?
No.
And what were the majority of the communications, as best you recall, with the defense on Signal?
Well, as I described, I know that at that point, and like I said, it was primarily confined to a pretty short window in March, but Mr. Jackson had indicated that around that time, I think ARCA was being litigated by this court in terms of our involvement in the case. I know that they had started to, I think, receive discovery as it relates to the Commonwealth's accident reconstructionist and biomechanist. So they were, I think, interested in utilizing us potentially in the second trial. So I think that they had submitted a letter to the U.S. Attorney's Office to try to be able to work with us. I said that on my end, I could reach out to them because I hadn't heard from them in months. So I think it was around mid-March, I had reached out to the U.S. Attorney's Office to try to get my own clarification on whether or not we could move forward.
All right, so I want to stop you there. I apologize for interrupting you, sir. But what was the date that you reached out to the U.S. Department of Justice to see if you could participate in the second trial?
Probably around mid-March, maybe March 18th, March 15th.
Did you have an understanding at that time that the Commonwealth had retained an entirely
Still don't
new
trust this Fed.
firm and expert in the area of accident
I
reconstruction?
don't care what anybody says.
I think Mr. Jackson had indicated that there had been some material disclosed, but I think it was just a simple report or something of that nature at that point in time.
Was it a report, just like a page and a quarter or so of findings and conclusions and then a slide presentation? Is that what it was?
Yes, that sounds right.
Was any of that information at all helpful or meaningful to you in your ability to respond to that and to determine what was done and what ARCA might want to do in response?
Well, certainly not the report. The report was very, very brief. The PowerPoint, somewhat hard to follow, but again, it really didn't provide a complete picture.
And in terms of scans, electronic data, etc., do you recall when you finally got that information?
Well, I think that would have been after the defense officially retained us on March 26th. I think that's when we received that information.
So in terms of the information that you received, those scans, etc., did that allow you to proceed with any meaningful work?
Well, it gave us, again, a better insight into the foundation or the basis for the analysis, yes.
Could you have proceeded with a contract with anybody, not just the defense, but anybody, with the level of information you had before you got the scans and the data?
I think it would be very difficult to do so.
Could you have even created a scope of work based upon that report and that PowerPoint presentation?
Most likely not, just because some of the areas that Dr. Rentschler and myself are particularly interested in are extremely vague in that report in PowerPoint.
Once you got
you're not even convinced me that this Fed is
information
trustworthy
that you have
because he's
now,
handsome. Not happening.
what is the ordinary time
He's a
it
handsome
would
fella.
take in the regular course of ARCA's business to evaluate
Got murder eyes
that
right now.
information and prepare
licked his-
your own report, analysis, and finding? In the ordinary course, how much time would it take ARCA to do that?
Well, certainly for the nature of this case, as I mentioned, we were officially retained by the defense on March 26, 2025. As I mentioned, I myself just got word from the Department of Justice just a day or two, I think, prior to that we could move forward. So immediately, once Mr. Jackson I indicated to him on the 26th that we did have authorization to move forward.
Tommy,
he
I
immediately
need the
asked
whole
that I
call.
send over, again, our typical procedure with the contract and retainer. And I think that same day, at the 26th or the 27th, his office sent over, I believe, links to notices of discovery, I believe 1 through
great speaking
62,
voice,
which I think
too.
encompassed about
Makes me
800
self-conscious.
gigabytes worth of information and
Lower
data.
my
How
tone.
much in relative term, 800 gigabytes? Is that a little data, medium amount of data, or a lot of
It's
data?
a medium about a data.
Voluminous, a lot of data.
Ooh,
So
voluminous.
we immediately started
That's
to
what he
review
calls
that.
his
And
ex-wife.
again, I feel like maybe I speak for most experts. One thing we always want is more time, right? So in a case like this, I mean, ideally we would be talking months to be able to sift
Alita, it
through
looks
all
like
of that
Robbie
information.
from American Beauty grew
be able
up,
to do
became a
analysis,
fed.
be able to do testing, be able to write a report, right? So I think certainly we are on the order of months, not weeks.
What did you do, however, if anything, to try to expedite the work and get it done as quickly as you could once you got the level of information you had from Aperture?
Certainly. So I certainly understood that the trial was imminent. So I worked as quickly as I could along
I had
with
to
Dr.
drop an
Rentschler
American Beauty
to review that
reference.
material and certainly in parallel try to determine, okay, what testing do we need to do to effectively evaluate and potentially come up with opinions for this case?
Did you put other work aside at ARCA to work on this matter?
Absolutely. Work and personal things.
And personal things. What did you put aside? Just one example.
So the other week, my wife and I, we celebrated our
Conception of his
10-year
children.
anniversary. So
So it affected his personal life, I understand.
Okay, I'll move on, Your Honor. With regard to the work, you performed it on an expedited basis, as you said. You shortened the time period down as much as your firm possibly
I've
could.
already
Is that
tasked
correct?
Ryan with
Correct.
creating an Alessi voice.
You said you would like to have had more time, correct?
correct, but I understood Your Honor's order and I wanted to beat that deadline. So I worked as quickly as I could over the last week to ensure that, again, we could respect that deadline and we completed our testing.
And with regard to the testing now that you worked on that you just described, does that testing relate to any previous work, or is it all in response to the new expert for the Commonwealth, Aperture, and the new information from Aperture that came in iterations through the month of February?
It would be in response to Dr. Welcher's work. Certainly, much of what was alluded to in his report and PowerPoint was not discussed in the first trial.
Could you have done any of the work you've been working on the past month or so? Could you have done any of that work without receiving the Aperture report and slides and scans?
No, I don't even know what we would be responding to then.
So you needed the Aperture information before you could even start working, correct?
Correct.
Do you have in mind, or does ARCA have in mind, any further testing that you need to do, or have you completed what ARCA needs to do with regard to fairly and properly responding to the new work of Aperture?
I think we're satisfied that we've completed that testing, yes.
And what, if any, more work do you contemplate that needs to be done from, as you sit here today, going forward?
Well, as I mentioned, all the testing is done, so I think the analysis and the report to follow, yes.
To use expert engineering type terms, is it QA/QCing the report? Is it putting all the information together in a compilation so everybody can understand what you've done and make clear your findings and conclusions? Is that what's left to do?
Yes, and I will note, obviously, as the court is aware, we've produced all of that raw test data, photographs, video. So it's all there. The basis and the foundation for what the report will lay out has all been provided to the court.
You got ahead of me, and thankfully, so that my next question, which is, there's nothing that you have that you've done that hasn't already been produced to pursuant to the court's order. Is that correct?
No, I think that we've responded to the court's order, yes.
How long on an expedited basis. Well, let me ask you, in the ordinary course, how long would it take you to do this last part of your work in the ordinary course?
Probably, again, it can vary. Maybe around a month would be fair.
However, it would take a month in the ordinary course. How quickly can you get that work done fairly?
I'm hoping if it pleases the court, hopefully May 7th will work.
And so you believe everything would be completed by May 7th?
Correct.
Where you are. That's all I have at this point, Your Honor.
All right. Mr. Brennan?
There really shouldn't be much left. There's, on the subject, they're voir diring him because of alleged discovery violations. They believe that the ARCA people have withheld communications from the defense.
Doctor,
they said we don't
suggesting that
have
it's
them
going to take
anymore.
until May 7th for you to complete your reports in this case?
May 7th.
And the analysis, yes.
Do you know when this trial started?
I think like a week or so ago.
You provided raw data last Friday,
Raw data.
Yes.
but you would agree you still have not provided any reports.
Correct.
This guy thinks any place with a salad bar is fancy.
You said if you were notified or received information, you could have your testing and opinions done within a month, correct?
Potentially. Again, it would also depend on when we got authorization from the Department of Justice, which, as I mentioned, was at the very end of March.
I understand that. We're going to talk about that separately.
Well, we're
I'm
going to talk
talking
about it.
specifically about how long it would take if you received the information. You said that you could have the testing and reports done in 1 month, correct?
I don't know. I said the testing, the reports, and everything.
Would it take longer than a month?
Ideally, I think it depends on what kind of a report that we're talking about. I think if it's something along the lines that Dr. Welcher produced, I think it could be pretty quick.
You said March 26th is when you received authorization, and you're going to have things done by May 7th. So that's a month and a week?
Sounds about right.
Okay. Do you know when the Commonwealth in this case turned over Dr. Welcher's information to the defense? Do you know?
I don't know, no.
Did you know that it was turned over in a report on January 30th?
Just the report?
Yes.
I didn't know that,
And
no.
the file in its entirety was turned over by February 5th? Did you know that?
Avi was trying to.
Do you know that?
I don't, Your Honor.
And if you had a month from February 5th to complete your testing and report, you could have been done by March 5th or even the second week of March, couldn't you?
Presuming we had authorization, the defense had authorization from the Department of Justice as well as ARCA, yes.
Putting aside the authorization, I'm going to ask you about that. But just the time you need to test, if you knew or received the information by February 5th, you could have been done by March 5th or mid-March, couldn't you?
Potentially, yes.
Well, you're going to get it done that quickly now. So wouldn't that be an accurate guide to when you could have done it then?
It's certainly not ideal, but we certainly are working as quickly as we can.
I know it's not ideal, but isn't it the same time frame? Whatever
Isn't
it's
it
gonna
good
take
to
you from
not have
March
ideal
26th,
results?
You could have done from February 5th. True.
Again, I don't know the timeline in terms of what exactly was produced when from Dr. Welcher, so I'm not aware of that.
But I'm not asking about the timeline. I'm talking about the time.
You are
needed
asking about
to
the
deal with this
timeline.
Information you said you could have done in around a month.
I think a month or more, yes.
So your contract with the federal government ended, ARCA's did, in June of 2024, didn't it?
I believe it was sometime last year, yes.
Do you know the Commonwealth notified the defense that they were going to have a new expert back in October of 2024?
No.
Are you aware of any effort by ARCA or the defense to try to facilitate an agreement that the defense could use ARCA as witnesses back in October or November of 2024?
No.
Are you aware of any efforts by the defense to try to notify the federal government to be able to use ARCA in December or January?
No.
And so as far as you knew, this came out of nowhere in March that the defense wanted to use ARCA, or specifically you and Dr. Rensselaer, in late March of 2025.
No, I think, again, it was, like I said, around February of 2025. I know that, like I said, when I spoke to Mr. Jackson, that he had indicated that the ARCA issue was being litigated. And I think that like I said, there was, I think, multiple motions pending against us, and he didn't even know if he could move forward with us at that point in time.
Do you know why the defense waited until February 2025 to even seek permission from the federal government to retain you and Dr. Rentschler so you could review the materials?
Objection, Your Honor.
Do you know? Do you happen to know that?
I don't know, no.
Next question.
You shared with us communications you had with the United States Attorney's Office. Were you receiving information in this case since the last trial from the defense or from the United States Attorney's Office?
What do you mean with respect to information?
Evidence, discovery, information.
From the Department of Justice?
Anybody?
No, not until recently, no.
So you haven't seen any discovery until after February of 2025. Isn't that fair to say?
Correct.
Now, when you were involved in this case before trial last year, we talked about your communications and conversations with the defense. Was anybody giving you information as an intermediary? Was anybody updating you on the defense of the case or giving other information to you?
Yeah, I think I previously testified that the Department of Justice was closely watching the trial and providing us information.
What information were they providing you about the trial?
I think that they provided information regarding the some of the witnesses that had testified with respect to, I think, the reconstructionists, and I think some of the evidence.
So when the Department of Justice was giving you information during the trial about witnesses, what witnesses do you remember they were giving you information about?
One that comes to mind was, and I don't even recall his name, it would have been the accident reconstructionist.
Is it a coincidence that when you were receiving information from the Department of Justice about particular witnesses testifying in this case, is it a coincidence that your phone calls and text messages are more frequent?
Is it a coincidence?
Yes.
I presume so.
Well, when you were receiving information from the Department of Justice about witness testimony in this case, was that part of the catalyst for you to either call or text the defense and ask questions?
No.
Did you ever share any of the information you received from the Department of Justice with the defense?
No.
When you were receiving information from the Department of Justice about witness testimony, that was before you testified, correct?
Correct.
And part of that, when they were giving you information, did they ever give you any live video?
No. It was just verbal communication.
And they were giving you updates and summaries of testimony?
I wouldn't say summaries. They just pointed out some key things I think that came out.
What were the key things they were talking about with the reconstructionist testimony? What were they telling you?
I think it was as it relates to the arm being outstretched, and I think some of the kinematics of the pedestrian. I also think there was some mention of potentially some DNA evidence.
And is that how at trial, even though you had no evidence that was produced as part of your report or to consider for your report, that you knew that there was DNA evidence because of the intermediary?
Because of the Department of Justice?
Yes.
Yes.
Did you know there was a sequestration order in this case that you were not supposed to consider or review other witnesses' testimony or information? Did you know that?
I was never made aware of that.
Nobody made you aware about a sequestration order in this case?
No.
But you did, in fact, receive information about other witnesses' testimony before you testified in this case in front of the jury, didn't you?
From the Department of Justice, yes.
What other witnesses were you advised about their testimony and issues in this case before your testimony in this case?
First of all, it's cumulative testimony.
That's all I
it's
recall.
Pointless. It
Well,
does
you said it was
not.
more than one. You said
None
some
of
witnesses.
this testimony
Take a moment.
indicates
Think back.
undue
What other
collusion
witnesses
going
stand
on,
out
or
that
even
you
a
were offered
discovery violation
information
in the first place.
from the Department of Justice about this case before you testified?
As I mentioned, I don't know which witness provided the DNA information, but I would presume that that's the other witness, yes.
So you heard information, you learned that there was information and testimony about DNA.
Yes.
And certainly when you took that information before you testified, you considered it when you testified, didn't you?
No, because again, our report was already solidified, so it didn't change my opinion in any way.
Well, not about whether it changed your opinion. You testified about DNA, didn't you?
I don't believe that I did, no.
I'm going to approach, if I may, Your Honor.
Okay.
This is your outline with your comments. Do you recognize this?
Yes.
I'd like to introduce that as an exhibit, please. Thank you.
Exhibit 3.
So as an expert, when you receive information, you need time to look at the raw data, don't you?
Potentially, yes.
You need time to look at the report of another expert, don't you?
Potentially.
And then you got to consider whether or not you think that their testing is accurate. You can test their testing, can't you?
You can, yes.
And you can also generate new tests based on what you've read if you think that there is some explanation needed. Yes?
Perhaps, yes.
And then you can write a report.
Yes.
So it's fair to say when an expert introduces new information, testing materials, it takes about, if not at least a month to process through that information, vet it, and then consider your own testing.
Well, if they've already authored a report and done their own testing, that should be solidified and memorialized already.
Well, if there's new testing, if a new expert does something new and an expert wants to look at it, you would agree to sift through that much information and consider and vet it and then do independent testing. It could take over a month, couldn't it?
If it's necessary.
And it would be the expert that determines whether or not that was necessary, wouldn't it?
Sure.
And if your report is not due until May 7th, is that what you said, May 7th?
Yes.
May 7th. It could take an expert, if they wanted to do testing based on new testing that you provided, over a month, couldn't it?
It depends. I can't answer that.
When you wrote that initial report and you provided the report, how many pages was it? 10, 12 pages?
The original DOJ report?
The report that you produced in this case with your opinions, yes.
That sounds about right.
Okay. You never gave the raw data for that report, did you?
No, it was all protected.
It was all what?
It was protected. It's classified.
Have you been asked for it? Has there been a request made for all the raw data that formed the basis of your opinions, of those initial opinions?
My understanding from communication with the Department of Justice is that all communication and work product is protected and cannot be disclosed.
So that raw data that's necessary to you for your evaluation and your testing, that wasn't provided in this case, was it?
For the first trial?
Yes.
No.
And videos of the demonstrate, you built like a potato cannon, right?
I'm sorry, what?
Potato.
You build like a potato cannon.
If that's how you want to characterize it, sure.
Okay. Did you take videos of it when you were doing your demonstrations and tests?
Yes.
You post them to your
those
Instagram.
videos, did you?
Again, we're talking about trial one. As I mentioned, for trial two, let me finish.
Trial one. So
Okay.
no, I want you to focus on.
Okay. No, that
trial
was
one.
not produced. No.
Never turned over any of those videos, did you?
Again, we were not able to.
And was there any failed testing the first time around?
No.
In addition to videos, I'm sure you had other raw data, notes, photographs, right?
Yes.
And so when you look at a report, so for example, you saw Dr. Welcher's report and you had access now to his file and data, correct?
Correct.
You reviewed that, didn't you?
Yes.
Because to be fair, you need to review not just the report, that's just someone's opinion. You need to review the raw data, don't you, to get an accurate understanding of an opinion?
Right, which we have already provided
Right,
in
so-
response to Dr. Welcher.
Without video and without the raw data,
Without video.
as an expert, there's no ability to really vet the reliability of your first experiments that led to your testimony in trial one, is there?
I think you might be confused. Again, our role for this round.
I don't think I am.
Objection, Your Honor, you should be allowed to answer.
I don't think I'm confused. I'm talking about trial one.
Right.
You had a 12-page report. You provided no video, no raw data, no notes, correct?
I only like my
Correct.
data
But
raw.
for this trial, sir, we are being asked to respond to Dr. Welcher.
That's
Okay.
not what I'm
We
asking
have
you.
provided everything that he would need to evaluate the testing that we have done.
That's not what I'm asking. What if he wants to evaluate the testing you did the first time? Are you going to come into court? Do you hope to testify about the opinions you gave the first time? About those 4 opinions?
I don't know what the defense's plan is for us. My understanding is that it's to evaluate and respond to Dr. Welcher.
All right, with that, I need to see counsel with that.
So this judge should have put a stop to this testimony a long time ago. It's clear that they have nothing on some sort of undue collusion and that they just don't seem to have the discovery that they're accused of having. Now, they're accused of having it, but they haven't produced anything to suggest that they actually have it. No evidence. It's just, well, there's more emails out there. There's more text messages out there, and you need to give them to us. And they're like, "What? We can't." because they don't, like, they're not actually there. I don't know if you know what deleting means, but they're not there. So they have to, or the judge should be putting a stop to this, because right now he's just bullying the witness. There's no purpose to it. Oh yeah, who'd you talk to? Who'd you talk? He sounds like a fucking detective from like a 1950s cop movie, right? Like, oh, I'll tell you who you're talking to. You're talking to 9 minutes? 9 minutes? You got 9 minutes for this? It's like, come on, man. This is ridiculous. You on the phone? You on the phone 2 minutes? You're on the phone 3 minutes? Another time? What'd you do in those? That's 5 total minutes. You combine those together, that's half a conversation easy. It's like this is ridiculous. Now the jury's not in there. So he's performative for the judge in this way. And he thinks that the worst thing is when you watch someone be performative and you realize who their audience is and you go, they think this will work. And the reason he thinks it'll work is because the judge has been favorable to him through an entire trial. Now they're going after another one. But it's
You're all set. And let's bring Dr. Rentschler in here, please.
Thank you, Your Honor.
okay. So he's good, I guess. Now we're going to have the next doctor. You're going to get the exact same thing.
Thank you.
Gates of above says, a request to get an lessee to the super tips. It must be required to use only caps lock when using his voice. Bifron says, check out Dolly Talk for daily live court streams. From one Adam, Auntie Bev will rule against the defense. She always rules for the prosecution. And B, thank you, Nick, for subjecting yourself to Massachusetts bullshit. Blue Varro says, it would be like me calling Nick as a lawyer for an hour, but never.
All right, Dr. Rentschler, this is going to be very quick.
Nick is going to bill me for
Go
an
ahead,
hour.
Mr. Brennan. We
Well,
just need his name.
I wouldn't.
Good afternoon, doctor.
Good afternoon.
Could you please state your name
I
for the
would've
record and spell it?
Practice.
Dr. Andrew John
Izzy, welcome to
Rentschler,
Paralegal Status.
ANDREWJOHNRENTSCHLER.
You've testified before in this case?
I have, yes, sir.
That was a lot of fucking
voir dire
letters.
in a past trial?
That's correct.
Did you have conversations and communications with the defense before your last testimony?
I did, yes.
Did you use text messages?
Kind of looks like the villain in an
Communicate?
Adam Sandler movie.
I believe there was maybe one text message.
How about phone calls?
There was maybe 1 or 2 phone calls, I believe.
Okay. Would it be fair to say there was 6 text messages?
Fair to say.
you?
6 whole
Yeah,
text
I
messages?
believe I sent one, and then there were 5 sent to me.
And were there 23 phone calls?
No, I don't believe so.
Have you looked at the records outlining the phone calls that supposedly you made to the defense?
I looked at the records from the defense, but then I looked at my own records, which indicate a different number, only 3 phone calls, I believe.
Okay, so the 23 phone calls that are summarized, you don't think you made those phone calls?
No, if you look at them, it's like 1 minute, 2 minute, 3 minute. And in that time period, according to my phone records, I have like a 21-minute phone call that encompasses most of that time.
Did you discuss with the defense before your testimony anything about this case?
I don't believe so.
3
No.
phone
You
calls.
say you don't
but it's
believe so.
worth
Do you remember
23.
speaking to them about this case at all?
I remember speaking about my qualifications and my background, and I believe that's it.
Did you ever use any other medium to have conversations with the defense other than text or emails or phone calls?
Yeah, Shooter McGavin.
No,
there
sir.
you go.
Did you ever communicate with them on Signal?
No, sir.
Why not?
There was no reason to.
As an expert, when you communicate with clients, there's no concern about having it in writing, is there?
So when I
Keeping a record, whether it's a phone call or a text message or an email, there's no concerns when you're dealing with clients having a record of that, is there?
I don't believe that ARC has any specific policy for that. No, sir.
Did you keep track of your hours prior to your testimony?
I did, yes.
And before you testified, did you have conversations with people from the Department of Justice about this case?
Yes, I did.
Did they inform you about witness testimony?
They did inform me, yes, about testimony and situations and events that came forth in the trial that I was not aware of.
Who decided whether it was going to be an issue worthy of talking about before trial?
With the DOJ, you mean? Well, that certainly that would have been up to the DOJ. I mean, I would have had conversations with them. I don't believe that I asked or requested anything, but they would call to update us about what was going on.
Do you know why they were calling and raising certain issues with you?
I do not know, no, sir.
And by calling and raising issues and telling you information, even if you weren't requesting it, it helped prepare you for your trial testimony, didn't it?
It would certainly help prepare me to understand what was going on during the trial, yes.
Did you know there was a sequestration order, that there was supposed to be no discussion of testimony and issues that were occurring in the courtroom before you testified?
I'm going to allow it. Were you aware of that, sir?
No, I was not.
Okay.
After you testified, did you, before you testified, did you get a chance to meet anybody from the defense?
Just when I came at court, I think for the voir dire is the first time I met anybody.
Did you just spend time with the defendant and the defense after your
The
testimony?
sequestration order with your expert is insane.
Well, after my testimony at trial on the 24th, yes, I was provided a ride back to the airport, and I believe I was the last witness. So before my ride to the airport, they said, there's a lunch next door. We need to get somebody else to take to the airport. Come over, have lunch. I had lunch, stood in the corner, and then got a ride back to the airport.
Spend time with the defendant and her family?
Oh, they were certainly there.
Did you talk to them?
Well, they talked to me. As I said, I ate my lunch, and then I actually went and stood in the corner, and then I believe some people came over to talk to me and approach me.
So you spent some time with them?
Certainly, yes.
Okay. And, sir, I understand the report is not going to be ready until May 7th or after?
I believe currently that's what the estimated deadline is, yes.
And so in evaluating Dr. Welch's materials, you want to look at the raw data, the conclusions, the findings, the PowerPoint, all the materials, right?
Yes, you'd like to review all the materials before coming up with an
You
opinion.
make a decision on what you think is appropriate to contest or maybe agree with, and then do your own test if necessary, correct?
To be able to respond to what those opinions and allegations are, yes, sir.
And it's taken you at least a month to fairly do that, hasn't it?
Well, I believe that's what we've had, a month. I don't know if it's taken us a month. That's basically all we've had up to this point to do that.
And it's still not done?
No, not yet. That's correct, sir.
All right. Is that it, Mr. Brennan?
That's it, thank you.
All right. Can you get that report and everything completed before the 7th? If I order you to do so?
If you order me to do so, I mean, I could certainly try and expedite that.
All right. I appreciate that. Thank you very much. You're all set, sir.
Thank you, Your Honor.
All right. I want to see counsel at sidebar for 1 minute.
So there we go. He's ordered to do it faster, or will be. Kind of seems like a trap. This guy's going to pull some long nights to get it done. I imagine Bev is going to put an order on it, but she's going to say, that it needs to be provided, and then they'll address the issue of whether it's admissible.
That's it. Thank you.
In the future.
All rise to the court, please.
Goodbye.
Hey. There we go. Well, that's the end of trial for today. Got 1 second here. Let's see. So I was just tweeting what I was thinking about, waiting for them to finish talking. And I don't know, the worst thing about trials like this is when you realize that the state is content to deprive someone of life and liberty with good lawyering rather than good law or good facts. And that's what you see happening here. Remember, the purpose of trial is to find the most appropriate balance between maximizing the amount of information available, cutting down the amount of excess noise that surrounds an issue, so you can find the most likely representation of what happened factually, and then marry those facts into a legal analysis. Did Karen Reed hit him with the car? If she did, was it intentional? Was it reckless? Whatever it is, like, did these things happen? When you have a case like this, where there core argument appears to be that she said she did it and that she was conscious of her own guilt. And they're lacking in their forensic analysis. And when their forensic analysis is challenged by another federally recognized forensic team that was available to both the prosecution and the defense, and the prosecution fights vehemently to exclude the facts from this forensic team. And again, this is a forensic team used by the federal government in criminal investigation and was equally available to both parties. But their analysis doesn't match up with the state's case. And so the state is looking to exclude these experts, not bring in more facts from a highly qualified and recognized company, not to bring in more facts, not to bring in better data, but to exclude facts from the jury's access to them. Because
Hey, what's up, money? Hi. Thank you.
I don't. Nope. Don't need any more trial coverage. Get the hell out. Be gone. But you have this question, and personalities are involved, and it's a contest, right, for these lawyers. But like, these people's lives on the other end of it, and their deaths, and the destruction of what they've built, and the destruction of families, the destruction of careers, anything, all of it is baked into the system. Putting people through that is one thing. Putting people through that and convicting them based on crafty lawyering, effective strategy, rather than facts and law, is offensive to the notion of liberty. It is not the purpose of the court system to find convictions, but it has become the purpose of state prosecutors to find convictions. That's not why you exist. You exist to prosecute when the evidence is sufficient. And we've gotten away from what sufficient evidence looks like, what the standard should be in principle, not what it is in practice, because it is something lower than beyond a reasonable doubt. It is something lower than probable cause. The criminal justice system so heavily favors the state, even though we have all of these alleged protections for the defendant. They don't actually apply. They're not employed. They're not employed in the way they were designed, and they're certainly not employed favorably to the defendant. The defendant is put in a position of proving their innocence rather than the state being put in a position of proving the defendant's guilt. We can pay lip service to a right, but if the right isn't respected, then it's irrelevant. You have the right. You have the right to a presumption of innocence, and you're presumed innocent. Get arrested. See how innocent you're presumed to be. There's no presumption. There's no waiting. There's no hearing before you're guilty. And they bring you into court in your orange jumpsuit or whatever, and you don't feel innocent at all. And then you're restricted in some way. You don't feel innocent. Karen Reed's been under this. I mean, she's an alleged murderer. It's not like she's out gallivanting around having a great time. She's under it, man. She's under, even if she's not under actual scrutiny, she'll be under practical scrutiny. People in her community, the police, the prosecution, they'll be watching everything she does, anywhere and everywhere. So to have all of that, and then at the end of the day, imagine you're accused of a crime and they just can't get the evidence, but you said something and they got your statement in a crafty way. And then someone else did something and they used that to show that you're conscious of guilt. And then when you try to bring in experts to disprove the obviously shoddy forensic analysis of the state, they get the judge to prevent the experts from testifying based on alleging discovery violations and telling the judge that they didn't provide something that they couldn't provide because it doesn't exist. That's good lawyering. It's great. I just don't like putting people's liberty to test on good lawyering. I want the state to bring a good case, not have a good lawyer. So anyway, that's just my little ranting shit. Mephisto says, sounds a bit personal there, Nikki. I mean, again, I pled guilty to my case. There are legal things that I definitely believe that the state didn't measure up on probable cause on the warrant. I believe the discovery may not have been fully provided to me about what led up to that warrant based on statements from the state. But hey, I have to presume that they complied with discovery, or I have to challenge it. So, you know, I mean, was it good lawyering that won? No, I mean, it was me pleading guilty. might have had some not sufficient lawyering on my end. I mean, my attorneys had a strategy. That strategy didn't work. That's the way it goes. You hire someone to run the legal strategy for you. So what the? And it didn't work out. I don't know that means that my rights shouldn't be observed or not. But hey, again, actually that issue is still appealable, I believe. But that being said, like I did my crime, right? Like I did it. I pled guilty to it. I'm going through all of that. So it's not personal in the way that I'm describing it, but the refocused attention that I have towards that issue is personal. That's, when something happens to you, it kind of kicks your attention in the ass. It says, hey, pay attention to me in this way. And you go, oh yeah, yes, these principles that I've talked about are actually real. They actually apply and they actually suck. Like that's the way it's personal for me. Again, I did the thing. You won't catch me saying I didn't have a bunch of drugs in a safe in my bathroom. Did that. That happened. That's done now. And I'm paying the penance for that. But watching people like Karen Reed go through it, hers is a murder charge. Like it's good night. See ya. She will not get probation instead of prison. She'll go to prison, even though it's I believe it's like a reckless indifference or whatever murder, but she'll get prison time. There's not really any way around it. She's not going to get probation and get out of it, So for her, if I'm her looking at this, I'm going, this is so fucking unfair. If they prevent our experts from testifying, what are we supposed to do? And to me, it's just, I don't see the reason to prevent them from testifying. I don't see any reason to exclude their testimony. I know the judge found a discovery violation with them. I find that hard to believe that that's actually justifiable, but judges are given broad leeway to control their courtroom and to enforce their court rules. And if the judge issues that there's issues an order saying there's a discovery violation, that's what's on the record. Did you or did you not plead guilty for peeing in the hot tub? I have never peed in the hot tub. I would always pee out of the hot tub from in the hot tub. So I'd be in that and then you pee out of it. Because it's cold out in the winter. Leave me alone. All right, we've got a couple chats here. If you haven't seen the super tip system, we do have some new voices today. We've got one super tip here from Jay-Z. Heart in your coverage. You're doing great. To guts to make a comeback. The trolls are just douches. Wishing you and your family all the best. Yes, thank you so much. And the trolls are just who they are. Ronnie, or not Ronnie. Just for whatever reason, I can't pull this down off the screen, so I'm going to play another one. Just a reminder that we did get a Ronnie O'Neill voice today, and I love it.
The evidence will show that LawTube is a bunch of silly bullshit.
That voice is perfect. It came out just right. We have, let's see, Mactavius says, that's a huge biatch. How friggin' tall is he? I don't know. Who? The new doctor guy that was just up there? Ellie Fan says, it's like people thinking the attorney general's office works for the people / public. No, they are the state federal / federal attorney. Right. Their client is the state or the county or, depending on the level of attorney that they are or a level of office. My prosecutor is the county attorney. So they represent the county government in all matters. So criminal matters, yes, but also in civil matters involving the county government. Ray says, time to ask the question. With a train wreck the last trial was, and then being on the same track again, how many times can a judge mistrial this and keep the burning, not so merry-go-round spinning? Well, I mean, the judge can mistrial it as many times as there's a mistrial. The question is, the question is always, will the state decide to invest the resources again if they haven't been successful in the past? And, until you get an actual verdict, one way or the other, you're not in double jeopardy territory. So in theory, they could just keep going forever. But, each one of these gets to be more and more burdensome on the state as well. And though the state will be paying out, the state will pay out whatever it's going to pay out. And one particular trial won't affect its budget too much. I mean, there are limited resources. There are other things, and eventually it becomes a political issue. And that's why, having elected county attorneys and district attorneys is, and even, of course, attorneys general of the states, that's why we have elected attorneys, and there is a politician responsible for the decision-making at some point. Somewhere there is a responsibility that can be voted in or out of office. And that's pretty critical to our system, in my opinion. I mean, I don't see a better way to do it. You have to have someone that the people can say, you know what, fuck this. They're not good at it, though. The people are not good at picking their state's attorneys or county attorneys or district attorneys, however you do it. In Minnesota, we do county attorneys. They're not tuned into it, and it's really hard to research what these attorneys do, what they believe. And frankly, I think a lot of people, if you haven't had contact with the criminal justice system, you're more prone to trusting it. You're like, oh no, these guys are fine. They're not fine, in my opinion, my humblest opinion. I think the system needs a lot of work. I don't think the individual people are bad. I mean, individual people are bad or good wherever they are. That's just wherever they are. But with, with jobs like cops and attorneys and stuff like that, the system pushes out a required course of action to have a successful job. And that required course of action makes a person questionable on the respecting of rights. And again, I'm trying to be very careful in how I say that, not because of my own personal woes or whatever. I think they already know how I feel about their positions. It's just about being clear on how. Well, the reason I want to be careful is because, again, it's the job that does it. The system is engineered to produce results that impact liberty. Now, the question is the impact justified or not, right? Sending someone to prison justified? Well, if they did the criminal acts, sure. But the job is engineered to produce convictions. So it does produce convictions. So good lawyering can win a case where they don't have good facts or good law. And to me, that's a problem. I don't know exactly how to fix it. I just kind of hate it. So, I think we're going to get to wrap up for the, oh wait, Billdozer 74 says Rekieta wants the feds goo. No, I don't. Gross. He had nice dimples, but I think under his shirt, he looks like cheese or something. No, it's, I don't know, man. These are weird trials, like the one Bronca's doing as well. I tend to default towards the non-government entity. I tend to default towards the defendant in a criminal case. Not always. Sometimes the defendant is pretty guilty. Like the one who shot that lawyer in Wisconsin, shot him in the head. live stream that trial. Like that guy, I mean, I wasn't really on his side from the start. He kind of looked like a bad guy. But anybody who's up against the state, I'm like very skeptical of the state's position. But when you have like a cop who's the person up against the state, like we had with Kim Potter, I'm like, I mean, I don't think Kim Potter should have gotten a murder charge. But at the same time, I mean, I really didn't want her to accidentally pull out a gun instead of a taser and ice that guy. Like, that's not a good thing. So I'm not really on her side either, you know? But, yeah, so in those cases, it's harder to tell. In these cases, Karen Read looks like someone getting railroaded by the state in general, not just with the murder charge, but it looks like a frame job. So it looks like not only is she catching the murder charge, but they're engineering one, and that sucks. And I can't imagine what she's going through, thinking about the conspiracy against her and the people who she is up against on a practical level outside of court. Like this extends into the community a long way. It automatically will, but it also, it permeates the entire court process, because all of these people are connected to that court process. If they're cops, they've testified in front of this judge before. I mean, they're gonna be. I think one of the witnesses rented Auntie Bev's cabin or something like that. Bev being the judge. I mean, you have these ties in a smallish community, and they're gonna run deep. I wouldn't want to be up against that on any charges, much less a murder charge. So, anyway, we'll be back tomorrow for the next day of trial coverage. Not entirely sure what if I'll have anything in the meanwhile. I need some time personally to get some videos put together to kind of recap what's been going on, give my thoughts on specific things. So I'm going to maybe work on that, maybe do a live stream, something like that when I can, but I don't know if that's going to be today. I'm really trying to rebalance how I was doing YouTube before, because I was spending a little bit more time on it than maybe I should have, and had some other stuff to take care of. I know that sounds weird because you're probably remembering right up to my arrest, in which I was not spending enough time on YouTube at all. I wasn't doing the job that I was supposed to do, but I'm talking about before that fiasco really metastasized into what it was. There were just times where I was just so like into being on stream all the time that I was doing it at the expense of some other stuff. So trying to figure out that balance as I get back into it. I also haven't done this for a year, so it's all new. So thanks for bearing with me, guys. I appreciate it. Occupant 42 says the job of the prosecution is supposed to be to seek the truth, not get a conviction. It's supposed to be. But you know who cares about convictions is voters. And that's hard to remember, because those voters are putting state attorneys in office, and they all think they want the tough on crime candidate, etc. And you don't want like the completely polar opposite that you get in some of these California districts, where people are allowed to just go rob a Walgreens as long as they only steal so much and no one can do anything about it. Like, you don't want that side of it on the converse. So you have to find this happy medium, but people tend to default towards law and order, quote unquote, law and order candidates, and especially on the right. And people need to reevaluate how much trust they have in the government, the government's policing of their activity. I said it before and I made it true. We're all just 1 or 2 bad days away from a felony. It really doesn't take much. For me, it was pretty much like 2 bad days. And that really just sealed kind of some behavior that wasn't thought through. And if it can happen to me, trust me, it can happen to you, because I never thought I'd be there either. But yeah, man, we'll see you guys very soon. I don't know if I'll be doing anything tonight. You can always follow on Locals, rekietalaw.locals.com. You can follow for free. There's an announcement for every show that goes out. You can follow on Twitter. Try and keep announcements going there as well. Or you just watch for links. Everything's accessible. In any case, Tomorrow morning we'll be back. All right, guys. That's all I got. Have a good day. Thanks for watching. Peace. Peace.